ಇಂಟರ್ನೆಟ್ ಸಿಗ್ನಲ್ ಸರಿಗೈತೆ.
ಯಾವ್ದೋ ಕಂಟೆಂಪ್ಟ್ ಐತೆ, ಯಾವ್ದೋ ಸಮನ್ ಬೇರೆ ಮಾಡೋನೆ ಅಸಿಸ್ಟೆಂಟ್ ರಿಜಿಸ್ಟ್ರಾರ್ನ, ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ನ, ಸಾರಿ ಮೊದಲನೇದು. ಆಮೇಲಿಂದ ಎಲ್ಲ WP ಅವೇ.
ಎಲ್ಲ ಆರ್ಡರ್ಸ್ನಾಗೆ ಅವ. ನಮ್ಗಿಂತ ಜಾಸ್ತಿ ಹ್ಮ್
Serial number 37 to 40 minutes.
37,
37 to 40.
37 to 40.
40 minutes. Final hearing matters. I request your lordship to have it on some other day because I'm not too well. I have informed the other side also.
You are from the other side?
Yes, I have informed.
So you ensure that he will not come even if we deny request. All right, ಯಾವತ್ ಮಾಡ್ತೀರಿ?
Anything. Your lordship.
In the second week of January
ಮಾಡ್ಬೋದು.
at the request of.
Milord, one more submission.
ಹಾ,
What has happened, Milord? There are 5 matters. Milord.
ಅಲ್ಲಿ ಮೈಕ್ ಇಟ್ಕೊಳ್ಳಿ. ಮೈಕ್ ಇಟ್ಕೊಳ್ಳಿ.
Your lordship is audible. Yeah. There are 5 matters, Milord. One matter has not been connected. I have already given to the court officer that matter also to be listed along with it.
ಅದು ಕಾಲಲ್ಲಿ ಆಗಿತ್ತು. ಕಾಲಲ್ಲಿ ಆಗಿತ್ತು. ನಂಬರ್ ಕೊಟ್ರಾ?
Quoted.
ಹಾ. ನೀವು ಇದಕ್ಕೆ ಅದರಲ್ಲಿ.
I am for the respondent.
I have informed you.
Yes. 26. ನಾವು ಕಡಿಮೆ ಮ್ಯಾಟ್ರಸ್ ಹಾಕೊಂಡಿರ್ತೇವೆ. ನೀವು ಟೈಮ್ ತಗೊಂಡು ಹೋಗ್ಬಿಟ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ನಾವು? ಬೇಗನೆ ಎದ್ದು ಹೋಗ್ಬೇಕು. 26 ಏನು ಕೋರ್ಟಿಗೆ ಬರ್ಬೇಡ್ರಿ ನೀವು. ನಿಮ್ಮ ಅಬ್ಸೆನ್ಸ್ ನಲ್ಲಿ ಕೇಸ್ ನಡ್ಸಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳಿರೋ ಏನು? 23 ಸತೀಶ
I am here,
ಏನೇ
but initiation of inquiry after 20 years.
26 ಹಾ WP ಯಾವ್ದು ನಂಬರ್ ಹೇಳಿ? ಅಲ್ಲ ಯಾವ್ದು ನಂಬರ್? 8708. You want time? You are for? All right. After vacation at the request of. Yes. Entry order idea? Entry order to continue. Entry order, if any, shall continue.
Lord, serial number 35, my lord. I appeal for
35.
recognition. Seek for a
Yes.
short accommodation, my lord. There is some inconvenience. today.
2015 matter.
Yes, my lord. Kindly have it on 18th, my lord, if I may suggest.
ಇವತ್ತೇನ್ ತೊಂದ್ರೆ?
Allah, senior counsel is not available, my lord. Please. 18th.
2015 matter. ನಾವು
Go ahead, ma'am.
ಬಂದೇವಿದ್ನ.
On the last occasion, the ASG has undertook to.
18 ನೋಡ್ರಿ ಏನ್ ಹೆಂಗಿದೆ? 18 ನಾವು ಪೋಸ್ಟ್ ಮಾಡ್ಕೋಬೋದಾ? ಜನರಲ್ ಹಾಲಿಡೇ.
15, my lord.
Then you have to seek orders from the honorable chief justice for our
My
sitting.
apologies, my lord.
Eh?
My apologies. 15th, if I may suggest.
15.
Yes.
ಹಾಕೋಬೋದಾ? ಫ್ರೈಡೆ ಬೇರೆ ಬೆಂಚ್ ಇತ್ತು. that's working it. ಹಾಕೋಬೋದು. No,
Or
20th
19th,
ಹಾಕೋಬೋದು. Huh?
19th, my lord.
19th.
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 Much obliged.
Yes. ಕೂತ್ಕೊಂಡು. Yes.
Fresh matters. for
In professor.
preliminary. Two fresh matters for preliminary next week for date court.
ಅರ್ಜೆನ್ಸಿ ಇದೆಯೇನು?
Agency's notice of something promotion is there, please.
ತೊಗೊಳ್ಳಿ, week after next ಹಾಕೋಣ.
Date may be changed.
Date ಕೊಡೋದು difficulty. Promotion matters ಅಲ್ಲಿ ಎಲ್ಲಿ?
sorry,
We
I'm
never
sorry,
treat as a.
I'm sorry.
All right. No issue. Yes. Balakrishna Shastri. 2013.
Notice has been issued, your lordship. So
2013
ಅದೇ ಡಿಪಾಸಿಟ್ ಅಮೌಂಟ್ ಮಾಡಿ ಗ್ರಾಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ತಾವು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ರಿ.
Comply ಮಾಡ್ತೀವಿ ಅಂತಿದ್ದಾರೆ ಸರ್ ಈಗ. ಅವ್ರು ನೋಟಿಸ್ ಇನ್ನು ಕೊಟ್ಟಿಲ್ಲ. Anyway, we will comply, we will pay it. No.
ಡಿಪಾಸಿಟ್
ಹಾ.
1064 rupees.
ಎಷ್ಟರ ಇಲ್ಲಿ ಹಿಸ್ಟರಿ 2013 ಇಂದ ಇಟ್ಟಿದ್ದೆ. ಜನ ನೋಡಿದ್ರೆ ಏನ್ ಅನ್ಕೋತಾರೆ ನಮ್ಗೆ? ಕಂಟೆಂಪ್ಟ್ ಮ್ಯಾಟರ್. ಏನ್ ಮಾಡಕ್ಕೀಗ? ಶಾಸ್ತ್ರಿ ಅವರೇ ಏನಾಗಿದೆ?
Sir, ನಾವು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀವಿ. ಅವರು ಡೆಪಾಸಿಟ್ 300 times of land revenue they have to milord under cashewnut cultivation rules, milord. In 1958 lease was granted.
ನೀವು you are right to deposit that money.
We have offered several times from the year 1988.
ಮಾಡ್ತಾರೆ.
From 1988 they go on filing.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಬೇಕಾ?
ಬೇಡ ಅಂತಲ್ಲ, ಬೇಡ.
ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ ನೀವೇನ್ ಮಾಡ್ತೀರಿ?
1511 we have fixed the date.
1511 ಅದಕ್ಕೆ
ಡಿಪಾಸಿಟ್ ಮಾಡ್ಲಿಕ್ಕೆ within that period ಮಾಡಿ.
ಹಾ, ಅವ್ರು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತಾರೆ, ಮುಂದೆ ನೀವೇನ್ ಮಾಡ್ತೀರಿ? ಆಲ್ರೈಟ್, ಅವ್ರು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತಾರೆ, ಮುಂದೆ ನೀವೇನ್ ಮಾಡ್ತೀರಿ?
You have to grant it.
ಏನ್
As
ಗ್ರಾಂಟ್?
per the terms of the orders. Subject to result of SLP ಅಂತ ತಾವು ಹೇಳಿದ್ರಿ last time.
ಅಡಿಯಿಲ್ಲ.
Accordingly, we have given notice.
learned AGA on instructions of his clients submits that 11th, 18th, 11th, 15/11. That notice has been sent to the complainant to be present before in the office concerned on 15/11/2024 and with relevant documents. And on that day, if the amount due is remitted by the complainant, the grant would be made and further complies with the
No other complaints.
ಏನಿಲ್ಲ. Order ತೋರ್ಸಿ. Order
ಏನು ರೂಲ್ಸ್ ಇಲ್ಲ. ಅವ್ರು ಕಲೆಕ್ಟ್ ಮಾಡಿ ನಮ್ಗೆ ಪಟ್ಟ ಇಶ್ಯೂ ಮಾಡೋದು ಅಷ್ಟೇ ಬಾಕಿ ಇತ್ತು. That they have been annexure A, my lord, is the order. Page, my lord, 27.
27.
Subject to the documents only.
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ. ನಮಗೆ ಲೀಸ್ ಗ್ರಾಂಟ್ on expiry of 30 years, they have to confirm
Collect
it.
the price and do that needful ಅಷ್ಟೇ ಇದೆ. Recall that order. Recall that order. Learned one ನಿಮಿಷ. This complaint alleges violation of the writ issued by a learned single judge of this court, wide order dated 23/7/2012 in petitioner's WP number 23692 of 2012 LR. First off, the operative portion of the order at para 13 reads as under. Nodama, page 21 nalli para 13 hakbidi. Next paragraph. After service of notice, the respondents having entered appearance through the learned AGA submit that if the petitioner makes payment in terms of the above order on 15/11/2024, the grant certificate shall be issued, issued. Within what period? Within 4 weeks.
But they have to produce documents there.
What? There is a direction. ಅದೆಲ್ಲ ಏನಿಲ್ಲ. You can't travel.
ಎಕ್ಸ್ಪೆಂಡ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ಅಲ್ಲಿ ಬ್ರೀಚ್ ಆಫ್ ಇದ್ದಿದ್ರೆ ಅವ್ರು ಗ್ರಾಂಟ್ ಮಾಡಿ ಅಲ್ಲ. ನಾವು ಅದನ್ನ ಒಪ್ಕೊಳ್ತೀವಿ. So far as money is aspect is concerned, we are not disputing.
ಅಲ್ರಿ ಬೇರೆ ಏನಿದೆ ಅವರ?
Collect it and have to grant.
ಅಷ್ಟೇ.
There is any breach, your lordship, in respect of lease agreement, your lordship.
Even otherwise, the order is as clear as Gangetic waters and admits no interpretation. First stop. Next paragraph. The vehement submission of learned AGA that the complainant has to comply with other conditions
Documents.
or produce any documents in support of his claim does not fit into even penumbra of the order in question, and therefore is rejected. First stop. Next paragraph. If compliance rejected. First stop. If compliance as indicated above is not reported, the first respondent deputy commissioner runs the risk of arrest and detention in addition to other penal action.
Subject to result of SLP ಅಂತ ಹೇಳಿ.
Last year.
ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಸರ್. ನನ್ನ ಹತ್ರ ಆರ್ಡರ್ ಕಾಪಿ ಇದೆ.
50488 of 24.
It is made clear that compliance shall be subject to result of SLP if any pending. Okay.
Please.
ಅದ್ ನೋಡ್ರಿ ಅದಾಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾವು ಅರೆಸ್ಟ್ ಅಂಡ್ ಡಿಟೆನ್ಷನ್ ಆರ್ಡರ್ ಮಾಡ್ತೇವೆ.
ಇಲ್ಲ ಕೊಡ್ತಾರೆ.
They cannot play 2013 matter ಎಷ್ಟು ವರ್ಷದಿಂದ ಇದು ಎಲ್ಲ ಯು ಆರ್ ಹರಾಸಿಂಗ್ ದ ಸಿಟಿಜನ್ಸ್. ಎಸ್. Disposed of. Proceedings disposed of.
Disposed of.
Disposed of. With liberty to seek revival if compliance is not done. Okay. Next.
Taken out paper publication. Respond number 8, my lord, I have taken out paper publication.
Service on or it's held sufficient.
So Francis Prabhakar.
Service of notice on respondent number 8 is held sufficient in as much as despite calling his name in the open court loudly, comma, there is no response from his side. All right, paper books haki ಆಗಿದೆಯಾ? ಆಗಿದೆ. ಯಾವಾಗ? ಅಲ್ಲಿ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೋಬೇಕು.
You have given the copies, my lord. Already filed.
ಅಲ್ಲ, ನಮ್ಮಲ್ಲಿ ರೂಲ್ಸ್ ಅಮೆಂಡ್ ಆಗಿಲ್ಲ ಇನ್ನು. ಅಲ್ಲಿ ಹೋಗಿ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೋಬೇಕು. ಇಲ್ಲಿ ಡ್ರಾಫ್ಟ್ ರೂಲ್ಸ್ ನಲ್ಲಿ ನಾವು ಆ ರೀತಿ ಮಾಡೇವಿ, ಸರ್ವ್ ಮಾಡಬೇಕು ಅಂತ. They have not yet become rules. ಮತ್ತೇನಿದೆ ತಗೊಂಡ್ ಮಾಡ್ಕೋದು. We have come after reading the papers.
I'll obtain the copies, my lord, then we can vote it for.
Call this matter next week at the request of counsel appearing for the respondents, finally. Yes.
Petition my lord. There is rectification of office objection.
ಏನಿದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್?
Recall.
ಏನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್?
Copy to the government advocate has to be.
ಇದೇನ್ ಕಾಪಿ ನಿಮ್ಮಲ್ಲಿ?
Copy ಇದೆ.
ಕೊಡಿ. Peremptory order. Recall ಮಾಡೋಣ brother. Let him give 1 or 2 books to the library. ಅದು ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡ್ಬೇಕಾಗತ್ತನು? ಕಂಪ್ಲೈನ್ಸ್ ಆಗ್ಬಿಡ್ತದೆ. The registrar P&H wide order dated 13/4/2023 has said as under. First, next paragraph. Now an application is filed to recall the peremptory order. Peremptory order. First off, it is supported by affidavit. Yardo?
My affidavit.
And you are an advocate of counsel himself. First, there is no reason to doubt the version in the application or in the affidavit. First, next one. In the above circumstances, the subject application having been favored, the peremptory dismissal order dated 13/4/2023 is recalled, and as a consequence, petition is restored to the board. Yenidu matter.
Is it
Ready?
next week, Monday, my lord. Case of the dismissal from compulsory adjournment, my lord. Yes. Yeah.
All right. In the meanwhile, I call this matter after 2 weeks, and in the meanwhile, office objections to be addressed. Muralidhar
Number
permitted
4,
to
my lord, I
retire.
pray for a short accommodation, my lord, in this case. My lord.
Brother, you need accommodation?
Please, my lord. We'll file our objections, my lord, in this case, my lord.
Madam,
For a week's time.
Only-
hearing application allowed. Call this matter.
Only one submission, my lord.
ಏನು?
Lord, the matter pertaining to seniority, right from, my lord, our appointment, that is, my lord, 1994 to till, my lord, 2021, throughout the seniority list, my lord, we have been placed above. In the year 2021, my lord, provisional list is published, we have been shown above. Without any opportunity, my lord, impugned seniority list is published, we have been pushed down. Now, my lord, DPC,
ಅವ್ರೇನೋ time ಬೇಕು ಅಂತ.
my lord,
One
DPC
hour,
is
yeah.
held, will be held tomorrow. Not, yes, my lord. Right, 27 years, my lord, we have been,
All right. TPC the recommendation ಆಯ್ತು ಅಂದ್ರೆ ಎಷ್ಟು ದಿವಸ ಬೇಕಾಗ್ತದೆ effect ಕೊಡ್ಲಿಕ್ಕೆ?
But within, my lord, 2-3 days, my lord, they will be promoted.
Now we have been
DPC
posted above them, my lord.
Huh?
Now we have been posted above
You have
him,
been placed
placed
above
above him.
without giving an opportunity to them, even in the draft list, they were shown
Yes.
seniors. Covered by Kathe Gaudana,
Kategorically.
Kathe Gauda.
Kathe Gowda and my lord, PK Roy.
Ah.
Without opportunity, my lord, we have been.
All right, we will give you time.
Please.
But don't finalize DPC proceedings. Don't finalize DPC proceedings. Call this matter in the 3rd week of January 2025 at the request of counsel appearing for the contesting respondent. First up, in the meanwhile, if DPC is held, its outcome shall not be given effect to without the leave of court.
Yes.
Okay. This order we have made after noticing that all through petitioners figured above the contesting respondents, and for the first time, the final seniority list shows them below, although it was preceded by the draft seniority list in which petitioners figured above. Okay. Yes. Steps. Steps to this is response 3.
I have already taken a process.
DC response 3 service matter nalli steps. What is this matter?
Your lordship,
This matter nalli DC jarigi. Huh? Complainant is dead. Complainant is not a necessary party. He is only a proper party, but now he is dead. We cannot bring his LRs in. Where is the estate to be represented? It is reported that our respondent, the third respondent who happened to be the complainant before the Lokayukta is dead and gone. First up, registry seeks steps to be taken in respect of deceased. First up, this is ununderstandable in as much as there is no estate left by the complainant involved in the subject petition. First up, therefore, there is no need to take steps. First up, a note to be made beside the cost title to this effect. Cost steps ready na?
yes, sir.
Are you ready?
Yes, sir. Kindly pass over this matter since because I have passed. Yes, sir, your lordship, I would like to submit my contention, your lordship. Your lordship, my grievance is annexure F, your lordship. Annexure F and X, your lordship.
F and
X, your lordship. Annexure F dated 4/7/2018.
page
That-
number helve.
Your lordship, page number 52, your.
52.
Yes, your lordship. In a complaint raised by the complainant. Dated 4/7/2018, your lordship.
ಅಕ್ರಮ ಆಸ್ತಿ ಗಳಿಸಿರುವ ಬಗ್ಗೆ ದೂರು.
Yes, your lordship. The content of the complaint is like this, your lordship. He has raised an allegation against the petitioner stating that the petitioner is conducting a real estate business in survey number 64/12. So that is the allegation raised by the complainant, your lordship. So the complainant filed after lapse of 7 years, your lordship, which is against to provision 9 of Karnataka Lokayukta Act, your lordship.
It's not a case of bribery or accumulation of wealth by discharging official functions favorably. Eh?
Converted the land and used it for agriculture purpose. He purchased the property, land, you are
Correct.
that wants to do the agriculture. Since his mother was also agriculture, he wants to do the agriculture operation of the reason for buying that land. Later it was converted.
Correct.
After conversion, without seeking the permission of town council authority, started selling the land.
How that is a service matter? Huh? How that is a service elements of service disputes? It may be wrong, it may be illegal, maybe imprisoned also. But where is the element of the service dispute? How it is associated with his discharge of official function? What is that there, sir? That may be wrong, but how you are going to associate with the discharge of official duty? Huh? ಅದು ಹಂಗಾಗಿ ಇಲ್ಲಿ ಬಂದಾರು. You need not take everything with the Lokayukta will say as gospel truth. That's the reason they are here. Where is how are you going to associate the alleged activity with the discharge of public function? He has amassed wealth by doing some business. He did business without leave of the employer, you can take action. But that is how.
Expected to comply with all the, and he cannot just do, ultimately it's the public who are going to pay that. He purchased the property with your permission only. He is a government servant.
He bought the property.
He bought the property. But for and pay. Agricultural land. Agricultural land, yes. There also there is, the intent was different. Later he has converted, within 1 year he has converted the land. Agricultural land into non-agricultural. You should have, you only permitted it. You only permitted it. You should have refused conversion.
Suppose if he conducts the marriage ceremony of his daughter in an illegally constructed chowtry, can you take action as under the service law? They have permitted. Page 22.
You permitted him to purchase,
This is
you
nothing but
permitted him to convert, and then somebody says that.
amassed wealth from his selling the land.
Permit then.
We are allowing this matter. Anything. All this matter. Next.
Your Lordship, may I seek a date, Your Lordship?
Huh?
May I seek a date?
22. ಅವರಲ್ಲಿ ಮೊನ್ನೆಯಿಂದ ನೋಡ್ತಾ ಇದ್ದೀವಿ ನಾವು ಬರ್ತಾನೆ ಇಲ್ಲ ಎಲ್ಲ ಕೇಸ್ ನಾವು ಡಿಕ್ಟೇಷನ್ ಲಾಸ್ಟಿಗೆ ಆಪರೇಟಿವ್ ಪರ್ಸನ್ ಇದ್ದಾಗ ವಿ ಅಪೋಸ್ ಅಂತಾರೆ ಇಲ್ಲಿ ಬಂದು ಹೇಳಿ ಅವರಿಗೆ ನೋಟೆಡ್ ದಿ ಅಬ್ಸೆನ್ಸ್ ಆಫ್ ಕೌನ್ಸಿಲ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ದಿ ಲೋಕಾಯುಕ್ತ ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ week after next to enable the said council to come and argue if at all he wants to. Yes.
Much.
Lord, in this matter appears, Lord, sorry for I am some inconvenience, my Lord. I could not able to come physically before your Lordship.
All right, we need not come physically at all. We will be afraid of you if you come here. We'll be safe in your
No, my lords, that is not the thing. My lord, the except translation copy. Other office objections are very trivial, my lord.
Objections.
Objections to translated copy has to be furnished majorly. ಆಮೇಲೆ ಜೂರಿಸ್ಟಿಕ್ಷನ್ ಬರೋದಿಲ್ಲ ಪ್ಯಾರಾಗ್ರಾಫು ಆಮೇಲೆ ಮಧ್ಯ ಕನ್ನಡದೊಳಗಿದೆ ಅದನ್ನ ಟೈಪ್ ಮಾಡಿ ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡಿ ಟೈಪ್ ಮಾಡಿ ಹಾಕ್ಬೇಕು ಅಂತಿದೆ.
All right. Office objections.
Your lordship.
You have objection for overruling the office objection? Over being insignificant or overruled.
My lord, paragraph 14 may be kindly look into page number 32. That is only the grievance which I can apprise your lordship under the jurisdiction of Article 227. 32, my lords. Paragraph number 14 of the internal page 22 of the KT order. Lordship, paragraph 14, 5th line from the bottom. The tribunal itself has found it is an excessive punishment as levied on me, and penalty has been imposed of 4 years withholding increment of cumulative effect and postponement of the promotion. That postponement of the promotion has been granted by the tribunal. Lord, the penalty in so far as the the withholding of the increment with cumulative effect for a period of 4 years has been confirmed. Lordship, at your hands, when the tribunal itself has found it is an excessive in nature, in proportionate to the gravity of the charges proved.
ಯಾರು appear ಆಗ್ತಾರೆ? Notice ಆಗಿಲ್ಲ ಅದು. No, ಬರ್ಕಳಿ. Issue notice. Then the AG is requested to accept notice for the respondent number 1. ಎರಡನೇದರ ಯಾರು? ಲೋಕಾಯುಕ್ತ ಯಾರು ಲಾಯರ್ ಒಬ್ರು ಯಾರೋ ಬಂದವರು ರೆಗ್ಯುಲರ್ ಬರೋರ ಹೆಸರು ಹೇಳಿ. ಶ್ರೀ ವೆಂಕಟೇಶ್ ಅರಬಟ್ಟಿ, learned panel counsel is requested to accept notice for second respondent. Issue emergent notice to third. All right, ನೋಡೋಣ.
ಆಗ್ಬೋದು much obligement.
Yes. Yes, Vinayaka.
For the petitioners, my lords,
Yes.
process fee katila anta bandide in the first matter
Process fee.
is to be made good, my lords. I'll do that in the
ಯಾರು other side?
steps ತಗೋಬೇಕು ಅಂತ ಇದೆ. I'll
Steps to be taken in respect of respondent number 20. You appear for Shri so and so appears for respondent number 24. ಬರ್ಕೊಡಿ. ಬಿಟ್ರೆ ಆನ್ ಮಾಡಿಕೊಳ್ಳಿ, ಮೈಕ್ ಆನ್ ಮಾಡಿಕೊಳ್ಳಿ.
My lord, I have filed an application to come on record, my lord, as additional respondents.
You are interested in the proceeding?
Yes, my lord.
How?
My lord, we belong to 2012 batch. My lord, the petitioners, my lord, they belong to 2015 batch. My lord, now in the event, my lord, this writ petition is allowed. My lord,
my lords, the purpose of the act is challenged before the KAT, my lords. KAT quashes the
Okay.
certain provisions.
Time. Go. Sit down. Yes.
Certain provisions are quashed and it is held ultra vires. I was not made party there. I filed a review and thereafter writ petition is filed before my lords. The history of this litigation
That's
dates
all right.
back.
How you are agree, you will be.
I will.
Ah.
I will get
Correct.
1990.
Application supported by an affidavit seeks impleading. Full stop. If that application is allowed, no prejudice will be caused to the petitioner's side. And on the other hand, it would facilitate due adjudication of the list from all angles. Full stop. The only prejudice the petitioner would suffer would be to tolerate the longer cost title than otherwise. First off, the applicant answers the description of proper party, if not a necessary party, in the light of apex court decision in Rajia Begum. First off, in view of the above, application is allowed and petitioner is directed to implead the applicant, array the applicant as respondent number
71 to 76.
71 to
77.
71 to 77.
71 to 77.
My lords, my objection may be
Okay.
recorded.
We have made this order after noting the objections orally submitted by counsel for petition. Okay, next. Then ಅವ್ರು ಯಾರು?
My lords, they were appointed freshly in the year 2015. We were serving right from 2002. They were appointed in 2012. Very well. Proper party.
Consequence ಆಗೋದಿಲ್ಲ, ಬರ್ಕೊಂಡು.
Very well.
The subject matter of the other application is almost substantially similar to the one in the above application which we have allowed today. First off, like cases need to be treated alike in the normative procedure. First, next one. In view of the above, this application is also allowed and petitioner is directed to array the applicants as respondent numbers
78 to 81.
78 to 81. 81. All right. Call after
Much of.
for entry matter then.
My lords,
Interim-
it's absolute.
Interim order ಇದೆ.
Ide, absolutely. Okay. Next.
Much of.
Rule number 8, I'm appearing for the petitioner, my lord.
Yes.
Office has raised certain objection that certain pages legible copy is not there, my lord. These are matters pertaining to interstate seniority in the Southwestern Railways, and these are all running ranking list, please, my lord. So certain pages were all uploaded online itself in by the Southwestern Railway.
Which pages are not legible according to office?
My lord, they have told page number 30, 31. These are all
You
running.
keep typed copies of pages when you argue the matter on merits. We'll dispense with the requirement now.
I will, my lord. Actually, it will not come in the way of adjudication because I'm not entirely relying on these particular pages, but they are all just running pages, please, my lord. Page number 30, page number 31.
All right, all right.
And these are the only ones available online, please, my lord.
Okay. The office objection as to the illegibility of the subject documents is overruled, since counsel for the petitioner submits that he would not rely upon the said pages at all. First, however, it is open to the other side to bank upon those copies if they so want. Yes, what is this matter about?
My lord, matters pertaining to interstate seniority, the petitioner was put in the second batch, please, my lord, after training. And
Notice agide, my lord. The reason is, my lord, interstate seniority, the affected parties are not made parties.
Although, if it goes to basic principle, they need not be. If it is above the basic principle, then need to be. That's how Justice Ramajoy says.
Please. Lord, it affects their seniority also, my lord. Therefore, my lord, on
That may affect.
that on 29/8/2024, when the matter was listed, my lord, there's an order, my lord, to implead them as a necessary
I
parties.
have
my lord.
filed amended memo of parties, please, as
Because they were
directed
not
by the
made
court.
parties before the tribunal.
Application ಇದೆ. ಈ application allow ಮಾಡೋಣ ಹಾಗಾದ್ರೆ. Impleadment ಗೆ.
Please, my lord.
I have already filed amended memo of parties and served the copies
Application
to
allow
all the
No, my lord.
respondents also, please.
One of the grounds on which relief was denied to the petitioner was that some other employees who would be affected were not made parties. First, to cure that defect, petitioner has moved an application seeking leave of the court to implead those employees. Notice ಆಗಿಲ್ಲ ಅದರಲ್ಲಿ.
My lord, already ಆಗಿದೆ Swami. On last date, Honorable Court had
Notice agide.
directed me to file amended memo of parties and serve it on the respondents. I have served it on respond number 3 to 12. I've already served copies through Ministry of Railways, please, my lord.
It is served, my lord. It is served, my lord. I'll file the acknowledgement to that effect, my lord. It was given to the railways, my lord. The railways has served it, my lord.
Where is the application?
My lord, the court had, without the application, the court only had directed me
don't
to
waste time.
file amended memo.
We have already, Albert.
Please,
A
my lord.
coordinate bench of this court while order dated, recall that order. A coordinate bench of this court while order dated 29/8/2024 had said as under. First off, in terms of the said order, petitioner needs to make an application for impleadment. First off, ordinarily, oral request for making impleading the leftover parties is not entertained, since it will have a lot of consequences. First off, call this matter after 2 weeks. In the meanwhile, first, it is open to the petitioner to file impleading application if he so chooses.
Great.
My lord, already I have filed, please, my lord. Based on the
The
court's direction,
Amended
memo,
last
amended memo,
memo is hereby rejected. Next.
rejected.
Yes, what should happen? Yes, next.
Lord, I am appearing for the response 1 and 2. Respondents 4 to 9 may not be.
4 to 6
Oh, yes, my lord. 4
Ah.
to 6. 4 to 6.
not necessary parties.
Because in the trial court,
No, we're asking you.
they are not necessary party for the reason in the trial court, those served, they are unrepresented.
They are?
Though they were served, they were
Least ex parte.
unrepresented before the KAT. Unrepresented.
Unrepresented ಇದ್ರು ಆಗಿಲ್ಲ. Ex parte ಇದ್ರೆ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ. They will be unrepresented, believing that the order will be passed rightly without affecting their interest. But once you want to upset it, they are a necessary party. That's how Rajia Begum treats the matter, na? 58 Supreme Court. ಅವ್ರನ್ನ ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಅವ್ರಿಗೆ
Notice.
ಸ್ಟೆಪ್ಸ್ ತಗೋಬೇಕು, fresh steps
Fresh step.
in respect of unserved respondents within 10 days, failing which petition stands rejected. Failing which interim order stands discontinued. ಇವಾಗ immediately ಮಾಡ್ತಾರೆ. ತಡೆ. Memo for retirement is accepted. Yes. Next.
My lords,
Yes,
in this,
Abhishek, ಏನಿದು?
my lords, here office objection is to issue notice to R2 to R4 in serial number 10, my lords.
Ah.
My lords, in serial number 10.1, similar respondents,
Are
counsel
represented.
represented by
Preparing for respondent 2 to 4 in this second matter, my lords.
Yes.
We informed them regarding this matter, my lords, last night. We have no instructions, my lords.
We are requesting you now.
ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ ಅವರು ಈ ಮ್ಯಾಟರ್ ಮಾತ್ರ ನಮಗ್ ಕೊಟ್ಟಿದ್ದು ಬಿಫೋರ್ ಈವನ್ KAT.
All right.
identical
All
matters,
right.
my
all
lords.
right. Entry order ಇದೇನಲ್ಲಿ?
ಇಲ್ಲ, dismiss ಆಗಿದೆ.
We'll issue entry order now. Then they will know. ಕೊಡಿ.
ಅಲ್ಲ, I will request, I will tell them, my lords. I will
Why
suggest.
are you worried? You are not there.
No, what had happened is, my
Don't
lords,
worry. We'll issue entry order in that so that they will come running here. ಬರ್ಕಡಿ.
ಇಲ್ಲ, I will, in fact, I'll tell them, my lords, I'll accept notice.
Why do you tell them? You are not briefed to tell them. You are briefed to argue that other matter. Only in this matter, we are issuing entry order. ಬರ್ಕಡಿ.
My lords, at least let it be passed over, my lords. I'll seek
But that-
instructions.
You said you will not appear for the same parties who are in the companion matter. You are entitled to say that. But we are entitled to see whether interim order should be granted to them because there is no objection from the other side. Otherwise, fairly, you should say, I take notice for them. You can't do that way. Otherwise, no person will come, nobody will honor our orders. They are represented, you are appearing for them. In that matter, they do not take the notice. What is this?
My lords, notice was issued in 10.1 after hearing.
ಏನ್ ಮಾಡ್ತೀರಿ?
I'll accept notice.
ಹಾ, ಬರ್ಕಳಿ. Learned counsel Shri Rayappa Y Hadagali on our request accepts notice for respondent numbers 2 to 4. 2 to 4.
My lords, this matter may be linked with WP 18088, my lords.
ಬರ್ಕೊಡಿ. Call these matters week after next along with WP number. Write down.
18.
ನೋಡಿ ಅವ್ರು ಬರ್ಕೊಟ್ಟಾಗ ಟ್ಯಾಪ್ ಮಾಡಿ ಸೈನ್ ಮಾಡಿ ಕೊಡ್ಬೇಕು.
My lords,
ಸ್ಮಾಲ್ ಆಮೇಲೆ ನಾವು ಇದನ್ನ ಹೇಳಿಲ್ಲ ಅದನ್ನ ಹೇಳಿಲ್ಲ ಹೇಳ್ಬಾರ್ದು.
my lords, I
Ashwin
request
Gupta,
the copy of the writ be.
ಕಾಪಿ ಕೊಡಿ.
Please, my lords.
ಕಾಪಿ ಕೊಡಿ.
My lords, I request for 3, in the other matter, my lords, we had sought for 3 weeks time. It had come up last week.
ಹಂಗಾರೆ ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಅಲಾಂಗ್ ವಿತ್ ದಟ್ ಮ್ಯಾಟರ್ ಮಾಡಿದ್ರೆ
ಯಾಕಂದ್ರೆ objection ಹಾಕ್ಬೇಕು.
ಕಾಲ್ ದೀಸ್ ಮ್ಯಾಟರ್ಸ್ ಅಲಾಂಗ್ ವಿತ್ WP ನಂಬರ್ ಸೈನ್ಸ್
9-1, the second.
ವಿಚ್ ಎವರ್ ಇಟ್ ಇಸ್. ಎಸ್.
Much obliged.
ಎಸ್.
I appear for the petitioner. Registry has raised objection.
ನಾವೆಲ್ಲ ಮಾಡಿದಂತ ಎಲ್ಲ
Registry
Yes, Matter.
objection is, my lord, the Tahsildar is not made party to the petition, my lord. This land involved in this petition is forest land, my lord. Yes,
ತಹಶೀಲ್ದಾರ್ ಬೇಕಿಲ್ವಾ?
Tahsildar is need not to be made party.
Office objection as to non-impediment of, non-arraying of Tahsildar as a respondent is overruled. Can be solved. I left to him how the cast title is the domain of the dominant litis. You can dismiss if he is not made a party, but how can you say he should be made a party and ಹೇಳಲಿಕ್ಕೆ ಬರ್ತದ? ಅದೇ, if it is, I am the master of cast title. I am the dominant litis. I know whom to implead, whom not to implead. If right party is not impleaded, dismiss it. But how can you say that unless he impleads, quest should not be posted? Okay. Ayambadama? The office objection as to non-arraignment of Tahsildar as a respondent is overruled after seeing the Registrar Judicial's order circular dated 14/2/2024. First off, it has been settled since the days of Privy Council that it is the cast title is the domain of dominant litis. First off, if a necessary party is not arrayed, comma, it can be a ground for denial of relief to him. First off. Okay. Yes. Suppose ಅದು necessary party ಅಂತ ಆಮೇಲೆ ಗೊತ್ತಾಯ್ತು ಅಂದ್ರೆ ನಾವು ಆಮೇಲೆ ಇಂಪ್ಲೀಡ್ ಮಾಡಕ್ ಬಿಡಲ್ಲ.
Please.
ಏನಿದೆ ಹಿರೇಮಠದ್?
The respondent number 2 range forest officer has initiated
ಮತ್ತೆ ಫಾರೆಸ್ಟ್ ಅಂತ ಇದೆ ಅದರಲ್ಲಿ annexure page 9 ನೋಡಿ.
Yes, ma'am. That's why it is not a revenue land and the Tahsildar is not necessary party.
That's all right. Merit ಮೇಲೆ ಏನಿದೆ?
My lord, the petitioner is cultivating the land in survey number 149 of Chetnahalli to the extent of 4 acres, 20 guntas. She has filed an application under Rule 11(1)(a) of Scheduled Tribes and the other traditional forest dwellers recognition of forest rights rules 2007. That application is pending. And the Forest Rights Committee has recommended for 4 acres for the regularization of land 4 acres, 20 guntas. The range forest officer's allegation is that I have encroached 13 guntas, 13 acres and 28 guntas of land. After appearing, I filed objections to the objections in the land grabbing court stating that drop the proceedings since I have encroached 4 acres 20 guntas and I have filed a prescribed application under the provisions regarding 4 acres 20 guntas.
ಯಾವ್ದು ಸೆಕ್ಷನ್ ರೂಲ್ ತೋರಿಸಿ. ಇನ್ನು ಉಳಿದಂತ ಲ್ಯಾಂಡಿಗೆ ನೀವು ಸಂಬಂಧ ಇಲ್ಲ.
ನನಗೆ ಸಂಬಂಧ ಇಲ್ಲ.
That is the observation made by the land grabbing. Kindly see my lordship para 13 of the observation.
ಬರ್ಣ ಅದೇನು ರೂಲ್ಸ್ ಕೊಡಿ, ನಾವು ನೋಡಿಲ್ಲ. ಅದೇನು ಫಾರೆಸ್ಟ್ ಡ್ವೆಲ್ಲರ್ಸ್ ಆಕ್ಟ್ ಅಂತ 2000 ಆಕ್ಟ್ ಬಂತಲ್ಲ
ಇದೆ.
ಇನ್ ದ ಲೈಟ್ ಆಫ್ ದಟ್ ಕೊಡಿ ನೋಡಿ. ಅದು ಫಾರೆಸ್ಟ್ ಡ್ವೆಲ್ಲರ್ಸ್ ಇರಬೇಕು. ಟ್ರೆಡಿಷನಲ್ ಫಾರೆಸ್ಟ್ ಡ್ವೆಲ್ಲರ್ಸ್,
traditional forest dwellers recognition of forest rights rules 2007.
ನೀವೇನು ಟ್ರೆಡಿಷನಲ್ ಫಾರೆಸ್ಟ್ ಡ್ವೆಲ್ಲರ್? ಫಾರೆಸ್ಟ್ ಡ್ವೆಲ್ಲರ್ ಆಗಲ್ಲ, ಟ್ರೆಡಿಷನಲ್ ಫಾರೆಸ್ಟ್ ಡ್ವೆಲ್ಲರ್ ಆಗ್ಬೇಕು. ಅಲ್ಲಿ ಹಕ್ಕಿ ಪಿಕ್ಕಿ ಆದಿವಾಸಿ ಇಂಥವರೆಲ್ಲ ಇರ್ತಾರಲ್ಲ ಅವರಿಗಿದೆ ಅದು.
But my application has been recommended by the forest.
They may recommend so many things because you have done something to them. But question is, do you fit into the 4 corners of the state?
That has to be decided, my lord, by the competent.
Even my lordship consider that they have only 4 acre 28 guntas. Total my lordship encroach is 13 acre 28 guntas.
ಅಲ್ಲ ಅದನ್ನ ಬಿಟ್ಟು ಕೊಟ್ಬಿಡ್ತಾನು.
I have no objection. I have no objection.
ಪೇಪರ್ ಬರ್ಕೊಡಿ, ಮೆಮೊ ಬರ್ಕೊಡಿ. ಅಟ್ ಲೀಸ್ಟ್ ಅದು ಲ್ಯಾಂಡ್ ಉಳಿಸಿ ಮುಂದಿನ ಎಕ್ಸಾಮಿನ್ ಮಾಡೋಣ.
Please.
Counsel for the petitioner on instruction of his client submits that his client has no claim whatsoever in respect of
13 acre, 28 guntas.
13 acres, 20
28 guntas, except
28
4 acres,
guntas.
20, except 4 acres, 20 guntas.
Guntas. Except guntas, and that her claim is confined to 4 acres,
20 guntas.
20 guntas only. First off, he also admits and asserts that the subject, the alleged encroached land belongs to the forest department. First off, therefore,
But,
department,
regarding forest land, I cannot say that it is forest land. They have to ascertain it and take action again.
do you have
I am confined.
confined to 4 acre,
20 guntas.
20 guntas? 4 acres, 20 guntas.
ಬಿಟ್ಟು ಅವ್ರು ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ. I have no objection.
ಅದು ಪೆಂಡಿಂಗ್ ಇದೆ.
ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ, ಬಿಕಾಸ್ under that which is that judgment, which one judgment of the apex court in Godavarman treated it. Godavarman Thermal Pad treated one of these aspects, which Rutvik Datta and Bhupendra Yadav in their book they have referred to, the law relating to forests.
That is under Panchayat committee.
Panchayat
Committee.
ಯಾವುದು?
Gram Panchayat committee.
Forest
Our
rights
application
committee
is
and
pending
Panchayat
with
ಅವ್ರು
the
ಮಾಡಿದ್ದಾರೆ.
Gram Panchayat Forest Committee. That committee is formed by that rule, my lord.
Gram Panchayat the forest committee.
Yes.
Village forest committee. ಏನಂತ ಯಾವ ಸ್ಟ್ಯಾಚ್ಯೂಟರಿ ಏನ್ ರೆಕಗ್ನಿಷನ್ ಏನು? ಸೆಕ್ಷನ್
My lord.
ನೋಡಿ, ನಮ್ದೊಂದು ಫಾರೆಸ್ಟ್ ಇದ್ರ ಮೇಲೆ ಒಂದು ಜಜ್ಮೆಂಟ್ ಬರ್ದಿದ್ವಿ ನಾವು, ಕಾಂಪ್ರಿಹೆನ್ಸಿವ್, ಧಾರವಾಡದಲ್ಲಿ ಇದ್ದಾಗ 2-3 years ಬ್ಯಾಕ್. ತೆಗೆದು ಕೊಡಿ. ಅದೇ ಅಂತ ತೇಲಿ ಅಂತ ಅಡ್ವೊಕೇಟ್ ಯಾರು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರು. Take out that judgment. Read that judgment. We have considered all these aspects. Read and come back. All right? Tomorrow. All right. Learned AGA is requested to accept notice for the official response for the respondents. First off, he points out that to the extent of 13 acres, 28 guntas, 28 guntas, there is an encroachment, and that encroached land is the forest land as per the records. First, at the next ಮೊದಲಿಂದ recall ಮಾಡ್ಬೇಕಾ, ಇನ್ ಬರ್ಕೋಬೇಕು. At this stage, learned counsel for the petitioner submits that his client's claim is confined to only 4 acres,
20 guntas.
20 guntas. 20 guntas, in respect of which an application has been moved under ಯಾವ rule? Rule ಯಾವುದು?
Rule 11. Rule 11(1)(a) of scheduled tribes and other traditional forest dwellers.
Under Rule 11 of
Sub-rule 1, clause A.
Rule 11 of the scheduled tribes and other traditional forest dwellers. Rules so and so. The submission is noted. Call this matter Monday. ನೋಡ್ಕೊಂಬನ್ನಿ.
Till then.
ಏನು?
Land grabbing.
Next.
My lord, in the first matter, my lord, I have filed wakalat. My lord, my name is not shown.
Yes, but
My lord, in the first matter, my lord, I have filed wakalat.
ಅದರಲ್ಲಿ ವರುಣ್ ಗೌಡ ಇಲ್ಲನು?
ಅದ್ರಲ್ಲಿ ವರುಣ್ ಗೌಡ ಇಲ್ಲ. ಇದ್ದಾರೆ. He has given NOC, my lord.
NOC ಕೊಟ್ಟಾರ, want to retire ಅಂತ ಹೇಳ್ಯಾರ.
ಹಾಗೆ NOC ಕೊಟ್ಟಿದ್ದಾರೆ.
Learned counsel Mr. Narayan Bhatt submits, he appears for the petitioner in WP 19037 of 2024 along with Varun Gowda,
Yes.
who has notified is no objection.
My lord, that amended cost title, my lord, I'll file it in the registry.
You have filed it now.
My lord, it is with me, my lord. If your lordship permits, I'll file it in the court.
Call after 2
3
weeks.
weeks, my lords.
Huh?
We have to file because we have been impleaded now. Our say matters here.
Call immediately after vacation.
Vacation ಬೇಡ sir.
ಆಗಿಲ್ಲ ಆಗಿಲ್ವಾ?
Notice ಆಗಿದೆ. My lord, they were impleaded, my lord. And I have even filed ವಕಾಲತ್.
ಅಲ್ಲ ನೀವು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡೋದು ನಮ್ಗೆ ಏನಾಗುತ್ತೆ? ನಿಮ್ ಬೇಕಾದ ಫೈಲ್ ಮಾಡ್ತಿದ್ದಿಲ್ಲ.
Government.
ನಿಮ್ ವಕಾಲತ್ ಮೇಲೆ ನಾವು ನಡ್ಸಕ್ ಬರ್ತದೆ. ನೀವು ಅಪಿಯರ್ ಆಗಿದ್ರೆ ಮುಗಿದು ಹೋತಪ್ಪ. Your Shauri appears for whom?
My lord, UGC, my lord. Universities Grants Commission.
R4
Or for in
all the matters.
all the matters. Was impleted on 28/8/24.
How so?
28/8/2024.
Yes.
8 weeks are already over.
Yes.
ಮತ್ತೆ objection ಹಾಕ್ಬೇಕು.
Instructions.
My lord, they are only formal parties to ascertain, my lord, the rule. I had produced the rule. My lord, otherwise, my lord, they have no rule to clarify their rule, which has been produced, my lord, in the.
Shauri seeks 4 weeks time to file statement of objections. Objection. Call after 4 weeks. Next.
My lord, there is some urgency, my lord.
AGA for 1 to 3 ಏನಿದೆ urgency?
Otherly, next batch, my lord, is being considered for promotion. My lord, there is no element of selection.
The promotion, if effected, shall be subject to list pendants. Okay. Ah. Yes, Dan.
Some issue on maintainability has been raised
Ah.
on the writ petition. Lord.
Ah.
Section 17 order of the arbitral tribunal is challenged by way of an appeal before, my lord, the civil court or the commercial court,
Yes.
against which there is no second appeal under the Arbitration Act.
Only first appeal alone.
Only one appeal there,
Before, that is 37.
that is 37, against which, my lord, there is no appeal before this court. Only a writ petition is maintainable. Because
It
the,
is maintainable.
no, writ is maintainable, that is Deep Industries, my lord, Supreme
How
Court.
courts have taken?
Deep Industries Supreme Court has said,
One, and the order under 37 is final.
that order is fine. There is, unless of course one goes under 136 to the Supreme Court.
Of
But-
course, 136 is a different.
That is different, but Deep Industries my lord, has answered this question specifically, Supreme Court.
What do you say, Chidanandaya?
That's correct.
He's-
Under 30A, appeal
He is
is.
all through.
Only
Office
when it
objection is overruled. Since order made under section 37 of Arbitration and Conciliation Act, so and so, is final, and there is no second appeal created under the act. First, this view gains support from the Deep Industries Limited versus Oil and ONGC. 2020, 15 SCC 706 paragraph
17,
17,
16 and 17, 16,
16.
the last line of 16. Statutory mandate also provides for one bite at the cherry, as Nariman says, and interdicts a second appeal from being filed.
So it interdicts second appeal.
So one bite.
There are
at the cherry.
16 and very better. That way. All right. Yes, what is this then?
Yes.
What-
Now, there is a school, my lord, which is being run in the leased premises.
Very better. Officer, Cabinet Senior Advocate, Mr. Dhan, appearing for the petitioner, points out that the office objection is unsustainable in view of deep science judgment. Para 16. First, we agree with this. Office objection overruled. Okay.
Single or division bench? Of course, my lord, there's also one issue, my lord, I'm not very sure. Should it come before a single judge or a division bench?
Because to come before division bench because
The order
the
of the
order is passed by
arbitrator-
the retired judge of this honorable court. It has to come before the division bench
Division bench.
Then
because there is a circular issued by.
Correct, correct. There is
If it is by
even
the
otherwise
district-
also,
Yes.
it stands to reason.
Yes.
Lord,
Ah,
there was a lease arrangement
there was,
between a lease arrangement for running of a school. We are also the manager of the school, my lord, and a trust. And therefore, we are running a school there. there is a dispute with respect to whether there's rents have been paid properly. There's also a statement by us saying some areas have to be cleared in a certain time frame. Then an application comes to be filed by the owner saying, I've terminated the lease, therefore restrain the school from admitting students. And it's a running school, not a new school. There are students and there are students who have been admitted.
That's
Now,
neither. Students,
there are about 1,000 students,
1,000.
1,000 plus students in this school. Now the learned arbitrator, my lord, we point out to the learned arbitrator that in a lease arrangement, you cannot interdict us from carrying out our business so long as we are in the property. The learned arbitrator says, yes, I will not stop you from running your business, but adds 2 other conditions and says you must now intimate the students and the parents about this ongoing litigation and the fact that their admission is going to be subject to this litigation, and also put up a board outside. Now, we are only challenging it on a jurisdictional ground. On a jurisdictional ground, Lord, because as opposed to a court exercising jurisdiction and imposing conditions, an arbitrator, Lord, being a creature of the contract, can only act within the 4 confines of the contract. Cannot go beyond the contract in granting relief, either, my lord, under the contract itself or under Section 17, which, my lord, applies, and similar to Section 9. Section 17 also, but the limitation is you have to act within the confines of the contract.
Correct.
Therefore, whether you could have granted this relief, arbitrator is one with us and saying that I can't grant that relief of stopping admissions to students, but adds these 2 additional conditions, which we challenge before the court. Saying, Lord, that these 2 conditions you couldn't have added, because notwithstanding whatever be the position, an arbitral tribunal or an honorable arbitrator cannot go beyond the scope of the contract or the scope of the dispute to add an additional condition. That's the essential contention raised. Now, there's no answer to it by the honorable court below.
No, power to put those conditions is in the adjudicatory process in the best interest of the litigants. That is not controlled by the terms of the contract.
True, my lord. Now, there's a difference in my respectful submission. The difference I would say, my lord, is that while granting relief, an arbitral tribunal, my lord, has been held for many years now.
Correct.
That you cannot go beyond the confines of the
That is
contract.
all right.
Correct.
That's
Now,
all.
whether it is a final relief or the interim relief, in this case, it is a rejection of the interim relief. The interim relief granted by the other, sought for by the other side,
Is granted,
is refused.
refused, but condition.
But conditions are imposed on me. Therefore, in a way, my
best
lord,
interest of the, how you are aggrieved by that. This stands to reason and justice. The conditions which the arbitral tribunal had imposed is consistent with rules of reason and justice. Because tomorrow they should not come before the court. We are also stakeholders. We were never told about this litigation. Therefore, give us an audience. Set it aside.
that may not be
What?
there.
No, how you are
Because-
aggrieved by this?
Because in
You
an,
tell them. No, you are telling the truth. You are telling the truth. In fact, in Sanskrit, there is a.
Want to hide it?
That's why.
In a way, my lord.
So many truths have to be hidden. It is another thing. The life
No,
game
the
itself.
difficulty is it creates a lot of tension amongst the minds of
Why?
of
You
of-
tell them. See, in fact, therefore, Satyam Bruhat Ritam Ugram. No. Satyam Bruhat Ritam Ugram. It's a bad truth. The effect of truth is always.
There are 2
that
parts.
way
One
only.
is, of course, information, Lord. The other requirement is you obtain a signature from the parent.
That may not.
Please see the order, my lord.
First one, let it.
Yes, I see what you're not saying.
Because
Please.
that you cannot travel
Page
outside
60
the sunset.
Page
You cannot do
66.
that way.
Page 66, my lord. The order
Understand,
says.
understood.
The second part of it is a problem.
Second part, perhaps.
I'll put up a circular, my lord, or a
You
notice.
tell them.
We'll
You
inform
tell them.
that there's a litigation going on.
Yes, litigation is, legal battle is going on. And they said truth. Not a bitter truth. My brother was saying Satyam Bruyat, Priyam Bruyat, Na Bruyat, Satyam Apriyam. Anyway, we will not go to that level now. At least you tell that we are litigating, this property is being litigated upon. That's all. But is, yes.
Right, only, in fact, I should have been aggrieved. I should have filed that petition. When I have been under 37. Milad, the learned arbitrator said, Milad, admissions have already commenced. Therefore, it is not right to interfere with admission because they themselves have admitted 8 crore 43 lakh rent is due. They have
First
not paid.
condition on point.
Yes.
The second one, ನೀವು ಇಬ್ರು ಒಪ್ತೀರಾ ಇದಕ್ಕೆ ಅಥವಾ ನಾವು ಆರ್ಡರ್ನೇ ಮಾಡ್ಬೇಕು?
I'm sorry.
Do you, both of you agree with this proposition of the court?
We will inform the teachers, my lord, that this litigation is going on and that therefore.
That it should be put it in the.
We'll put it on the notice board. We'll put it up on the notice board, my lord, than anything else.
Second condition, my lord, I think it is in the interest of the students, my lord, because
I can't get this.
You have to tell what the interest of, you are telling the parents. Almost most of the students, though they are not doli in tax, but they are all minors. Minors.
that's the reason why that it is directed that it should be intimated to the.
Intimated already.
No,
How
to
you
the
obtain their
parents.
signature?
Well,
Intimation,
such an event,
public
your
notice
lordship
will
may
be
say
submitted.
that, in fact, lad,
No.
that instead of taking the signature, that the petitioner shall intimate the parents, the pendency of the proceeding.
ಅದನ್ನ ಅವರಿಗೆ ಡಿಸ್ಪ್ಲೇ ಮಾಡಿ ಅವ್ರದ್ದು ಏನಾದ್ರು ಒಂದು ರೆಕಾರ್ಡ್ ನಲ್ಲಿ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಸೇರಿಸಿಬಿಟ್ರೆ ಆಯ್ತು.
ಅಲ್ಲ ಅವರು ಸೈನ್ ಮಾಡಲ್ಲ ಅಂದ್ರೆ ಏನು?
ಬೇಡ ಸೈನ್ ಮಾಡೋದು.
ಅವ್ರು ಸೈನ್ ಮಾಡದೇ ಇದ್ರೆ then they can intimate, my lord, to the parents.
Intimation ಅಷ್ಟೇ, ಸೈನ್ ಮಾಡೋದು.
We'll put it up on
Compel the parents. ನೀವು ಇಲ್ಲಿ ಸೈನ್ ಮಾಡ್ರಿ, ಅಲ್ಲಿ ಸೈನ್ ಮಾಡ್ರಿ. ಬಿಟ್ಕೊಂಡು ಇನ್ನೊಂದು
Instead of taking the signature, may I suggest this, my lord, direct the petitioner to intimate the parents the pendency of the proceedings.
That's what.
That will
Agree.
serve both the purposes.
Are you agreeable with that?
Lord,
Appears to be very sensible.
It normally would have been, Lord, but I don't want to create some kind of panic
No,
in
just
in
inform
the
them.
minds of parents who've already admitted their children that something may happen midway. That's the only danger in all of this.
That way, that danger. It is like a physician telling the patient that gangrene is developed. He has to whisper it, maybe in sweet words, that the patient dies not by the statement. Instead of gangrene, you have to tell the patient that the gangrene is developed. That way it is. Tomorrow, suppose if they all of a sudden, now at least they will be prepared. If they go back and go in search of another Gloucester grammar school, you can't do anything.
Of course. No, if we are, I'm sorry.
That you can't prevent them.
I'm not preventing them, but I don't want them to get into some fear
Yeah,
psychosis of what
vigilance.
might happen
What may
immediately.
happen, we can't. Otherwise tomorrow,
You run that risk.
that's why.
You run that risk. It is your headache.
Always. That of course, no, whether this.
A
litigation is
small
just-
section may go.
You have to inform the other stakeholders who may come to the court saying that, no, tomorrow the school is closed.
We have held that in one matter.
Future of the students.
No, same happened. In one matter where Madam Lakshmi Iyengar argued, perhaps last year, same thing happened. The DRT had made an order and all children were sought to be removed. Then we made some order saying that children should not be this one. Madam is here, Lakshmi is here.
Yes.
Yes. Therefore, that's our consistent view.
So whatever your lordship thinks is fair, no, but to get their signatures and all maybe.
ಅದು ಬೇಡ.
No.
ಅದು ಬೇಡ.
We'll put it up on the notice board.
With, my lord, intimation to each of
ಅವ್ರಿಗೆ
the parents.
ಇಂಟಿಮೇಷನ್ ರೈಟಿನ ಕಳಿಸ್ಬಿಡಿ, ಒಂದ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಲ್ಲಿ ಕಳಿಸ್ಬಿಡಿ.
Yes.
ಪೇರೆಂಟ್ಸ್ಗೆ ನೀವೇನ್ ಕೊಡ್ತೀರಪ್ಪ ರೆಕಾರ್ಡ್ಸ್, ಅದ್ರಲ್ಲಿ ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಹೇಳಿ. ನಾವು ನೋಟಿಸ್ ಬೋರ್ಡ್ನಾಗ ಅವ್ರು ನೋಟಿಸ್ ಬೋರ್ಡ್ ಹಾಕಿರ್ಲಿಲ್ಲ ಅಥವಾ ನಮಗೆ ಆ ಲ್ಯಾಂಗ್ವೇಜ್ ಓದ್ಲಿ, ಇದೆಲ್ಲ ಬೇಡ ನಮಗೆ, ಅವ್ರಿಗೊಂದು ಕಳಿಸ್ಬಿಡಿ.
By
ಹಿಂಗೂ
post.
we have been fighting a legal battle, but we are very hopeful of the victory. Victory.
Make it sound positive.
Although it's very difficult to say anything that would happen in Dalal Street and courts to predict that. Yes.
My lord, only
Say that.
second condition can be modified to this extent, my lord, saying that the petitioner shall inform the parents the pendency of the proceeding before the arbitrator. If that will take care of both the
There's only
interests.
one request. On the first order, my lord, if you.
ಅದನ್ನ ಪೂರ ತೆಗೆದುಬಿಡೋಣ, ಇಷ್ಟೇ ಇಟ್ಬೋಣ.
My lord, let the first order.
Both,
be-
First order.
just hear us.
Please,
We are giving one pattern.
please. my lord.
Having heard learned senior advocate and senior advocate so and so appearing for the parties, and having perused the petition papers, we suggested to the parties that keeping both the conditions that are put in challenge apart, it would suffice if the petitioner informs to the parents of the children, the students, about the pendency of the arbitral proceeding.
We'll do it.
All right? Perfect.
Let- may I just.
Both the sides have.
That's only that circular, my lord, if it is put in the notice board, my lord, that. may
No,
not be
intimate
useful.
ಮಾಡ್ತೀವಿ.
No, they will inform.
My
them.
lord,
It's
intimate
your
ಮಾಡಿ,
condition.
apart from that, one
But
circular
you
in the
cannot
notice.
Once it is sent to them, ಇದು ಬೇಡ ಆ ಮಾಡಲಿಟಿ ಮೇಲೆ ಬೇಡ ಬರ್ಬೇಕು. This petition filed under 227 seeks to call in question this petition essentially filed under 227 of the Constitution of India as the following prayer column 31, 32. Learned senior advocate Shri Dan Chinnappa appears for the petitioner. First, ನೀವು ಕೇವೇಟ್ರಾ?
For the respondents.
Learned senior advocate Mr. Chidanandaya represents the respondents who are on caveat. First, 1 and 2 ಅಷ್ಟೇನಾ?
1 and 2.
Notice to third respondent is dispensed with. Having heard the learned senior advocates appearing for the parties and having perused the petition papers, we suggested that both the impugned conditions be set at naught, will be set at naught, and in their lieu, the condition in their lieu, that in their lieu, the petitioner shall inform in print to the parents of the school children concerned about the pendency of subject arbitral proceedings, so that the parents and their wards, arguably being the stakeholders, may not take the outcome of the said proceedings as a bolt from blue. First, both the sides agreed with this. First, in terms of the agreement, this petition is disposed of. Courts having been witnessed. Okay.
Dispose of with the direction, Millet.
Huh?
Dispose of with the direction to the petitioner
No,
to intimate within the time stipulated, some 15 days. Instead of setting aside, Millet, modify this.
This agreement will be given effect to by the petitioner by taking appropriate proceedings, by making appropriate provision within 4 weeks from this day.
Yes.
And file compliance in the registrar with the Registrar General of this.
Please, will do that. May I only request that instead of setting aside, modifying that condition.
No, ಆ condition ಸರಿನೇ ಇಲ್ಲ. Because if he goes saying that the contract should govern the rights of the parties in arbitration, then many other reflections will come. That's the reason. Yes. Okay. Yes.
That's 14. Day before yesterday, my lords, this matter had come up. My lords have referred to that sub-registrar counseling matter.
By and large.
By and large. But
strict apply ಆಗಲ್ಲ.
ಇಲ್ಲ.
By and large.
By and large. But here, my lord, situation is different. My lords, we have 1,011 fresh recruits that have come under Rule 9 of the rules itself. Here, there are rules which are in force. Under Rule 9, to accommodate them, I have to post them in Zone C, Zone E. Zone E is the rural area, my lords. Then Zone A is BBMP area. Zone B is corporations and other city municipal councils.
ಇವ್ರು ಬಂದಿದ್ದೀಗ no relief is granted by the tribunal ಅಂತ.
Tribunal only interim order has not been granted. They're challenging Rule 9.
ಅದರಿಂದ ಬಹಳ ಹೆವಾಕ್ ಆಗ್ತದೆ.
Rule 9 has been challenged. Their ground is, my lords, they have completed minimum term tenure of 4 years. Rule 9 is challenged, my lords, to see that they continue there. But my problem is I have my lords, shortage of staff. Now recruitment started in 2021. no, appointment orders, my lords, were issued on 5th of September. Now, counseling has to happen for me to give posting. In terms of the rules, posting can be given only in Zone E. All of them are working in Zone E. Those who have completed minimum year will be shifted out and they will be given posting. And 1011 postings have to be given. 53 applicants are there. Any, my lords,
ನೀವೇ ಹೇಳಿ ಯಾವ ರೀತಿ ಮಾಡಬೇಕು.
my lords, if
Validity of rules are challenged.
please, my lords.
Otherwise,
Lords,
they
if we
have to
say
look into.
that the counseling can go on and the result of the counseling shall not be given effect to, what will happen is for the 53 persons, I will not be able to shift out, but for the remaining people, I can give posting where there is no dispute. But for the 53 new applicants, they will have to wait for the posting till, my lords, they come in and there is shortage of staff. Now, if I give a posting to which they choose, they'll be going and working there again after 15 days. If they're displaced, there could be some havoc. My respectful submission is this: in case they're agreeable, my lords, 11th, my lords, the petition is scheduled before the tribunal, the same day that the other petition also. But their pleadings were complete. Here, my lords, it is a fresh petition. We are supposed to complete the pleadings. We'll maybe try to complete the pleadings on 11th and get a date fixed, my lords. That is on the validity of the rule itself. But till that time, my lords, we will counseling was scheduled on Monday. It has been postponed. Now, in all probability, tomorrow or day after, we're going to do the counseling. My lords, may I just make this suggestion? We will hold the counseling and we will see which post they are given. We will come back after 2 days so that in case most of them are agreeable, they can go to the place of their choice. And thereafter, my lords, this any interim arrangement could be made in this case. Is that?
Prima facie, that should be acceptable. Might just mention whatever Learned AG said is all absolutely right. Only with respect to the numbers, a slight variation. The new recruits are all about 1,000 people. The transferable posts are about 400. So there is a vast difference there. And therefore, that should not be affected. It is not just about Zone E people being affected. Here, the larger question why we have challenged. In fact, Rule 4 was...
ಅಲ್ಲಿ ಯಾವ ಆರ್ಡರ್ ಮಾಡಿಲ್ಲ KT
KT has just issued.
Reconsider ಮಾಡಲೇವು.
Please, lords, what insofar as interim arrangement, my lords, what happens is this: tomorrow, when counseling happens, they will be choosing a post, but will not give effect to that. We'll come back to my lords. If out of 53, 30 people are satisfied with their posting,
At least to that
even rule challenge itself will not.
I'm told even today some more have gone to KT.
Don't worry about it. They are not your clients.
Please.
Lords, counseling is scheduled tomorrow.
Tomorrow.
I will come back.
Counseling Counseling agli.
We'll come back on Monday, my lords.
Monday, ಬರ್ರಿ.
For insofar, we will not disturb them till Monday.
All right. Call this matter Tuesday.
Please, my lords.
ಮಾಡ್ಬೋದಾ? On Tuesday. First off, interim order granted would continue till then. Okay.
Please, grateful.
Appearing for the appellant in this matter, yes. Suit for declaration, the applicants want to come on record on the ground that they have a right, they have a share in the property. That the suit is filed against the corporation for declaration and mandatory injunction, my lords. So if they want to come on record as a shareholders, this application is not maintainable. They have to file a suit for partition.
But suppose if you are declared as the owners of the subject property, will they not be affected? They will be.
Yes, my lord. So
then they are entitled to be impleaded. Although ideally they should have been before the court below is one thing. But now it's a continuation of the original proceeding only.
yes, my lord. They are seeking for impleadment only on the ground that they are the children of some Jogappa. But we are disputing that, my lords. This suit is filed against the corporation for a declaration that.
Then you say that we will not enforce this decree against them. I will write that and leave them. See, declaration, these are all decrees in personam, not decrees in rem.
Please.
Is it not?
Please.
So decrees in personam midre, decree will be binding inter party or persons claiming under the parties. Section 11.
Please.
So you cannot pass, even if you succeed, then you cannot, in the guise of this decree, you cannot disturb their apple cart. If you agree, we'll write that and dismiss the application. That will be the legal position, otherwise also. Otherwise, Rajia Begum, 58 Supreme Court. We leave it to you now. Choose one.
Maybe, Your Lordship may consider the application.
Consider the application.
In fact, my lord, the proposed applicants, father by name Bellurappa,
How we can decide all these things?
he filed a suit against the I am representing the corporation. It is let's about CS at American site. We are in possession of the property. It's
You are
civic-
defendant.
dependent corporation.
1 second. You are defendant.
Yes, my lords.
First defendant.
Dependents,
Or
1, 2, 3.
only defendant.
Yes, only dependent.
Only defendant. You are corporation.
Yes,
Statutory
madam.
corporation.
Please, my lord, suit is filed against me.
1 second. Who will decide what should be the cost title of the original proceeding? Who are you?
We are,
Give me one provision, one single decision, where defendant can seek impleading, except in partition. In partition suits, and there are other 2 more suits. What Mullah says is, there, who is plaintiff, who is defendant, pales into insignificance. But in this case, in declaration, you can resist the suit on the ground that necessary parties are left out. But you can't say he should add the necessary party. What is your right to?
and I am not
interfere?
making any submission so far as implead the applicants as parties. Before filing the present applicants to come on record, their father by name Bellurappa has filed a suit against the same property against the corporation.
Correct.
That suit came to dismiss on merits. Thereafter, he filed RAPA 321/1992. It was disposed of way back in 1999.
So,
With the observation, my lord, shall I read, my lord, the portion of the,
no,
Well-
what is your right? What are you saying now?
my submission to my lord, it's the property belongs to corporation, we are in possession of the property, public at large making use of the property in question.
Correct.
Now plaintiff is claiming right over the property and the impleading applicants also claiming right over the property in question.
Do you hold,
Ultimate,
do you hold a brief for the other persons? You are entitled to protect your interest.
yes, my lord.
Is it not?
Yes, my lord.
Why do you worry? You need not convert this into an interpleader proceeding.
Instead of protract the proceedings, my lord, come on
It's
record.
not in CPC, necessary party, proper party, desirable party. Only 3 classes. ಅವರನ್ನ ಮಾಡ್ಲಿದ್ದಾಗ litigation ಗೆ ಏನ್ ಆಗ್ಬೇಕು ಅನ್ನೋದು. What is, it's not your.
Their rights already been decided by the, by this court in Arbitral
They
proceeding.
are not here. ಅವ್ರೆಲ್ಲಿದ್ದಾರೆ counsel for applicants?
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಬಂದಿಲ್ಲ.
last time ಬರ್ಲಿಲ್ಲ ಅವ್ರು.
ಬಂದಿಲ್ಲ.
ಬಂದಿಲ್ಲ.
Lordship has noted their absence in the order sheet.
But have we noted that? This appeal is more than a decade old. First, it arises from a decree, judgment and decree rendered in a suit for declaration and injunction.
Please.
First, the impleading applications are moved in the appeal. Arguably, in the appeal, and they are supported by affidavit. First, the applicants were not parties to the suit.
Please.
So, first, ordinarily, those who were not parties to the original proceeding are not permitted to get impleaded on their own in appellate, at appellate stage, subject to all just exceptions into which case of the applicants does not fit. Next paragraph. Secondly, the decree in question or outcome of the appeal is apparently inter partes. And therefore, persons who are not parties eo nomine to the suit or to the appeal are not bound by the decree. First, next paragraph. In the above circumstances, such applications are rejected after noting absence of their advocates. ಯಾವತ್ತು ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀರಿ? ಬರೀ 2013 ಸ್ಟಾರ್ಟ್ ಮಾಡಿಬಿಡಿ.
ಪೇಪರ್ ಬುಕ್ಸ್ ಹಾಕ್ಬೇಕು.
ಇನ್ನು ಹಾಕಿಲ್ವಾ?
ಇನ್ನು ಹಾಕಿಲ್ಲ ಸರ್. 2 weeks time.
Paper books to be filed within 10 days, failing which appeal stands rejected.
Please.
Lord, I appear for the petitioner.
Yes,
Matter relating to the
ready. But
the petitioner before your worship.
Rangnath, we have a small prayer to you. After you speak one sentence, halt for a moment so that we can process your speech. Yes.
Lord, the petitioner herein was the applicant before the Central Administrative Tribunal. She was working as a scientist C in the respondent Central Research Training Institute. My Lord, she was
Agriculture Research Training Institute.
Yes, ma'am.
Technology Institute.
Yes, ma'am.
Yes.
She was initially appointed as a senior research assistant as per annexure A1, page 40.
Page 40. That was 21/7/1989.
Thereafter, my Lord, she was the revision of pay scales were ordered, and the petitioner who was working as research assistant was treated as a scientist, my Lord, page number 41.
This matter will take another 15-20 minutes. Your friends can go for a coffee round. Others.
Yeah.
Huh?
Yeah.
All.
On 17/12/89, to pay by the pursuant to the approval of the conveyed by the Ministry of Textiles, Government of India for revision of pay scales of CSB scientists. The pay scale attached to the post of senior research assistant under Central Board has been revised from 8,000 so having completed 10 years of service in grade of 6,500. In respect of those who have not completed 10 years are competent
break up your sentences, small sentences.
She was granted the pay scale under this government order.
Pay scale was granted on?
So on 17/12/99, but with effect from 7/8/99, para 2 ending.
Where is that? In this only?
A2, page number 41, para 2 ending. She is advised to submit necessary option, like pay fixation was done, man.
You're right.
Then, madam, A3, page number 42. In continuation to this office intimation on subject of Rekha statistician Central Research Institute is hereby informed that her designation has been changed as senior research officer statistics from 7/8/99. That the very date from which my pay scale was granted, I was redesignated as senior research officer statistics.
It's a redesignation.
Redesignation. Then, my lord, your A5, page number 44. Consequent of rationalization of the cadres,
Assistant Director anta madidru.
Assistant Director has been changed as Assistant Director from the date of issue of this order, that is from 2001, 28/11/2001.
Idu change of designation consequence idya?
A consequence in it is an administrative decision to change it. There is no consequence because pay scale and all remained the same.
Only change of nomenclature.
ಹೌದು, ಅವರು ಸೀನಿಯರ್ ರಿಸರ್ಚ್ ಆಫೀಸರ್ ಅಂತ ಇತ್ತು ಡಿಸಿಗ್ನೇಷನ್, ಅದನ್ನ ಅಸಿಸ್ಟೆಂಟ್ ಡೈರೆಕ್ಟರ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ದಿ ಪೇ ಅಂಡ್ ಆಲ್ ರಿಮೈನ್ಸ್. ದೆನ್ ಮೈ ಲಾರ್ಡ್, annexure A6, page number 45.
Fixation of pay.
ಫಿಕ್ಸೇಷನ್ ಆಯ್ತು. ಅದಾದ್ಮೇಲೆ that was in 2006 April.
With retrospective effect from 7/8/99.
99. Then, my lord, as per annexure A7, page number 46.
further promotion was given to scientist C, my lord, because the post which I held earlier, that is SRO, Senior Research Officer or Assistant Director, was grade of the grade of scientist B, and the next higher scale was of scientist C. This was granted. Let me read the order, page number 46. Scientist C ke promotion ಕೊಟ್ಟಿದ್ದಾರೆ.
Promotion is given with effect from 38/2006.
Yes, sir, correct. Based on the performance assessment interviews, the following.
Then what happened?
Then, my lord, for the first time after 7 years thereafter in 2012, I was issued with a show cause notice annexure A8 saying that your promotion given earlier and all pay fixation done was not correct, and therefore the same is sought to be cancelled, my lord. I will read the notice. Page number 47. The Honorable High Court of Karnataka at Bangalore in WP number so filed by Central
That
Silk
was
Road.
Dodda Narsaya's case, they made the order.
Yeah, that was a case. I will read the order. I have put it, my lord. That has nothing to do with my case, but they refer to that order, my lord. Let me read this notice and then come to the order of the High Court. Passed by this also, Honorable High Court, while quashing the order dated so and so.
One nimsha. We are reading. Wait. Why you should not be put back to the common cadre?
Well, first of all,
our show cause notice ಕೊಟ್ಟರು ನಿಮಗೆ.
ಕೊಟ್ರು,
In the light
ಕೊಟ್ರು.
of that ದೊಡ್ಡ case. ಆ judgment ಎಲ್ಲಿದೆ?
Exactly. I am coming next, my lord. Page number 51, annexure A9.
ಅಲ್ಲೇನು ಹೋಲ್ಡ್ ಮಾಡಿದ್ರು?
ಅದ್ರೊಳಗೆ ಏನ್ ಮಾಡಿದ್ರು, ಅವ್ರಿಗೆ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಪೇ ಸ್ಕೇಲು, ಅದನ್ನ ನಂಗೂ ಕೊಡಿ ಅಂತ ಅವ್ರು ಕೇಸ್ ಹಾಕಿದ್ರು. ದಿ ಫೈನಲ್ ಆರ್ಡರ್ ಅಟ್ ಪೇಜ್ ನಂಬರ್ 72, my lord. Page number 72, paper book, internal page 21 of the court order. Para 17.
So extending revised pay scale to him.
ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ ನನ್ನ ಬಗ್ಗೆ ಅಥವಾ ಬೇರೆ
As
ಯಾವ
was given to rest of the people.
Yes, ಅಷ್ಟೇ ಹೇಳಿದ್ದು. ಅದ್ರೊಳಗೆ there was no, in fact I am not a party to that also. There was no reference to my case or any other case except saying the authorities shall hear the applicant receive any written submission and thereafter consider the case of the applicant for extending revised pay scale as was given to research assistants in accordance with law and for appropriate orders within 2 months from the date of the order. They shall not only decide the question of pay fixation but also decide question as to whether pay is fixed if the arrears to be kept. So entire thing was whether to be given to him as per the research assistant ಬೇರೆಯವ್ರಿಗೆ ಕೊಟ್ಟಂಗೆ ಇವರಿಗೂ ಕೊಡಬೇಕೋ ಬೇಡೋ ಅನ್ನೋದು ಕ್ವಶನ್ ಅಷ್ಟೇ. Beyond that there was nothing in the order. But taking reliance on this order, after 12 years of my promotion, that is I was granted promotion in 2007, whereas this notice was issued after 5 years of my promotion to the said cadre, redesignation ಎಲ್ಲ ಆಗಿದೆ. 89 ಇಂದ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದನ್ನ they sought to cancel. Then my lord, I replied to this note.
All right. Again, pause. Sentence pausing back. Otherwise, we'll post this matter some other day. We are dead against absence of pause. Pause is essential part of speech. This is what Osho says. ನೀವು ನಿಲ್ಬೇಕು, ಯಾಕಂದ್ರೆ ನಾವು ಪ್ರೊಸೆಸ್ ಮಾಡ್ಬೇಕಲ್ಲ ನಿಮ್ ಸೆಂಟೆನ್ಸ್. ನಿಜ ಹೇಳ್ತಿರೋ, ಸರಿ ಹೇಳ್ತಿರೋ, ತಪ್ಪು ಹೇಳ್ತಿರೋ ನಮ್ಗೆ ಗೊತ್ತಾಗೋದು ಹೆಂಗೆ? ಯುವರ್ ಫಸ್ಟ್ ಸಬ್ಮಿಷನ್ ಈಸ್ that case had nothing to do as the prelude for passing that order ಅಂತ ನಿಮ್ದು ಒಂದೇ ಫಸ್ಟ್ ಕಂಟೆನ್ಷನ್ appears to be so. How that is treated by the tribunal?
Before that one, I will just want to add one more thing. After this notice, I gave a reply, my lord. That reply is annexure A10, page 75. If your lordship want to read the reply, you can read the reply. Page number 2, page 75.
ಅದರಲ್ಲಿ ಕಂಟೆನ್ಷನ್ ತೊಗೊಂಡ್ರ ನೀವು ಆ ಕೇಸಿಗೂ ನೀವು ಮಾಡ್ತಾ ಇರೋದಕ್ಕೂ ಒಂದಕ್ಕೊಂದು ಸಂಬಂಧ ಇಲ್ಲ ಅಂತ ಏನಾದ್ರು ಹೇಳಿದ್ರಾ?
ಹೇಳಿ.
ಯಾವ ಪೇರ ಅದು? In which paragraph you have?
Page number 78, para 4.
78, para 4. 78.
Honorable High Court. May I read, my lord?
77, 78.
78.
ಅಲ್ಲಿ ಟೇಬಲ್ ಇದೆ.
ಆ ಟೇಬಲ್ ಅಲ್ಲಿ 4ನೇ ನಂಬರ್.
Table 1, 2, 3, 4. 1, 2, 3. Honorable High Court, while disposing of case, remitted the matter to the board for fresh then honesty was extending same benefit from the who had post graduation qualification, not biological. Our biological sciences ಅಲ್ಲಿ ಅಲ್ಲನು?
ಅವ್ರದ್ದು ಬೇರೆ, ಅವ್ರದ್ದು ಕೇಳರೆ ಬೇರೆ, ಸ್ಟ್ಯಾಟಿಸ್ಟಿಕ್ಸ್, economics and statistics. The then member secretary, having considered the case erroneously, passed the order extending same benefit from the date of the order extended to statistics, which has post-graduation qualification at biological science. That my answer, my lord, after the High Court order, next one. Scientific care, right side.
For non-scientific works. That Dodda Narsaya was in non-scientific cadre.
Cadre, how? That is my contention. Scientific cadre commences from SRA, that is Senior Research Assistant, for which entry qualification as per the recruitment rules is MS second class. The improved pay scale was exclusively meant for scientific staff of board. However, scientific pay scales were also extended to senior research assistants having master degree in sociology and management subject, who were originally appointed for scientific work and R&D unit only. In the case of Doddarsaya, he has been appointed exclusively for board secretariat and for non-scientific works. Therefore, don't compare me with Doddarsaya. That is my contention.
How this contention is treated by the tribunal?
Tribunal, my lord.
The next order, the tribunal. Earlier, he had gone to the tribunal.
ಅಲ್ಲ ಅವ್ರು ಹೇಳೋದು ದೊಡ್ಡ ನರಸಿಯ ಕೇಸ್ನಲ್ಲಿ ನೀವೇನೀಗ ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ
ಅಲ್ಲ,
ಆ ಸ್ಕೋಪ ಇಲ್ಲ ಅಂತ ಹಂಗನಿಸ್ತು.
ಅದನ್ನೇ page 86, your lordship will see the earlier litigation, the tribunal has settled it. The applicant was the first applicant here. Petitioner Rekha.
ಕರೆಕ್ಟ್. ಅಲ್ಲಿ ಏನಿತ್ತು ಚಾಲೆಂಜು?
The reversion, the changing of the designation and the pursuant to the show cause notice, we passed the final order. That was challenged here. Page 107 in the, your lordship will get the reasons of the tribunal. They refer to the High Court order.
ಬಟ್ ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ಕರೆಕ್ಟ್, ಬಟ್ ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ನಲ್ಲಿ ನೀವ್ ಹೇಳ್ದಂಗೆ ಇಲ್ಲ ಅಲ್ಲಿ.
ಇದೆ.
ಜಸ್ಟಿಸ್ ಕುಮಾರ್ ಅವ್ರ ಜಡ್ಜ್ಮೆಂಟ್
Yes.
ಅವ್ರು ಏನ್ ಹೇಳಿದ್ರು, ಇವರಿಗೆ ಆನ್ ಪಾರ್ ವಿತ್ ರೆಸ್ಟ್ ಆಫ್ ದ ಪೀಪಲ್ ಕನ್ಸಿಡರ್ ಹಿಸ್ ಕೇಸ್ ಫಾರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ದಿ ಪೇ ಸ್ಕೇಲ್ ಅಂತ ಹೇಳಿದ್ರು.
No, if
ಈ ಎಂಟೈರ್ ಎಕ್ಸರ್ಸೈಸ್ ಮಾಡ್ರಿ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಅದರಲ್ಲಿ?
ಇದೆ.
ಹ?
Yeah.
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್? Para 16 even. Even 16 is specific. Long standing, you can't, we can't go back to the days of Alexander and say,
No,
no,
my
tappagittu
Your
Alexander.
lordship may see para 20 onwards, page 107.
107.
Yes. Tribunal has dealt with earlier itself.
This same issue was raised.
Same issue was raised by the applicant themselves herself.
And that was judged against her.
Yes.
Very
It was said, let the central government decide.
Let the central government.
Para 23.
23.
3.
It is needless to mention that as held with the Honorable so and so 22, writing the judgment of in the case of Suresh Kumar so and so, equation of votes and equation of salary is a matter which is best left to an expert body, and that fixation of pay and determination of parity among duties and responsibilities is a complex matter for the executive to decide. In the instant case, it is for government administrator to decide the question of equivalence.
Now
I
you-
decide ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ.
Now your lordship may go to 175 page.
ಅದೇನು equivalence between
ಅಲ್ಲ.
ಅಲ್ಲ ಇದರಿಂದ ಅರ್ಥ ಮಾಡಿಕೊಳ್ಳೋಣ.
Statistics.
Huh?
Whether they are eligible to become scientists, statisticians.
Statistical and economic staff ನಡುವಿನ
Yes. Whether that your lordship will get it answer in 175. That they were given they claim promotion, they were given promotion under FCS scheme. That your lordship will get it in the letter giving the
175.
promotion itself.
ಏನಿದು 175?
175 ಅಲ್ಲಿ
ಸರ್ ಇದು
FCS
ಏನು?
for the lot of queries were being raised by all over India. So they said next page, Mela. Next page. First file.
Five, qualification not required.
Allah, whether qualification MSc can be covered under FCS ಅಂತ ಕೇಳಿದ್ರು. Question.
No ಅಂತ ಹೇಳಿ.
They said no. So statisticians will not become scientists.
No, we are not on that.
We are on that.
You are on that, but we'll
We
treat
are
that.
on that.
But his grievance is, what Mr. Joyce says is, where is the, assuming that everything is wrong, at this length of time, how could you undertake the rectification measure?
My lord, if your lordship says one person, if he gets a relief, others can also get relief under Article 14. Right, my lord? If I have understood Article 14, as long as I have practiced, the principle here is, if one person has got it, the others in the same cadre will also get it.
Broadly, yes.
Yes.
Subject to many exceptions anyway, unless.
Here, my lord, Dodlar Saya was also in the cadre.
his claim was rejected. Then the applicant was also similarly situated in the same cadre. The applicant was given show cause notice, giving the reasons why we should not apply the judgment to you also. And the Honorable Tribunal accepts it. Earlier round of litigation, this three, your lordship got that judgment, my lord.
Yes.
Page 86. This is not challenged before any court. It is accepted by the.
ಅದು ಮೊದ್ಲಿಂದ OA ಏನಿತ್ತು ರಂಗನಾಥ್ ಬೇಸ್ರೆ?
Yes, my lord.
ಅದು ಮೊದ್ಲಿನ OA ನಂಬರ್ 1470 of 2014.
ಅಲ್ಲ 363.
363 of
363, my lord. This 363 was the first round of litigation where very notice was challenged. And the tribunal, my lord, because the government's orders were not there, therefore at page number 110.
ಅದೇ 24. Para
24 is with the above direction and observation, OSR stand disposed of the interim order as on so stand there, but it would prudent to CSB to avoid the decision of the central government in the matter before proceeding further action to prejudicial to the including recovery against the applicants and others similarly situated. So
ಈಗ ರಿಕವರಿನೂ ಮಾಡ್ತಾ ಇದ್ರನ ಅವರು?
Recovery, my lord, one small submission I want to make here, my lord. Now, before the tribunal, we have challenged the order by which recovery and refixation was done. Okay, my lord. Then, my lord, during the pendency of the application, we had a stay. But thereafter, application came to be dismissed. Therefore, we have filed this during the pendency, my lord, they implemented the order and so far as much they changed my as per the tribunal's order, they have changed everything, my status and all, my lord. But recovery, my lord, has now so far not been made. Now
recovery is not done.
Applicant has the petitioner has since retired, my lord. Therefore, only I request your lordship that there was a marginal difference between what was sought to be done subsequent to the Dasaya and earlier. So that applicant has taken the subsequent implementation of the order, retired also. So only thing is no recovery be affected as per Rafiq Masid case is my limited prayer in the at present, my lord. That is all what I am saying. Because I don't want to reopen the issue. She has taken the modified order in pursuance of the order of the Darsaya because of the pendency of this. In this writ petition, there was no stay. Therefore, the refixation has been done, but recovery may not be made. That is my limited question. What was paid for 8 to 7 years prior to the impugned order?
2013.
Yes, Rafiq Masid. 2015 SCC volume 4 334, my lord.
My lord, I have got
KR Singh judgment,
Rafiq Masid, whitewasher.
Punjab.
Whitewasher, yeah.
State of Punjab versus
If your lordship should see these two government orders, Government of India, they have extracted the judgments.
ನಾವು ರಫೀಕ್ ನಿನ್ನೆ ಫಾಲೋ ಮಾಡಿದ್ವಿ ನಾವು.
Rafiq Masid squarely comes to my question, my lord. Last 4 directions, if your lordship just see the last direction, whether I come within the purview of those directions is the question. Last, in which cases recovery should not be made is stated there.
Where they said where the employee had no role to play.
No, here it is only for Group C and Group D. Group C and Group D.
No, others also.
No.
Only one paragraph till Group C and D ಇದೆ. ಮುಂದಿನ ಬೇರೆ paragraphs ಹಂಗಿಲ್ಲ.
ಇದೆ.
That is considered.
Final order.
ಯಾವ್ದದು? ಹೆಸರು. Which is that whitewasher case is referred in 2022 Supreme Court, na?
Yes.
ಯಾವ್ದು judgment? It is explained by 2022 judgment.
No,
It
the
is.
judgment has not been modified.
ನೀವು ನೋ ಅಂತ ಹೇಳ್ಬಾರ್ದು. ಜಡ್ಜ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಂದ್ರೆ ಇಟ್ಸ್ ನಾಟ್ ದಟ್ ವಿಲ್ ನಾಟ್ ಕಮಿಟ್ ಮಿಸ್ಟೇಕ್, ಬಟ್ ವಿ ರೀಡ್ ಮೋರ್ ದ್ಯಾನ್ ಯು ರೀಡ್. Therefore, I am telling this with humility. I am asserting this. I am repeating this. ಕೊಡೋದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡೋದು 2022 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನೀನೇ ಮಾಡಿದ್ದು ಯಾವುದು? Yesterday we decided that matter, na? We referred to that judgment. We have reproduced that particular paragraph. Which is that? What do you remember? ಈ ಏಜಿಗೆ ಎಷ್ಟು ಬೇಗನೆ ಮರೀತಾನೆ, ಯಾವಾಗ ನೆನ್ಪಿಟ್ಕೊತಾನೆ? ಎಷ್ಟು ಡಿಫರೆನ್ಸ್ ಆಗ್ತದೆ? What would be the differential amount you want to recover?
1 lakh and odd. She is now, she retired in 2024. She was holding Group A post. So Rafiq Basha's judgment will not apply.
ಕೊಡಿ ಇಲ್ಲಿ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ. 2015 ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೇನು?
Rafiq Basha's para Roman 2.
ರಂಗನಾಥ್ ಜೋಯಿಸ್ರೆ, ನೀವು ಇಲ್ಲಿಗೆ ಬರಬೇಕು ಕೋರ್ಟಿಗೆ.
ಹೌದು
ಇವತ್ತಲ್ಲ, ಯಾವತ್ತು ಯಾವಾಗೂ ನಮ್ಮನ್ನು ನೀವು ಅನ್ಟಚಬಲ್ ಆಗಿ ಟ್ರೀಟ್ ಮಾಡ್ತೀರಿ.
No, never.
With you.
I am proud and in fact I am very interested. But today I have got another case. I am sitting in KAT, my lord. I am sorry. I have due respect to the High Court, but some other case.
ಈಗ ನೀವು ಜಡ್ಜ್ಮೆಂಟ್ ಹೇಳ್ತೀರಿ, ನಾವ್ ಹೆಂಗಪ್ಪ ತಗೊಂಡು ನಿಮ್ ಕೈಯಿಂದ ಇಸ್ಕೊಳ್ಳೋದು ಹೆಂಗೆ? ನಾವು ಇನ್ನು ಅಷ್ಟು ಟೆಕ್ನಾಲಜಿ ಮುಂದುವರೆದಿಲ್ಲ. ಇನ್ನು ಸ್ವಲ್ಪ
that blame I take on myself. I will give the copy along with the memo. I can give.
ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡೋದೇ ಇಲ್ಲ ನಾವು. ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಡೆಡ್ ಅಗೇನೆಸ್ಟ್ ಇದ್ದೇವೆ ನಾವು. ದಿಸ್ ಸೈಡ್ ಆರ್ ದಟ್ ಸೈಡ್ ಪೀಪಲ್ ಶುಡ್ ನೋ. ಏನ್ ನಾವು ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ನಾವೇನು ಬ್ಯಾಂಕ್ ಬಿಸಿನೆಸ್ ಮಾಡಲ್ಲ ಇಲ್ಲಿ. ನೋ ಕ್ವಶನ್ ಆಫ್ ಅಜರ್ನ್ಮೆಂಟ್. ಒನ್ಸ್ ಹಿಯರಿಂಗ್ ಸ್ಟಾರ್ಟ್ಸ್
Adjournment.
ಕೊಡಿ. ನಿಮ್ಮಲ್ಲಿ ಇದೇನು ಜಡ್ಜ್ಮೆಂಟ್ ಅದು? ರಫೀಕ್ ವೈಟ್ ವಾಷರ್ಸ್ ಕೇಸ್
In the bunch, my lord, it is extracted. I gave your lordship the government orders bunch.
2015 4 SCC
Your
page 3.
lordship should see the last page, last government order, 2016 government order. At para 4, they have extracted it.
ಓದಿ ಪ್ಯಾರಾ 4 1 2 3 4 5 ಪಾಸ್ಟುಲೇಟ್ಸ್ ಇದೆ.
Yes.
ನಿಧಾನವಾಗಿ ಓದಿ.
Yes.
Recovery from employees belonging to class 3, class 4 series, group C, you cannot do.
Cannot
Go to the next point.
Yes.
Recovery from retired employees.
Our employees
who are
due
due
to
to
retire 1
retire
year.
within 1 year of the ordinary recovery. No recovery. That for that group C and D does not apply.
Correct, my lord. The petitioner was in service.
Huh?
He retired only in 2024, March.
Near.
31/3/2024.
All right. Go to 4.
Even that will not apply, my lord.
Go to, we'll agree with you now. Arguably, we are with you now.
Recovery from employees who excess payment has been made period of 5 years.
5 years. Before the order of recovery is issued, how many years you had issued?
Before the order of recovery is issued, that is stayed by the courts.
No, recovery was issued when?
2013.
2013.
That was challenged in the OA.
1 second.
Yes.
2013 was the recovery order.
That was stayed by the
Not
court.
allowing us to put the question also.
Yes.
You don't want to put the judges to put question to you, but we will put you those questions.
Yeah.
We are not at your mercy. You are bound to answer this way or that way.
I am ready.
Answer. Now, you issued recovery notice dated what?
I'll tell you.
Tell the date.
It is there. It is produced.
Tell the date when you first time issued recovery notice. Tell, put na? 2022 Supreme Court. If Thomas Daniel.
28 3
28,
3 2013.
28, 3, 2013. This is the recovery notice.
Yes.
It intended to recover the amount paid up to what period?
Up to that day.
Huh?
Up to that day.
First payment was made, first excess payment.
First excess payment was made in pursuant to A4,
A4.
which my friend read to your lordship.
A4 ಅಂದ್ರೆ ಯಾವ್ದಾಗ್ತದೆ ಪ್ರಸಾದ್? A4. 28 August 2001.
Yes. No, 6/4/2006.
Huh? A4 ಅಲ್ಲ ಅದು.
A6.
Huh?
A6.
A6 is 6/4 to your right.
Yeah.
A6 is 6/4
2006.
2006.
And that was stayed by the tribunal,
That was stayed when?
by the OA 363.
That was stayed when? It must be subsequent to
2013.
2013.
2013.
Now we'll assume that it is stayed. The question is, till 28/3/2013, come to the first, which is that first. In any other case where the court has recovery in cases where an employee has wrongfully been required to discharge duties of air force and has been paid according. The third postulate.
Yes.
Recovery from employees
employee
when the
where
excess
excess
payment has been made for a period in excess of 5 years.
Yes.
ಅದು 5 years, 6/4/2003 ಇಂದ
2006.
6/4/2006 ನಿಂದ 5 years ಅಂತ ತಗೊಂಡ್ಬಿಟ್ರೆ 3/4/2011 ಆಗ 3/4/2011 ಇಲ್ಲಿವರೆಗೂ ನೀವು ರಿಕವರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ, even if the rest is stayed and quashed also. Number.
Yes.
And kindly come to the next postulate.
Yes.
Next postulate note.
Recovery in case where an employee has wrongfully been required to discharge duties of higher
Post.
and
has been paid accordingly, even though he should have rightfully been required to work against an inferior post. ಇದೇನಾಗ್ತದೆ?
ಅಲ್ಲ, ಇದರಲ್ಲಿ he was wrongly promoted by the CSB, giving a flexible scientific scheme, FCS.
ಅಲ್ಲ, ಅವ್ರು ವರ್ಕ್ ಮಾಡಿದಾರ ಆ ಪೋಸ್ಟ್ ನಲ್ಲಿ?
ಅಲ್ಲ, it is equivalent. Automatic.
Same post.
Assistant director only. It is called as scientist D. That's all.
Come to next postulate.
Yes.
ಅವ್ರೆಲ್ಲ ರಿಟೈರ್ಡ್ ಎಂಪ್ಲಾಯಿ, ರಿಟೈರ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಏನೇನೋ ಮಾಡ್ಕೊಂಡಿರ್ತಾರೆ ಅವ್ರಿಗೆ.
The retired employee ಇದಾದ್ರೆ, if we in my case, he was a group C employee.
That's all right. But
Let me explain to you all.
yes,
The pension now the applicant is getting is 52,800. Not mal. Your lordship may fix installment recovery. We have no objection. And my lord, we have paid her retirement gratuity of 25 lakhs already. It is not some small sum, or employee who is very getting meager pension or any such thing.
ಅಲ್ಲ, ಈಗ ಅವರಿಂದ ರಿಕವರ್ ಮಾಡೋದು ಎಷ್ಟು ಅಮೌಂಟ್?
1 lakh, same, 1 lakh and odd.
ಅಷ್ಟೇ.
Yes. Your lordship may fix 10 installments.
ಈ 28/3/2013 ಆರ್ಡರ್ ಇದೆಯಲ್ಲ, ಅದು 5-year ರೂಲ್ ಅಪ್ಲೈ ಮಾಡಿದ್ವಿ ಅಂದ್ರೆ ಇದರಲ್ಲಿ 3/4/2011 ವರೆಗೆ ಪೇಮೆಂಟ್ ಆಗಿದ್ದನ್ನು ನೀವು ಬಿಟ್ಬಿಡ್ಬೇಕಾಗ್ತದೆ. 5 ವರ್ಷ ಆಗಿಬಿಡ್ತದೆ ಅಲ್ಲಿ. ವೈಟ್ ವಾಷರ್ ನಲ್ಲಿ, ಇನ್ ವೈಟ್ ವಾಷರ್ಸ್ ಕೇಸ್, ಪಾಸ್ಟುಲೇಟ್ ನಂಬರ್ 4, ಯು ಆರ್ ರೈಟ್. ಪಾಸ್ಟುಲೇಟ್ ನಂಬರ್ 4 ನಲ್ಲಿ 5 years ಆಗ್ಬಿಡ್ತು ಅಂದ್ರೆ ಟೈಮ್ ಬಾರ್ಡ್ ಆಗಿಬಿಡ್ತದೆ.
ಅದು 3.
ಅದು 3, ಕರೆಕ್ಟ್. 3 5 ವರ್ಷ ಆಗಿ 5 ವರ್ಷ ಆದ್ಮೇಲೆ ಬಿಟ್ಬಿಡಿ. ಅದ್ ಮ್ಯಾಲಿಂದ ಬೇಕಾದ್ರೆ ನೀವು ಅದನ್ನೇನೋ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಏನೋ ಒಂದು ಮಾಡಿ. 5 ವರ್ಷಕ್ಕೆ ಎಷ್ಟು ಅಮೌಂಟ್ ಆಗ್ತದೆ? 8/4/30. ಅದು ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. 8/4/13 is notice is important. Prasad,
Yes.
you issued notice to him on 8/4/2013.
Yes.
From that day till that day, the time runs. Even in a suit for recovery, where certain laws prescribe prior notice.
That was because the judgment of this honorable court in Dodnarseya was in 2012 December. If your lordship should see the judgment, it is in September 2012, page 51.
It was stayed.
No, 51. Dodnarseya's case, your lordship was telling,
Justice Kumar's judgment.
yeah, that was rendered in September 2012. Immediately we issued a notice. Immediately after that order, we issued a
It
notice.
was on 8/4/2013. Notice you issued on 8/4/2013.
Page 84.
No, that was final order.
84 is the first notice.
No,
where you-
notice ನಿಮ್ದಲ್ವಾ? 8/4/2013 is notice ಅದು.
No, that is a consequential order, my lord, 28/3/2013. And page 80 is the detailed order. If your lordship should see the page 83, consequential order is 84.
Still 8/3/2013 ಆ ಡೇಟಾ ಒಪ್ಕೊಂಡ್ರು ಸಹಿತ ಸ್ಟಿಲ್
ಅಲ್ಲ ಅಲ್ಲ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಯಾವಾಗ ಆಯ್ತು?
ಅದು 2012.
2012. Immediately we issued notice. Show cause notice. Immediately after that.
ಅಲ್ಲ, we agree that you are a very strong advocate, but ಕೇಸ್ ಪಾಪ ವೀಕ್ ಇದ್ರೆ ನೀವೇನ್ ಮಾಡಿ?
ಇಲ್ಲ, ಕೇಸ್ ಏನ್ ವೀಕ್ ಇಲ್ಲ. If
he has handled thousands of such cases.
Millard,
handled thousands of such cases.
Millard, we issued notice on 24/12/2012. Within 3 months of the High Court judgment. Your lordship will get it at page 75.
ಅಲ್ಲಿ ಕರೆಕ್ಟು ಅಲ್ಲ?
ಹೌದು.
28/3/2013 ನೋಟಿಸ್ ಕೊಟ್ಟಿರಿ ನೀವು?
ಇಲ್ಲ ಸ್ವಾಮಿ, ತಾವು ನೋಡಿ ಪೇಜ್ 75 ನೋಡಿ. A10. Show cause notice. Immediate ಕೊಟ್ಟಿದ್ದೀವಿ.
2/1/2013 ಕೊಟ್ಟಿರಿ. Even going by
ಇಲ್ಲ,
that.
that is the reply. ಅದರಲ್ಲಿ ರೆಫರೆನ್ಸ್ ಇದೆ ನೋಡಿ.
24/12/2012.
Yeah, that is the notice. That is the show cause notice.
6/4/2013.
So within 3 months, we have given the notice of the High Court order. The High Court order settled the issue. You should issue a notice, then recovery anta. Then we pass the order on 28th March. 8.4 is the consequential order. Fixation, other things. That is, your lordship will get it in page 83. We have said that we will pass the consequential orders as per the decision. Consequential orders will be passed. This is 8/4/23, 2013 is a consequential order.
Arising from your show cause notice dated 24/12/2012.
Yes, yes. Which became effective because September 2012, High Court judgment came. Justice Kumar's judgment.
26/9/2012.
Yes. Within 3 months, my lord, your lordship knows, the government has acted upon within 3 months, digesting the High Court order and then giving detailed show cause notice to each of the employees. Not one. Separate. It's not a secretarial order. Each individually it has been referred to. If your lordship should see the show cause notice, we have referred to individually everything.
But for Justice Kumar judgment nalli,
Yes.
ಈ ಎಕ್ಸರ್ಸೈಸ್ ಅಂಡರ್ಟೇಕ್ ಮಾಡಬೇಕು ಅಂತ ಎಲ್ಲಿ ಇಂಡಿಕೇಟ್ ಮಾಡ್ಯಾರೆ?
ಅದೇ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿದೆ ನೋಡಿ.
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಹೇಳಿ? ಅಲ್ಲಿ ಬರೇ ಒಂದೇ ಒಂದು ಇಶ್ಯೂ ಇತ್ತು, ವೆದರ್ ದೊಡ್ಡ ನರಸಯ್ಯ should be given the extension of the benefits or not. That was the only question addressed by the division bench.
No. Para 13 in that judgment, they go into the issue of
ಇಲ್ಲ, ಅದರಲ್ಲೂ ಇಲ್ಲ.
para 15 ali notice on page 70. Question whether the applicant is entitled to higher pay. Similar, my lord, as I submitted to your lordship, when Article 14 applies, your lordship can't apply only to give benefits. It applies equally to all the employees. If one employee has lost it, the other employees also get them. And only thing is, we should issue a show cause notice. We have issued show cause notice. We have drawn the attention, and I also showed to your lordship the Government of India decision that MSc Statistics is not entitled to FCS, Flexible Component Scheme. And they are
overall, Mr. Prasad,
yes.
overall financial consequence ಎಷ್ಟಾಗ್ತದೆ ನಾವು ಇದನ್ನ ಅಪ್ಹೋಲ್ಡ್ ಮಾಡಿದ್ರೆ? ಇವೊಂದೇ ಅಲ್ಲ, because it will have repercussion. Rest of the employees.
Mikorella, most of them have paid. The only problem we have is with the applicant, because she has got throat stay of the recovery. It is court intervention. Supreme Court has also said court intervention will not come in the way of recovery. We are only, Lord, it is not a employee who is getting a meager pension. The applicant is getting 52,000 rupees as a pension now.
Plus 25 lakh.
25 lakhs, we have given it already. I have got all the acknowledgement from her for having received it.
Other employees ಇದೆಲ್ಲ ಏನೇನಾಗುತ್ತೆ? One question is not single employee.
Yes, there are no other practices.
5 years of the
And other awards that recovered. Only this lady itself.
ಅವಾಗ ಇವ್ರಿಗೂ rest of the people also.
Which court? I don't, I have no idea. They are not brought sick. Why do you walk in without knowing the details? You come to give instruction and you walk in without knowing the details. What happened to your law?
ಸಿಂಪಲ್ ಇಲ್ಲ ಇದು. ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಎಲ್ಲ ಏನು ಬೇರೆಯವ್ರ ಮೇಲೆ ರಿಪರ್ಕಷನ್ಸ್ ಬರ್ತದೆ ಅಂತ ಅವ್ರು ಹೇಳೋದು. ಇಡೀ ಹೋಲ್ ಸೆಂಟ್ರಲ್ ಗೌರ್ಮೆಂಟ್ ಥೌಸಂಡ್ಸ್ ಆಫ್ ಎಂಪ್ಲಾಯೀಸ್ ಇರ್ತಾರೆ ಅಂತ ಒಂದರಲ್ಲಿ ಹಿಂಗೆ ಅಪ್ಹೋಲ್ಡ್ ಮಾಡಿದ್ರು. ಬೇರೆ ಕಡೆ ಮತ್ತೆ ರಿಕವರ್ ಮಾಡಿದ್ದನ್ನು ವಾಪಸ್ ಕೊಡುವಂತ ಆಗ್ಬೋದು ಅಂತ ಈಗ ಪ್ರೆಡಿಕ್ಷನ್. Suppose, Mr. Prasad.
Yes.
We understand what you are saying now. We have understood.
Yeah.
In principle, we are with you. But we feel that recovery for 5 years is there. Even assuming your date itself, 2000, that is 12 December 2012. 12. From that, ನೀವು ರಿಕವರ್ ಮಾಡಿ. ಅದಕ್ಕಿಂತ ಮೊದಲಿಗೆ 5 ವರ್ಷ ಏನಾಗತ್ತಲ್ಲ, that 5 year will be over. 5/4/2011. 5, we will agree with you. In principle, we will agree with you because we may lay down a wrong law which will be applicable to thousands of people. We understand that your anxiety. But so far as 5-year limitation period which the apex court has fixed, ಅದನ್ನ ನೀವು ಬಿಟ್ಕೊಡ್ಬೇಕಾಗ್ತದೆ. ಉಳಿದಂಥದ್ದನ್ನು ನೀವು ರಿಕವರ್ ಮಾಡಿಕೊಳ್ಳಿ.
That your lordship may pass an order because
Understand?
the financial aspect, I can't give
Because repercussions ಬಹಳ ಇರ್ತದೆ ಅಂತ ನೀವು ಹೇಳೋದು.
I can't give a concession to the court. If your lordship may pass an order on that.
ಬರ್ಕೊಳ್ಳಿ. Petition is allowed in part in the light of postulate number 3 in Whitewasher's case, as reiterated in 2022 SC AR 2022 SC 2153 Thomas Daniel versus State of Kerala. As a consequence, the amount paid or emoluments drawn with effect from 6/4/2006 up to 3/4/2011 are barred from recovery. First stop. Other recovery ಸ್ವಲ್ಪ installment ಕೊಟ್ಬಿಡಿ.
That is, my lord, that your lordship has the power to
the
pass order.
Recovery in respect of the remainder recovery of the amount for the accruing in favor of the employer for the remainder would be done in 12 equalized installments. Installment. Okay. Rangnath Joyce, now you are also happy. He's also, his anxiety is, suppose, no, he's justified. I tell you why. Not one employee. Thousands of employees irtare. ಅವಾಗ ನಾವೇನೋ ಒಂದು ರಾಂಗ್ ಆಗಿ ಮಾಡಿಬಿಟ್ರೆ ಅದು hundreds of crores ಆಗ್ತದೆ.
But one submission you have to make, my lord. One submission you have to make. ಇದುವರೆಗೆ ನಮ್ದು ಒಬ್ಬರದ ಮೇಲೆ ಇದು ಮಾಡಿರೋದು, applicant is the person. The money they have, the silk board is in the habit of spending money like this. They have spent money. The amount of 1 lakh was nothing compared to the fees they have, a legal expenditure they have made for
Correct,
2
you
rounds
are-
of litigation,
Correct,
one
no, but,
high court petition and all. I'm an employee. That is what I just want to submit that.
Sentence in our considered view, the judgment of Honorable Justice Kumar arguably did not suggest the course which the authorities had taken. However, now that pales into insignificance. All right. Thank you.
Obliged. Sorry for not being physically
No, it's
present.
all right.
Beyond my.
ಏನಾಗ್ತದೆ, ನೀವು ರೂಲಿಂಗ್ಸ್ ಎಲ್ಲ ರಿಲೈ ಮಾಡೋದಿದ್ರೆ ನೀವು ಇಲ್ಲಿದ್ರೆ ಕೊಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ, ಅಥವಾ ನೀವು ಇನ್ನೊಬ್ರು ಯಾರು ಇಡಬೇಕು, ಅಲ್ಲಿ ನಮ್ಮ ಕಲೀಗ್ ಇದ್ದಾರೆ ಇಸ್ಕೊಳ್ಳಿ ಅವ್ರ ಹತ್ರ. We are ready, very happily will receive them.
Sorry. I will do that.
Yes.
This, my lord, my colleague is here, Your Lordship. I may be permitted to appear, Your Lordship.
All right.
Yes, sir.
We treat you as senior advocate only,
I'm sorry.
whether you are designated or not.
Grateful. Your Lordship.
But
The petition, my lord, has joined the duty, my lord, as excise inspector. my lord.
unmatched.
Yes, my lord. As excise inspector, my lord, in 2001. Since 2001, my lord, there was no remarks, my lord, till date, my lord. For the first time, my lord,
He became excise inspector.
excise
when-
inspector, my lord, on promotion, your lordship, I was told. On promotion. And he joined duty in 2001, your lordship. There was a first time, my lord, the charge memo was issued, my lord, on 2 grounds, my lord, that he has raided the house, my lord, in the night on an anonymous information received by him without the uniform and without using the government vehicle, your lordship. That is the 2 charges, your lordship. One charge was not proved, your lordship. Another charge, my lord, they say that it is proved, based on which, my lord, their order came to be passed, my lord.
One first charge ಏನು?
First charge, my lord, without uniform, my lord, he has raided the
raid ಮಾಡಿದ್ ಕರೆಕ್ಟ್, ಆದ್ರೆ ಬಟ್ಟೆ
uniform
ಹಾಕೊಂಡು
ಹಾಕೊಂಡು ಹೋಗುತ್ತೆ. ಎರಡನೇ ಚಾರ್ಜು
ವೆಹಿಕಲ್
ನ ಗೌರ್ಮೆಂಟ್ ವೆಹಿಕಲ್ ಉಪಯೋಗಿಸ್ತಾನೆ, ಮೊಮೆಂಟ್ ರಿಜಿಸ್ಟರ್ ಬರೀದೇನೆ, ನೈಟ್ ಟೈಮ್ ಅಲ್ಲಿ ಇನ್ಫಾರ್ಮೇಶನ್ ಬರ್ಲಾಗಿ ಇವೆಂಟ್ ನೈಟ್ ಟೈಮ್ ವೆನ್ ಯು ರಿಸೀವ್ಡ್ ದಿ ಇನ್ಫಾರ್ಮೇಶನ್ ಇವೆಂಟ್ ಅಲಾಂಗ್ ವಿತ್ 2
ಇನ್ಫಾರ್ಮೇಶನ್ ಬಂತು
ದಟ್ ಒಂದ್ ಮನೆಯಲ್ಲಿ ಒಂದು ಇಲ್ಲಿಗಲ್ ಆಗಿ ಲಿಕ್ಕರ್ ನ ಸ್ಟಾಕ್ ಮಾಡಿ ದೇ ಆರ್ ಸೆಲ್ಲಿಂಗ್ ಇಟ್ ಔಟ್ ಅಂತ, ಅವ್ರ ಮೇಲೆ ಬೇಕಾದಷ್ಟು ಕೇಸ್ಗಳು ಇದೆ ಅಂತ ಹೇಳಿ, ದಟ್ ವಾಸ್ ದಿ ಚಾರ್ಜ್ ಮೈ ಲಾರ್ಡ್. ಅಂಡ್ those points were not considered at all, your lordship, and one charge, based on one charge, your lordship, from the post of excise inspector, my lord, he was reverted back to 2nd division.
ಯಾವ ಚಾರ್ಜ್?
First division clerk, your lordship.
ಯಾವ ಚಾರ್ಜ್?
First division, that is without uniform.
ಬಟ್ ರೇಡ್ ಮಾಡಿದ್ದೆಲ್ಲ ಸರಿ ಇದೆ ಅಂತ ಹೊರಡು ಮಾಡಿದ್ರ?
ಇಲ್ಲಿ ಅವರು ಅಷ್ಟೇ ಹೇಳುದು, ಅಲ್ಲಿ the complainant, who is the complaint, Gauramma, she has not appeared before the inquiry officer itself, your lordship, and witnesses with whom the excise inspector went to the spot, my lord, they were also not examined, your lordship.
ಅಲ್ಲ ಇರ್ಲಿ,
Yes.
ನೀವು ರೇಡ್ ಮಾಡಿದ್ದು ಸರಿ ಇದೆ ಅಥವಾ ತಪ್ಪಿದೆ ಅನ್ನೋ ಬಗ್ಗೆ ಏನಾರ ಹೇಳಿದಾರ?
ಅದ್ರ ಬಗ್ಗೆ ಏನು ಹೇಳುದಿಲ್ಲ. ಓನ್ಲಿ ದೇ ಸೇ ದಟ್ ಮೂಮೆಂಟ್ ರಿಜಿಸ್ಟರ್ ಬರ್ದಿಲ್ಲ, ಯೂನಿಫಾರ್ಮ್ ಹಾಕೊಂಡು ಹೋಗಿರ್ಲಿಲ್ಲ, ವಿಚ್ ವುಡ್ ಹಾವ್ ಬೀನ್ ಇನ್ಫಾರ್ಮ್ಡ್. ಆಗ ಅಲ್ಲಿ ಏನೇನು ನಡೀತು ಅಂತ ಬರಿಬೇಕಾಗಿತ್ತು ಅಂತ, ದಟ್ ಇಸ್ ದಿ ಸರ್ಚ್ ವಾರೆಂಟ್ ಅಂತ. ಸರ್ಚ್ ವಾರೆಂಟ್ ಇಲ್ಲದೆ
ಅಲ್ಲ, ನಾಟ್ ಓನ್ಲಿ ದಟ್, ಯು were not accompanied by a woman ಕಾನ್ಸ್ಟೇಬಲ್ ಅನ್ನೋದು ಒಂದಿದೆ ಅನ್ನೋದು.
ದಟ್ಸ್ ಕರೆಕ್ಟ್.
ಹೌದು, ಮತ್ತೆ
that two houses, one house, my lord, which was raided, your lordship, with 2 panchayats, my lord. 2 panchayats were also not examined, your lordship, and
which rule requires that he should be accompanied by a lady? Which rule that?
under the CCA rules, my lord,
ತೋರಿಸಿ,
it is not there, your lordship.
read ನಮಗೆ ಲಾ ಮೇಲೆ ಹೇಳಿ ಮೊದಲು. ವಾಟ್ ಈಸ್ ದ ಲಾ? ಲೆಟ್ ಅಸ್ ಸಿ ದಟ್. ವಿಚ್ ಲಾ ಸೇಸ್ whenever a male employee goes for raid, he should wear uniform, we can understand. He has to perhaps. But he should be accompanied by a lady constable ಅಂತ ಯಾವ ಲಾದಲ್ಲಿದೆ ತೋರಿಸಿ. Warrant is a must. Which is, which requires warrant, which is that section? One more question ಅಷ್ಟೇ. ಬಡಿ, ಹೇಳಿ section ತೋರಿಸಿ. No raid without a warrant. Show that. ಓದಿ. All right, pass over, please. ಮೂರು ತೋರಿಸ್ಬೇಕು. ಒಂದು, he has power to raid or not. Number two, whether that power has to be exercised only after obtaining warrant. Number three, whether there are any exceptions to the requirement of warrant. Suppose warrant ತಗೊಂಡು ಮಾಡಿ ಹೋಗೋದ್ರಲ್ಲಿ ಮಾಲ್ ತಗೊಂಡು ಹೋಗಿಬಿಡ್ತಾರೆ. Therefore, there will be exceptions. At least there are two judgments of the apex court. Okay, ಅದನ್ನೆಲ್ಲ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. You also
I will
look into and come back. Next week ಹಾಕೋಣ. Against lady in the place. But that she did not come forward.
That is not proved, my lord. In the
That's
inquiry.
held to be not proved.
Not proved, and she did not come at all, my lord. And when they went to the home, they are also they were not available because she is not a resident of that area. She had an house, my lord, in that area, but she is not living, she is residing in some other village. And carries on the business, my lord, in a.
Anyway, that finding is in your favor.
Yes, your lord.
Which section gives you power to raid?
Yes.
ಅಂತ ತೋರಿಸ್ಬೇಕಲ್ಲ.
Yes, sir.
How that section is interpreted
That
by
I will-
courts.
Yes, sir. Yes, sir.
ತಿಳ್ಕೊಂಬರ್ಬೇಕು.
Yes.
Call next week.
There is a reversion order, your lordship. Possible, my lord, a remitted interim order may be granted, your lordship.
Interim order to continue.
No, there is no interim order.
No interim order.
No interim, first time matter is coming up.
ಈಗ ರಿವರ್ಷನ್ ಮಾಡಿಲ್ವಾ ಅವರು?
Reversion ಮಾಡಿದ್ದಾರೆ, ಇನ್ನು ನಮ್ಗೆ ಆರ್ಡರ್ ಕೊಟ್ಟಿಲ್ಲ. Report.
Till then you don't effect the reversion. It's a
Limited
very-
fine.
Not question of money or other things. That will be very, very defamatory to them in the event they, yeah. ಅದಕ್ಕೆ ನೀವು ಕರೆಕ್ಟ್, ಬಟ್ ಫಾರ್ ದಟ್ ಲೀಗಲ್ ಸಪೋರ್ಟ್ ಬೇಕಲ್ಲ, ನಿಮ್ದು ಬೇರೆ ವಾದ, ಅದರಲ್ಲಿ ಸಪೋರ್ಟ್ ತೋರಿಸ್ಬೇಕು. ಇಂಥ ಸೆಕ್ಷನ್ ಅಲ್ಲಿ ಹಿಂಗಿದೆ ಇದೆ. But Supreme Court has recognized in two decisions that the requirement of warrant is dispensable in provided ABCD. That's not correct. Till then, you don't give effect to the reversion order. But learned AGA is requested to accept again. Till next date of hearing, the reversion order, if any, passed by way of punishment, shall not be given effect to all.
Rightfully.
Call after 2 weeks.
Please.
This one. Unless it is already effected. Okay.
ಅಂದ್ಬಿಟ್ಟು ಓಲ್ಡ್ ಡೇಟ್ ಹಾಕ್ಬಿಟ್ಟು ಕೊಟ್ಬಿಟ್ರು ಅಷ್ಟೇ ಸಾಕು.
ಚೇಂಜ್ ಆಗಲ್ಲ, ಚಾರ್ಜ್ ಕೊಡೋದಿರ್ತದೆ.
Please, your lord. Gratefully.
My lordship, in serial number 18, my lordship.
18.
18, I appear for respondent number 1 and 2 in this matter for KPSC, my lords. Lords,
You
I'm-
don't appear to be well.
Please, my lords, I'm not keeping well. my lords.
Praying for
It is
a
not
week's
well.
time. Please, ma'am.
On health ground. Of the arguing counsel appearing for the respondent matter is adjourned by 2 weeks. Okay, next.
Please, my lord.
Entry matter ಇದೆಯಾ?
No, says interim.
No entry matter.
No interim.
Then we will have it in the second, third week of January.
My lords, there is urgency because she has still not been appointed, my lord, to the post, my lord. The examinations are conducted.
Next.
Obliged.
Please.
19, my lord.
Yeah.
I have already filed memo of appearance. My name is not shown.
You appear for
Please,
one.
please, two, my lord. Earlier Manjula D was appearing, but I have filed memo for
Three.
appearing. K. Prasanna Shetty.
Please, yes. For respondent,
Number two.
two. Manjula's name,
Maybe
To be
deleted.
deleted.
my lord. She's not in the panel.
name of Srimati Manjula to be deleted.
Please, I'll file my objection, my lord.
Huh?
There's no interim order. I'll file my objection, my lord.
Interim order ಇಲ್ಲ.
ಇಲ್ಲ.
Call after 2 weeks at the request of arguing counsel for respondent.
Date may be.
For the 2023 matter.
Please.
Yes. Three weeks. Call after 3 weeks to enable counsel for the petitioner to come and argue. Next. Ravi, same order. Misha.
Pending correspondence.
Suit for defendant's appeal.
Admission after 9 years.
The matter,
Supreme Court. Sorry, judges ಕೆಲಸನ ಮಾಡಲ್ಲ.
suit for recovery of the money. The suit claim is
Money suit.
3 crores 56 lakhs.
You are
I am for the defendant appellant.
suit decreed.
Suit decreed.
Decree put in challenge.
And plus interest also added.
Huh?
Already there was an interest at 18% granted.
But tell foundational facts.
Please, the society, the plaintiff society, Lord,
Ah,
he is dealing with the Araconite, sale of the Araconites, Lord. The defendant appellant, the transaction is between 1499 to
including interest. Cooperative society. Plaintiff is a cooperative society.
no, plaintiff is a cooperative society.
You are not a member of society.
I am a member of the society.
You are.
I am a member of the society.
Then why it went for suit?
It's not, he's not a
He's
member.
not a member of
He's not a
society.
member. of-
The court holds that the dispute, the suit filed is in accordance with law and not barred under the APMC Act or under the Societies Act. That is the finding given. That is on issue number 1 and 2.
Where are the issues?
Issues, Lord. But your lordship will find
Come to page 23.
22. The first and 2 issues, that is with regard to the plaintiff society. is
So
registered or
that
not,
first issue perhaps may not figure it out.
may not be necessary for
May
the
not
time.
miss it out. Number one, over.
And one
Plaintiff
issue,
to
third
society
issue is the
to
issue,
plaintiff.
madam. Whether the plaintiff through the defendant purchased 3,680 bags of Supari in the public auction held from 1/1/1999 till 16/3/2000, out of which the defendant has taken delivery of 1,728 bags of Supari by leaving the
Balance
balance of
1952
1,952 bags in the godown of the plaintiff.
The
So
auction took
this is the
place.
dispute, this is the dispute. So 1,952 bags that was given back again after reprocessing by the defendant appellant, my lord.
You give back to,
We get back to the society.
where is that evidence?
It was stored there only.
Please, my lord.
It was stored there only. You
It was
didn't
reprocessed again. There is an agreement entered.
lift it.
No,
That is what
there
the
is,
claim says.
Where is the evidence? Let's show that. That's the only case.
that's the,
The thirst. Admit ಮಾಡ್ಕೊಂಡು. Admit ಮಾಡೋ ಅಗತ್ಯನೇ ಇಲ್ಲ. ಅಲ್ಲಿಗೆ ಹೋಗ್ಬಿಟ್ಟು. We need not admit every appeal. Prima facie, let him show. Show your evidence.
the payment of 99 lakhs is not in dispute.
Huh?
Payment of in respect of
That's all right.
1,000
That is not, it's
1,124
only
lakhs
differential.
is not dispute.
Correct.
So out of that, that has to be deducted. 99 lakhs has to be deducted. That is paid. The
Huh?
remaining bags that was unlifted, that was remaining with the defendant, with the plaintiff.
You have said that. Now show you from your evidence. Read your evidence. That's the only case. ಇವೆಲ್ಲ RFA ಏನ್ ದೊಡ್ಡ ದೊಡ್ಡ ಇರಲ್ಲ. ನಾವೇನೋ ಭಾಳ ಇರ್ತದೆ ಅಂತ ತಿಳ್ಕೊಂಡಿವಿ ಅಂತ ಅದೇನಿರೋದಿಲ್ಲ.
ಅಲ್ಲ ಅವರು
ತೋರಿಸಿ ನಮ್ಗೆ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ relied upon their own accounts. The transaction which was exhibit P 95, 96, 97. That is on internal page 16 of the impugned judgment.
That you have put in challenge, na?
That is under challenge now.
That the challenge is sustain ಮಾಡ್ಲಿಕ್ಕೆ this finding could not have been entered pursuant to particular issue. That's the only point.
That's one submission.
So your evidence, read your evidence, your deposition. What is your deposition? Because you admit the delivery.
Delivery of.
Then I'll tell you, after reprocessing, you have given it back. Therefore, that amounts to admission under section 58 of the Evidence Act.
What they have done is, after return of the money, they took 645 days to resell over a period of 645 days. They sold it from the date of the transaction. Transaction is between 1/4/99 to 16/3/2000.
ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ರೀಡ್ ಮಾಡಲ್ವಾ ನೀವು?
Evidence.
ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ರೀಡ್ ಮಾಡ್ಬೇಕು. ಅಪೀಲ್ ಇದೆ, ರೆಗ್ಯುಲರ್ ಅಪೀಲ್, both on law and facts, because it is first appeal. ನಿಮ್ಮ ಎವಿಡೆನ್ಸ್ ತೋರಿಸಿ.
ಒಂದೇ one more submission, right? That what is the shown as principal is 1 crore 91 lakhs they have shown.
1 crore
91 lakhs.
This
is already interest added to that.
So interest ಆಗ್ತಿರ್ಲಿಲ್ಲ ಅಂತ.
The amount of rupees, the total transaction, according to the plaintiff, 3 crores 47 lakhs 50,194 million. Out of that, 99 lakhs paid. That comes to around 2 lakhs, 2 crores 48 lakhs and odd money. Thus, they again recovered out of that. That comes to around 99 lakhs again. They have recovered.
ಯಾವ್ದದು?
So total transaction, right? According to the
ನಿಮ್ಮ WS ನಲ್ಲಿ ಆ contention ಎಲ್ಲಿ ತಗೊಂಡ್ರಿ?
WS.
Show that contention in your WS and how you have substantiated that contention. Read from the WS. They say interest on interest is not permissible.
No, my lords, it is not, it is not.
Just to justify that, I'll say 3 crores 47, according to the plaintiff, 3 crores 47 lakhs.
ಆಯ್ತು ಸಬ್ಸ ನೋಡ್ಕೊಂಡು ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ.
50,000
ನೋಡ್ಕೊಂಡು ಬನ್ನಿ.
Please.
ಇದು ಮಾಡಬಾರ್ದು. RFA. But you have advantage of an appeal being both on law and facts. Take maximum
similar,
utilization of that.
another appeal this is filed by the wife. Another appeal filed by the husband, that is admitted, that is RFA number 1042 of 2015. On the similar facts.
I don't have any instructions with the data.
Maybe.
Same party.
The defendant is same.
Defendant
is same. Society is same. RFA 1042 of 2015.
ಅದು ಇನ್ನೊಂದು
ಇನ್ನೊಂದು same similar set of facts. Similar set of facts.
RFA ಗಳನ್ನು ಹಂಗೆ ಟ್ರೀಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಹಾಗಲ್ಲ, similar set of facts. Similar set of facts. I will come with the
respondent society is the same.
Same ಇದ್ರೂ ಬರಲ್ಲ. ಟ್ರಾನ್ಸಾಕ್ಷನ್ಸ್ ಬೇರೆ ಇರ್ತದೆ, ಎವಿಡೆನ್ಸ್ ಬೇರೆ, ಇಶ್ಯೂಸ್ ಬೇರೆ ಇರ್ತದೆ. ಅದು ಬಹಳ ಡಿಫರೆಂಟ್ ಇರ್ತದೆ.
Could I come at 2:30?
All.
May I request for next week, my lords?
Auction will be held on 11th, my lord. Auction will be held on 11th. That is the urgency.
2015 ಇಂದ ಯಾವ urgency ಇರ್ಲಿಲ್ಲ.
Correct ಅಲ್ಲ, ಇವಾಗ auction ಆಗ್ತಾ ಇದೆ. Auction ಆಗ್ತಾ ಇದೆ. Same, what I submit to your lordship is, very same property may be taken as security. The property that is offered worth about 7 crores.
230 argue ಮಾಡಿ.
7 crores.
ಬೇರೆ ಯಾವ್ದಿದೆ? 230 ಬೇರೆ ಇದೆ ನಮ್ಗೆ? ಯಾವ್ದಿಲ್ಲ. ಇದು ಒಂದೇನಾ? ಇನ್ನು ಮ್ಯಾಟ್ರಸ್ ಇದೆ. ಅಲ್ಲೇ ಕರೀರಿ. ಪೇಷಂಟ್ ಕೊಡೋಲ್ಲ, ಮರ್ತಿ ಬಿಟ್ಟು. ಪಾಸ್ ಓವರ್. ಯಾರು? 2015 pass over. After 2:30. ಯಾವ್ದು?
Serial 24,
Huh?
serial number 24
ಹಾ.
is covered by judgment of your lordship, it is sitting in Dharwad. Lokayukt has filed a enforcement order was quashed and remanded to the government. Lokayukt has passed the
ಧಾರವಾಡ ಬೆಂಚ್
Dharwad bench along with Justice Judge.
ಅದ್ರ ಮೇಲೆ ಅಪೀಲ್ SLP ಏನು ಆಗ್ಲಿಲ್ಲನು?
I am appealing for the petitioner that appeal ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ.
Don't today,
Next week ಹಾಕೋಣ.
please, next week it may be.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಡ್ತಾರೆ. ಯಾವ್ದಾದ್ರು ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಬಹಳ ಒಂದೇ ದಿವಸ ಕ್ಲಸ್ಟರಿಂಗ್ ಆಗ್ಬಾರ್ದಾ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಆ ರೀತಿ ಹಂಗೆ ಡೇಟ್ ಕೊಡ್ತಾ ಇಲ್ಲ ನಾವು.
But serial number 34, my lord.
34.
I'm for the petitioner, my lord. I mean, I'm the proxy counsel. The counsel appearing for the petitioner is little inconvenience.
You want time?
Yes, lord. Next date, next week.
ಯಾವ್ದು? ಟೋಟಲ್ ಮೂಡ್ 2014 ಮ್ಯಾಟರ್ ಬ್ರದರ್. ನಾನು 2014 ನಾವು ಓದ್ ಬಂದ್ಬಿಟ್ಟೇವೆ. 28 ಏನು?
Serial number 38, myself and Mr. Prakash's matter, 33.
33
May kindly be taken up after 10 days.
after vacation ತೋಣ.
Any, after vacation? No. We've had too many vacations, my lord. Too many vacations. But 20.
They are working.
20.
Both are working.
They've all been given assignments.
Yes, they have given.
They've given us assignments now.
Subject to order of this, they have
So
given.
it can come up anytime after 25th or any date.
They have already reported to duty person.
ಅಲ್ಲ they are all working now.
They are working now.
ಬಿಡಿ,
Yes.
ಏನ್ ಜುಡಿಷಿಯಲ್
Anytime.
in the third week of January 2025. 28.
WP 24944 of 23.
28. Connected met. Call along with WP number.
Obliged.
Call.
ಹೌದು.
ಮಧ್ಯಾಹ್ನ ಸಿಟ್ಟಿಂಗ್ ಇದೆಲ್ಲ?
Serial number 30 afternoon.
ಇದೆ.
Sir, 26, Raghvendra. ಯಾವ್ದು serial number?
ಏನೋ ಇವ್ರು ಕರ್ಕೊಂಬಂದ್ರಿ, ಏನೋ ಮಾಡೋ.
ರಾಘವೇಂದ್ರ, 26 ಸೆಜನ್ ಆಗಿದೆ. ಬೆಳಿಗ್ಗೆ 26 ಸೆಜನ್ ಆಗಿದೆ. ವಿ ಗ್ರೂಪ್.
ಭಯ ಹೆಂಗೆ ಭಯ ಇದು?
ಅಲ್ಲಲ್ಲ, ಅದು ಎಕ್ಸಾಮ್ ಆಗಿದೆ.
ಅದಲ್ಲ ಸರ್,
ಅದೇ.
ಸತೀಶ್ ಇದ್ರಲ್ಲ.
1 to 3 onwards is the entire charge defense brief that
Where
is
have you
extracted.
taken pinpoint?
My lord, it is said at, kindly see page 124, second paragraph. And also the second paragraph, I may be permitted to read it.
Sentence ಓದಿರಿ ಸಾಕು. Vague ಅನ್ನೋ ಶಬ್ದ ತೋರಿಸಿ. And therefore I am disabled from replying to that. Show that. ನಾವೇ ನಿಮ್ಗೆ ಎಂಟರ್ ರಿಟ್ jurisdiction ಇದೆ. ಅದು RFA ಅಲ್ಲ. Therefore, show that vague and
Madam,
disabled because of vagueness, not in a position to take up a proper
My
stand.
lord, my lord, I'll clarify, my lord. The charge of vagueness was taken up in the application before the tribunal.
Very in your reply ತಗೋಬೇಕು.
In defense brief, my lord, she has stated witnesses.
ತಗೊಳ್ಳೋದು.
In defense brief, witness, she has stated in her defense brief that.
Have you taken up that stand in your reply?
Defense
If you
brief.
send reply.
Defense brief, no,
to the
ma'am.
show cause notice. Is it not?
That she has not submitted.
ಹಂಗಾಗಿ you have understood ಅಂತ ಅರ್ಥ.
True, my lord. That-
Vagueness ಇಲ್ಲ ಅಂತ.
My lord, all that is said is, in the reply, they have said it is, she has admitted that she has denied all the charges and she
fine.
sought for documents.
Deny ಮಾಡಿದ್ದು brother, we should be little legalistic. ಏನು vagueness of charge ನಮ್ಗೆ ನಿಮ್ಗೆ ವೇಗ ಆಗ್ಬೋದು. But if she has understood.
Please.
ಅದಕ್ಕೆ
In page 91, in reply, what is the extracted in the reply is only this, my lord. Mrs. Ramani Krishnan so-and-so has completely denied all the 3 articles of charges right from the beginning, page 91.
So she has understood. Otherwise she would not have denied. Yes.
Please, my lord. Now kindly see, my lord, the charge.
Yes.
Thereafter, my lord, a report was framed. The contention of the petitioner is the report, the documents, the inquiry conducted is not in accordance with the CCS rules. My lord, is one of the contention taken, which is also taken absorbed in the defense brief. The documents admittedly, the department admit the documents sought for her to reply along with the charge memo could not be given for her for 1 long month. Therefore, she could not give reply at all for this aspect, which is admitted by the authorities.
You know? No.
Along with the charge memo.
One second. Your first contention is, what is your articulate?
My lord, the documents listed along with the charge memo was not provided to her.
Prakama. The first contention of the petitioner is that the document on which charges were sought to be established against her were not furnished.
While seeking reply to the same, while seeking reply to the charge memo.
While sending reply to the charge memo. Where did you ask for documents?
My lord, if I lord permit, page 62. In fact, authorities admit it. Page 62.
62.
Please.
Where have you said? ಎಲ್ಲಿದೆ?
My lord, the case has not been the whole taking tentative visit.
ನನಗೆ ನೀವು ಚಾರ್ಜ್ ಮೆಮೊದಲ್ಲಿ ಇಂತಿಂತ ಡಾಕ್ಯುಮೆಂಟ್ ಮೇಲೆ ರಿಲೈ ಆಗ್ತಾ ಇದ್ದೀರಿ, ಅದ್ರ ಕಾಪಿ ನಮಗೆ ಕೊಡಬೇಕು. ದಿಸ್ ಇಸ್ ಹೌ ಕಾಶಿನಾಥ ದೀಕ್ಷಿತಲು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಸೆಡ್ ಲೈಕ್ ದಿಸ್, ಗಿವ್ ಅಸ್ ಅಂತ ಎಲ್ಲಿದೆ ತೋರಿಸಿ.
My lord, what I have asked is that documents enlisted along with the charge memo is not furnished to me, which they
ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ?
ನಾನು ಹೇಳಿದ್ದಲ್ಲ ಸ್ವಾಮಿ, ಇದ್ರಲ್ಲಿ ಅವರೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. He has admitted it. Kindly see the appellate authorities order, my lord.
ಅದನ್ನೆಲ್ಲ ನೋಡಲ್ಲ. ರಿಪ್ಲೈ ಕೊಡ್ಲಿಕ್ಕೆ ಇಂತಿಂತ ಡಾಕ್ಯುಮೆಂಟ್ ಬೇಕಾಗ್ತದೆ, ಆ ಕಾಪೀಸ್ ಕೊಡಿ, ಅದಾದ್ಮೇಲೆ ಕೊಡ್ತೀನಿ, ಇಲ್ಲರೂ ಕೊಡಲ್ಲ. ಫಸ್ಟ್ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಇದ್ದ ಬಿಲ್ಡಿಂಗ್ ಪಾಯಿಂಟ್.
ಶೋಕಾಸ್ ನೋಟಿಸ್ ಅಲ್ಲ, ಚಾರ್ಜ್ ಮೆಮೊಗೆ ರಿಪ್ಲೈ ಕೊಡುವಾಗ the documents listed along with the charge memo.
So that you are only repeating. Repetition we don't allow, it's a violence.
Documents enclosed with the charge memo, my lord.
ನಿಮ್ಮ ರಿಪ್ಲೈ ಎಲ್ಲಿದೆ?
ಅದರ ರೆಫರ್ ಮಾಡಿದ್ದನ್ನು ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ ಅವರು.
Swami, reply copy, you ಕೊಟ್ಟಿದ್ reply copy ಇಲ್ಲ. I fairly submitted in the initial stage. That reply is not there, but that is not disputed fact. It is, they have admitted.
To their documents. All right, your first contention is non-supply of documents, material documents. Where have you taken up that contention? In your reply.
Reply, petition. They furnished it after a month, my lord. At the time of giving.
Repeats unnecessarily his answer, which again is irrelevant to the question as to where such a contention was taken up in his reply, in her reply to the show cause notice. Okay. Next point. Go to the next point.
My lord, after,
Number one. Number two, how you have been put to prejudice because these documents were not supplied. Please, where have you taken up that contention?
my lord, those documents contain
Things are necessary. Please.
one non,
Supply of documents. I demanded, give us the copies so that I will read them. I will structure my reply to your show cause notice. Number one, that you have failed to establish. The second one, at least non-supply of this document has prejudiced my case because I would have taken XYZ contention, which would have come to my defense. Where is that contention?
my lord, petitioner in her reply have not taken that contention. It is in the application, appeal, application, my lord, reply to show cause notice, and also in appeal preferred, and also in the application preferred CAT, it is there, my lord, consistently all the places.
In your reply, it is not there.
No, my lord.
Counsel for the petitioner fairly concedes that in the reply sent to the show cause notice, comma, no such request was made for supply of documents.
My lord, what I
Next.
submitted.
However,
it was
the
submitted,
contention is taken up in before the KT.
my lord, it is taken in the defense brief. My
In
lord,
the
my lord, let
defense-
me clarify one aspect, my lord. It is not that as if they never gave, they gave it after 1 month. For 1 month, they asked me to reply without giving document. Therefore, I had to briefly say I deny the charges. They gave these documents after 1 month, which is admitted fact. They have not disputed it. That's all I'm submitting.
No, that makes no sense.
No, my lord. Then question of how did these documents prejudice? What I'm submitting is, my lord. this-
Next, please. Counsel now says that these copies of documents were supplied to his client on which date?
Lord, the date is not there. They have admitted after 1 month. Appellate authority has admitted 1 month, my lord. That is not disputed.
1 month after. 1 month after?
After she gave reply to the charge memo.
After the reply was sent to the charge memo. Adellide?
It is admitted,
ಇದಂತ ತೋರ್ಸಿ.
it is admitted by them in the appellate authority. When this was contention in the appeal, they have admitted that in the appellate authority's order, my lord. Annexure A1 in the application, my lord, at page number
A1.
A1, my lord. It is at. Kindly see, my lord, page number 56. It commences with page number 56. At paragraph number 5, my lord.
Para 5.
Page 57, my lord. Para 5. The memorandum of charges.
One second. Where is that? Para?
Para 5 of page 57. A memorandum of charge dated 1/8/12 was not accompanied by the list of documents by which the articles of charge are proposed to be sustained as required under rule so and so. This non-compliance of the procedure has resulted in failure of justice as she was denied the opportunity of defending himself against the
This
charge.
is what? This is appeal. Yenidu.
Yes, my lord. Appellate authority's order, my lord. When I
In the appeal, you took up that contention.
right from the defense brief and appeal also, this was the contention taken, my lord. But reply.
One second, ನಿಧಾನವಾಗಿ. Defense plea ಎಲ್ಲಿದೆ?
Appeal ಅಲ್ಲಿ ಇದೆ sir. Defense ಅಲ್ಲಿ ಇದೆ, defense ಅಲ್ಲಿ ಇದೆ. I'm sorry, my lord. Defense ಅಲ್ಲಿ ಈ documents ಇಲ್ಲ, appeal ಅಲ್ಲಿ ಇದೆ. Defense ಅಲ್ಲಿ she only denied about CD. CD is also one of the document, but not the entire document with length. This is in appeal, my lord.
All right, don't confuse us.
So far as one of the
Okay.
documents CD is concerned, it is taken in defense brief also. my lord.
Counsel admits. ಅಲ್ಲೇ ಡಿಫೆನ್ಸ್ ನಲ್ಲೂ ನೀವು ತಗೊಂಡಿಲ್ಲ ಎಲ್ಲ ಕಾಪೀಸ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ನೀವು ಇದರಿಂದ ನಮ್ಗೆ ತೊಂದರೆ ಆಗಿದೆ ಅಂತ ಎಲ್ಲಾದ್ರೂ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಇದೆಯಾ?
ಅದೇ ಸ್ವಾಮಿ, ನಾನು ಇಫ್ ಐ ಕ್ಲಾರಿಫೈ, ಇದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ 1 month ಆದ್ಮೇಲೆ ಕೊಟ್ಟರು, ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ
ಓದಿ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್
Kindly see page 124, my lord.
124,
my lord.
24.
My lord, the sting operation, last 4 lines, my lord, are crucial. A keen look on the CD. He did not have the authority. It was last 1, 2, 3, 4, 6 line, my lord. It ends with in random. A keen look of the CD showing the sting operation extending to give the matter to Ramani Krishnan, it is not clearly exhibited. The person who has given the money to Ramani Krishnan, Raju Patil in the cross-examination has confessed that one camera was used and so his face was not appearing. The main charge is that Ramani Krishnan demanded and accepted money for the settlement of PF claim from Sridhar Kumbar. If it is so, what is the role of Sri so-and-so is a mockery. Sridhar Kumbar did not give any money. Approps the reply forwarded. He had nothing. He said, owing to technical reason, it was done. It was allegations. They have admitted this. This CD was given in the 8th hearing. Document was given after 1 month. CD was.
ಅದೆಲ್ಲಿದೆ ಅಂತ
Yeah, Swami.
ಡಾಕ್ಯುಮೆಂಟ್ ವಾಸ್ ಗಿವನ್ ಆಫ್ಟರ್ 1 month ಅಂತಿದ್ದಿದ್ದು
ಅದೇ appellate authority order.
ಇದರಲ್ಲಿ ವಾಟ್ ಯು ವಾಂಟ್ ಟು ಡಿರೈವ್ ಫ್ರಮ್ ದಿಸ್?
My lord asked me a question. Have you taken this contention in defense brief? And the reply ಅಲ್ಲಿ ನೀವು ಹೇಳಿಲ್ಲ ಅಂದ್ರಿ. ಹೌದು I admitted I have not said so because document but they gave it later. Why I have said this about only one document? CD also becomes one of the document, my lord. They insert it at the 8th hearing after examining several witnesses. Out of 7 witnesses, 5 witnesses were examined. Then they get CD also without giving a copy to me. That aspect is taken here for me to say one of the document is not given. My lord,
Did you ask for a CD?
my lord, that is one of the document which they introduced at a very last stage.
No, we are asking.
True, my lord. Yes, I asked for CD.
You asked for CD.
They have not given me a copy, my lord. They say we.
Why are you confused?
I asked, my lord, I asked for CD.
ಅದೆಲ್ಲಿದೆ ಅಂತ?
ಅದು writing ಅಲ್ಲಿ ಇಲ್ಲಿ ಅವರು my lord, it was introduced during the proceeding of ongoing inquiry. They said we are introducing CD.
ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲಿದೆ ಅವರು ಕೋಟ್ ಮಾಡಿದ್ದು?
Charge memo, along with charge memo, my lord.
ತೋರಿಸಿ.
Kindly see, my lord, page number 80.
80.
There is no CD in the charge memo. Page 80, these are the list of documents. Documents goes up to 22 in number. In either anywhere in 22 documents, CD is not a document at all.
Yes, CD is not enlisted here.
CD was subsequently during the course of the evidence, it has been produced by the TV person who is the sting operation, they have done it. my lord.
ಅವ್ರಿಗೆ ಮತ್ತೆ ಕಾಪಿ
ಆ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡುವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಇದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 104 ಅಲ್ಲಿ ಮಾರ್ಕ್ ಆದಾಗ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಇಟ್ ಹಸ್ ಬಿನ್ ಗಿವನ್ ಆಪರ್ಚುನಿಟಿ ಫಾರ್ ಹರ್ ಟು ಪೇಜ್ ನಂಬರ್ 104 ಸೀರಿಯಲ್ ನಂಬರ್ 22 ಮೈ ಲಾರ್ಡ್.
104.
104 ಅಲ್ಲಿ ಮಾರ್ಕ್ ಆಗಿದೆ ಎಕ್ಸಿಬಿಟ್ P23
ಮಾರ್ಕ್ ಆಗಿದೆ. ಅವ್ರು
ಕೊಟ್ಟಿದ್ವಿ ಸಮತೆ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಅದೆಲ್ಲಿದೆ ಅಂತ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ನೀವು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಕ್ಕಾಗ್ತದೆ. ನಾನು ನಿಮ್ಮನ್ನ ವಿಟ್ನೆಸ್ಸಿಗೆ ಹಾಕ್ಬೇಕಾಗ್ತದೆ. ಯು ಆರ್ ಎ ಲಾಯರ್. ದೇರ್ಫೋರ್ ವೇರ್ ಹ್ಯಾವ್ ನಿಮ್ ಕ್ಲೈಂಟ್ ಕೇಸನ್ನು ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕು ನೀವು.
ಹೌದು.
ನೀವು ಅವ್ರ ಶೂಸ್ ನಲ್ಲಿ ನಿಂತ್ಕೊಂಡಾಗ ಇದೆಲ್ಲ ಸಮಸ್ಯೆ ಆಗುತ್ತೆ. ಅವ್ರು ಮಾಡಿದಂಗೆ ನೀವು ಮಾಡ್ತಾ ಇದ್ದೀರಿ. ವೇರ್ ಹ್ಯಾವ್ ಯು ಸ್ಟೇಟೆಡ್ copies of these documents are furnished to delinquent official? Where is that? ಅದು ಉಳಿದಂತ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬಿಡಿ. ಉಳಿದಂತ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ that contention perhaps we are not agreeing. But CD is a very important document.
ಇದು ಬ್ರೀಫ್ ಬ್ಯಾಕ್ಗ್ರೌಂಡ್ ಆಫ್ ದಿಸ್ ಕೇಸ್
As is based.
ಬ್ಯಾಕ್ಗ್ರೌಂಡ್ ಆಫ್
On CD interview and only.
CD only.
He has not enlisted you.
yes background of this case is she was working as a departmental person in senior assistance, my lord. When she is the person who is giving approval for the PF ತಗೊಳ್ಳಿಕ್ಕೆ ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡೋ ಅಥಾರಿಟಿ.
ಆಯ್ತು, ಅದನ್ನೆಲ್ಲ ಮಾಡ್ಲಿಕ್ಕೆ ದುಡ್ಡು ತೋತಿದ್ರು ಅನ್ನೋದು ನಿಮ್ ಕೇಸ್ ಸ್ಟಿಂಗ್ ಆಪರೇಷನ್ ಆಗಿದೆ.
ಸ್ಟಿಂಗ್ ಆಪರೇಷನ್
CD ಅನ್ನು ಎನ್ಲಿಸ್ಟೇ ಮಾಡಿಲ್ಲ. ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅನ್ನು ನೀವು ಕೊಡ್ಬೇಕಾ? ನೋಡಪ್ಪ, ನಿನ್ ಮೇಲೆ ಇರೋ ಚಾರ್ಜ್ ಅನ್ನು ಪ್ರೂವ್ ಮಾಡ್ಲಿಕ್ಕೆ ABCDEFG
ಅದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ
ಲಯಪನ್ ಮಾಡ್ತೀವಿ, ಹೌದಾ? ಆ ಕಾಪೀಸ್ ಅನ್ನು ಕೊಟ್ಟಿಲ್ಲ ಅನ್ನೋದು ಅವ್ರ ಕಂಟೆನ್ಷನ್. ನಾವು ಅದನ್ನ ಒಪ್ಪಿಕೋಬೇಡ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ. ಎನಿವೇ ವಿಲ್ ನಾಟ್ ಸೇ ಮೋರ್ ದೆನ್ ದಟ್. ಬಟ್ ಹಿ ಇಸ್ ಪಾಯಿಂಟಿಂಗ್ ಔಟ್ an unenlisted document, though you are entitled to produce unenlisted documents also, provided copy thereof is given to the delinquent official. Nim whole jugular vein of the case ಏನು ಅಂದ್ರೆ
Yes.
ಆ TV9 ದ ಸ್ಟಿಂಗ್ ಆಪರೇಷನ್.
ಹೌದು ಸರ್.
ಮತ್ತೆ ಆ ಸ್ಟಿಂಗ್ ಆಪರೇಷನ್ ಇದನ್ನ ಎನ್ಲಿಸ್ಟ್ ಮಾಡಿಲ್ಲ ನೀವು ವಿಡಿಯೋನ.
ಸ್ಟಿಂಗ್ ಆಪರೇಷನ್ ಅವ್ರು ಅದು ಡಾಕ್ಯುಮೆಂಟ್ ಮಾರ್ಕ್ ಆಗಿದೆ, ಬಟ್ ಅವ್ರು ಕೊಟ್ಟಿರೋದಕ್ಕೆ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್
ಜಾರಿ ಕೊಟ್ಟಿದ್ದಕ್ಕೆ
ನಮ್ಮ ಚಾರ್ಜ್ ಶೀಟೆಡ್ ಎಂಪ್ಲಾಯ್ ಕೊಟ್ಟು
ಎಲ್ಲಿದೆ?
ಅದಕ್ಕೆ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇಲ್ಲ, ಬಟ್ ಶಿ ಸೇ ದಟ್
ಎಲ್ಲಿದೆ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ?
ಬಟ್ ಇನ್ ಬ್ರೀಫ್ ಆಕ್ಟ್ ಇದರಲ್ಲಿ ಹೇಳ್ತಾರೆ 92 ಪೇಜ್ ನಂಬರ್ 92 ಅಲ್ಲಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇಲ್ಲ. ಇಟ್ ಸೇಸ್ ಇನ್ ದ ಎನ್ಕ್ವೈರಿ ದಟ್ ಚಾರ್ಜ್ ಶೀಟೆಡ್ ಅಫಿಷಿಯಲ್ ಈ ಪೇಜ್ ನಂಬರ್ 92 ಮೈ ಲಾರ್ಡ್.
ಏನ್ ನಿಮ್ ಪ್ರಶ್ನೆ ಏನು?
ಅಲ್ಲ ಪ್ರಶ್ನೆ
ನಮ್ಮ ಪ್ರಶ್ನೆ ಏನು?
ಅದು ಅರ್ಥ ಆಯ್ತು. ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದಾರೋ ಇಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಪ್ರಶ್ನೆ ಅಂತ ಹೇಳಿದ್ದು. ಬಟ್ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ನಂತರ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ. ಬಟ್ ವೈಲ್ ಮೆನ್ಷನಿಂಗ್ ದಿಸ್ ಒನ್, the CO has inspected all original documents, 22 listed as documents, and has not raised any dispute with regard to the authenticity.
ಅದು 1 to 22 ಅದು.
1 to 2.
ಇದು 22 ಅಲ್ಲ.
22 ಸ್ವಾಮಿ.
ಯಾವುದು?
ಇದರಲ್ಲಿ CD is 22 as per page number 104.
ಅದು as per 104 ನೋಡೋದಲ್ಲ. ನಿಮ್ಮ ಚಾರ್ಜ್ ಇದರಲ್ಲಿ ನೋಡಿ ಎಷ್ಟು ಮಾಡಿರಿ?
ಪೇಜ್ ನಂಬರ್
22 ಅದು ನೋಡ್ಬೇಕು.
ಪೇಜ್ ನಂಬರ್ 80 ಅಲ್ಲಿ 22
79 80
22 yes
22
yes.
Copy of the attendance for the month of October 2011
is the last. Yes.
ಅಂದ್ರೆ CD ಎಲ್ಲಿದೆ? CD ಇಲ್ಲ.
ಆಮೇಲೆ she also not raised any.
ಆಮೇಲೆ ಅಲ್ಲ, ಮೊದಲು ಒಂದೊಂದೇ ಪ್ರಶ್ನೆ ಇದೆ. CD ಅನ್ನ ಅವರಿಗೆ ಕೊಟ್ಟಿದ್ದ ಬಗ್ಗೆ ನಿಮ್ಮ ಮತಿಗೆ ಮಟೀರಿಯಲ್ ಇಲ್ಲ, ಕರೆಕ್ಟಾ?
ನೆಕ್ಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸರ್
ಏನಂತ?
she had also not raised any objection when the POI has introduced the VCD containing the video footage telecasted in TV9 channel both in English and Kannada.
Correct. But ಅದು ಡಾಕ್ಯುಮೆಂಟ್ ಅಡ್ಮಿಟ್ ಆದ್ಮೇಲೆ ಅವ್ನಿಗೆ ಕೊಡೋದು ಬೇಡವಾ ಏನಿದೆ ಅಂತ? ನೀವು ಆಲ್ ಆಫ್ ಎ ಸಡನ್ ಬೋರ್ಡ್ ಫ್ರಮ್ ದ ಬ್ಲೂ ಟೈಪ್ ಅದನ್ನ CD ಕೊಟ್ರೆ ಒಂದು ಯು ಓ ಎನ್ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ as to why you did not enlist that CD in the list of documents. That gives a doubt.
Because it has been given by the TV person at the time of evidence. So it has been marked in that.
ಫಸ್ಟ್ ಪ್ರಿಲಿಮಿನರಿ ಎನ್ಕ್ವೈರಿ ಮಾಡ್ಬೇಕಾದ್ರೆ ನೀವು
ನೋಡ್ಕೊಂಡು
ಚಾರ್ಜ್ ಮೆಮೊ ರೆಡಿ ಮಾಡ್ಬೇಕಾದ್ರೆ ಚಾರ್ಜ್ ಮೆಮೊ ಇಸ್ ಲೈಕ್ ಎ ಚಾರ್ಜ್ ಶೀಟ್.
Yes ma'am.
ಇನ್ ಎ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ 207 ಕಂಪ್ಲೈಂಟ್ ಮಾಡ್ದೇನೆ ನಾವು ಟ್ರಯಲ್ ಮಾಡಕ್ ಬರ್ತದಾ?
ಇಲ್ಲ.
ಮತ್ತೆ ನೀವು ನಂತರ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ವಿತ್ ದಿ ಪರ್ಮಿಷನ್ ಆಫ್ ದಿ ಕೋರ್ಟ್ ಯು ಹ್ಯಾವ್ ಟು ಪ್ರೊಡ್ಯೂಸ್. ಇಲ್ಲಿ PO ಪರ್ಮಿಷನ್ ತಗೊಂಡಿದ್ದೀರಾ? ವೆದರ್ ಹಿ ಹ್ಯಾಸ್ ಅಲೋಡ್ ದ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ದಿ ಅಡಿಷನಲ್ ಮಟೀರಿಯಲ್ ಆರ್ ಯು ಜಸ್ಟ್ put it out from your pocket? See, unless the person who is on the defense side, he knows what document, what CD you are producing. How can he object?
Yes, I agree.
ಈಗ CD
ಅದ್ ಏನು ಅಂತಾನೆ ಗೊತ್ತಿಲ್ದೇನೆ
ಬಹಳ ರೌಂಡ್ಸ್ ಮಾಡ್ತದ ಆ ವರ್ಡ್. ಈಗ CD ಅನ್ನುವಂಥದ್ದು ಪೆನ್ ಡ್ರೈವ್ CD. ಈಗ ಇಫ್ ಯು ವಾಂಟ್ ಟು ಬ್ಯಾಂಕ್ ಅಪಾನ್ ಎನಿ ಡಾಕ್ಯುಮೆಂಟ್,
Yes ma'am.
ಯು ಶುಡ್ ಟೆಲ್ ಹಿಮ್, ನೋಡಪ್ಪ ವಿ ಆರ್ ಪ್ರೆಸಿಂಗ್ ಇನ್ ಟು ಸರ್ವಿಸ್ ದಿಸ್ ಡಾಕ್ಯುಮೆಂಟ್. ಇದರಲ್ಲಿ CD ಎಲ್ಲ ನೀನು ದುಡ್ಡು ತಗೊಳ್ಳೋದು, ಡಿಮ್ಯಾಂಡ್ ಮಾಡಿದ್ದು, ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ದು ಇದೆಲ್ಲ ರೆಕಾರ್ಡ್ ಆಗಿದೆ. ಈ CD ಅನ್ನ ನಾವು ಡಾಕ್ಯುಮೆಂಟ್ ಅಡ್ಮಿಟ್ ಮಾಡ್ತೀವಿ ಟು ದಿ ರೆಕಾರ್ಡ್. That you do it, though principles, the sections of CPC or evidence act may not be applicable, but ಒಂದು ಫೇರ್ ಪ್ರೊಸೀಜರ್ ಬೇಕಲ್ಲ.
ಹೌದು.
ಅದೆಲ್ಲ ಆಮೇಲೆ ಒಂದು ಎರಡನೇದು, why did you not enlist that document? Why it was kept as a very enigmatically? Why you had kept it? Though in the charge you say the TV9 the sting operation ಅಂತ ಹೇಳಿದ್ರು,
ಹೌದು.
ಅದನ್ನ ಯಾಕೆ ಎನ್ಲಿಸ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ ಇಲ್ಲಿ? ಆಯ್ತು, ಮಾಡಿಲ್ಲ. ಆಮೇಲೆ ನೀವು ಅದನ್ನ ಯೂಸ್ ಮಾಡಿದ್ರಿ, ಅದ್ರ ಕಾಪಿಯನ್ನು ಅವ್ರಿಗೆ ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ ನೀವು? ಹೌ ಟು ಅಸರ್ಟನ್ ಹಿ ಹ್ಯಾಸ್ ಟೇಕನ್ ಅದು ಫ್ಯಾಬ್ರಿಕೇಟೆಡ್ ಏನೇನೋ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಾರ ಅವರು.
I will verify in the original records of that one court, because as far as my knowledge concern is for the appeal and this one, there is no acknowledgement as such, my lord. In the inquiry, this one, it may be there. I may be permitted to see that record and submit.
ಯಾವುದು?
ನಮ್ಮ ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ ಇರುತ್ತಲ್ಲ ಸ್ವಾಮಿ, ಇವರು ಡಿಪಾರ್ಟ್ಮೆಂಟ್
ಟೈಮ್ ಇಷ್ಟು ವೇಸ್ಟ್ ಮಾಡಿದ್ರೆ ಉಳಿದಿದ್ದ ಕೆಲಸ ಎಲ್ಲ ಅವ್ರು ಏನಂತಾರೆ, ಇಲ್ಲಿ ಬಂದು ಕೂತ್ಕೊಂಡಂತವ್ರು ಬೇರೆ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ತಾರೆ ಈ ಜಡ್ಜ್ಗಳು ಅಂತಾರೆ. ನಿಮ್ಗೆ ಏನು ಅನ್ನೋಲ್ಲ ಅವರು, ನಮ್ಮ ಟೈಮ್ ವೇಸ್ಟ್ ಆಗ್ತದೆ ಅಂತ.
My lord, in page 59, they have admitted, my lord, that document 1 month late, they have admitted. And also that is, there is no, my lord, I submit not only on behalf of the instruction, also I have perused all the documents from inquiry, my lord. CD was never given. That is my bone of contention. Therefore, I said, my lord, even
CD is not given ಅಂತ ಒಂದು ಸೆಂಟೆನ್ಸ್ ತೋರಿಸಿ ಕರೆಕ್ಟ್ ಆಗಿ. ಏನು ವೇಗ್ ಪ್ಲೀಡಿಂಗ್ಸು, ವೇಗ್ ಇದು ಆರ್ಟಿಕ್ಯುಲೇಷನ್ ಇಲ್ಲ, ಎಂಥದಿಲ್ಲ, ವೆರಿ ಮೆಟಾಫರ್ಸ್, ಆಲ್ ಮೆಟಾಫರ್ಸ್.
unfortunately, I can't comment on the.
ಅಲ್ಲ ಎನಿವೆ, ಬಟ್ ವಿ ಆರ್ ನೌ ಕಮೆಂಟಿಂಗ್ ನಾ.
My lord, kindly see page 59 for.
Where have you stated,
Me-
despite request, the copy of the CD was not given to me. Therefore, I was not in a position to say anything about what CD said, shown.
That is only from application, revision and appeal, application, revision is there, my lord, not in that state, because that state she handled, my lord,
Appeal ನಲ್ಲಿ ಎಲ್ಲಿದೆ ತೋರಿಸಿ.
appeal ಅಲ್ಲಿ ಇದೆ sir.
ಈಗ ನಿಮ್ಗೆ ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ
ಕೊಟ್ಟಿದ್ದಾರೆ.
enquiry report was given.
ಒಂದ್ ನಿಮಿಷ, ಬಹಳ ಮತ್ತೆ ಹೇಳ್ಬಿಟ್ರೆ ನಮ್ಗೆ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ತೀರಾ ನೀವು. ನಾವೊಂದು ಮೆಥಾಡಿಕ್ ಆಗಿ ಹೋಗ್ತಿರ್ತೇವೆ ಇಂಥ ವಿಷಯದಲ್ಲಿ.
Please.
ಏನೋ ಒಂದು ಹೇಳ್ಬಿಡೋದು. ನಿಮ್ಮ ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟ ಮೇಲೆ ಯು ಸೆಂಟ್ ಯುವರ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಟು ದಟ್. ವಾಟ್ ಈಸ್ ಯುವರ್ ಸ್ಟ್ಯಾಂಡ್ ಇನ್ ದ ರೆಪ್ರೆಸೆಂಟೇಷನ್? ಟೇಕ್ ಅಪ್.
Reply to show cause notice, my lord.
No, reply to the enquiry report. Copy of the report was shared with you.
Along, that is show cause notice, my lord. Along with show cause notice, they give inquiry report, to which I have replied as reply to show cause.
ಅದೆಲ್ಲಿದೆ ತೋರಿಸಿ.
Please.
Kind permission, my lord. If my lord permit that issue, in page number 100, para number 64, we have handed over on 13th hearing date, my lord. 13th hearing date of the inquiry, the
One
CD
second,
was.
one second. I will come to that. Wait. Now, where have you taken up that contention? ನಮಗೆ CD ಕಾಪಿ ಕೊಟ್ಟಿರಲಿಲ್ಲ, ಹಾಗಾಗಿ ನಮ್ಗೆ ಅದ್ರ ಬಗ್ಗೆ ಏನೂ ಹೇಳಿಕ್ಕೂ ಆಗಲ್ಲ.
My lord, page 155, my lord.
155.
These are the contentions taken.
ಏನೇನಿದು ನಿಮ್ ಕಂಡೆ?
My lord, at IO had failed to note that, para number 4, my lord. IO had failed to note that there is no corroborative evidence to
ಅದರ
this.
ಬಿಡಿ, ಅದೇ ಉಪಯೋಗ ಉಂಟಲ್ಲ. ಈ ಸ್ಪೆಸಿಫಿಕ್ ಕಂಟೆನ್ಷನ್ ಎಲ್ಲಿದೆ? CD ನಮಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅನ್ಕೊಂಡು.
ಅದೇ sir. ಈ CD ಎಲ್ಲ application, revision and writ petition.
ಇದರಲ್ಲಿ
ಇದ್ರಲ್ಲಿ ಇಲ್ಲ
This
ಸ್ವಾಮಿ.
is
ಅವ್ರು-
the
it's not,
inquiry.
my lord, I have to be fair, my lord, in submission. What is not there, I cannot say. It is not there, my lord. In that particular term, it is not stated. Instead, they say entire evidence is not taken into consideration. My cross
ಅದ್ ಬಿಡಿ,
exam.
ಅದು ಸ್ಟೋರಿ that will come to. The where CD ಎಲ್ಲೂ ಅದ್ರ ಬಗ್ಗೆ ಎಲ್ಲೂ ಇಲ್ವಾ ಇದರಲ್ಲಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದಿಲ್ಲ. ಅಪೀಲ್ ಅಲ್ಲಿ ಬಂದಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಅಲ್ಲಿಂದ ಬಂದಿದ್ದಾರೆ. ನ್ಯಾಚುರಲ್ ಜಸ್ಟಿಸ್ ವೈಲೇಟ್ ಆಯ್ತು, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಅಪೀಲ್ ಆನ್ವರ್ಡ್ಸ್. ಅದಕ್ಕೆ ನಾನು ಇಫ್ ಐ ಕುಡ್ ಟೇಕ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಅಟೆನ್ಷನ್ ಕ್ವಿಕ್ಲಿ ಫಾರ್ ಪೇಜ್ 59, ಮೈ ಲಾರ್ಡ್.
ಆ ರೀತಿ ಎಲ್ಲ ತಗೊಳ್ಳಲ್ಲ ನಾವು. ಇವಕ್ಕೆಲ್ಲ ಒಂದು ಮೆಥಡ್ ಇದೆ.
Please.
ಅದು ನೀವು ಹಂಗೆ ಎಂತಕ್ಕದೋ ಅದು ವೇಗಾಗಿ ನೆಬುಲಮ್ ಪ್ರಿನ್ಸಿಪಲ್ ಮೇಲೆ ಆಪರೇಟ್ ಮಾಡಿದ್ರೆ ಒಂದ್ ಕೇಸು ಡಿಸೈಡ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಮಾಡ್ಕೊಳ್ಳಿ. Your first contention, you said what?
Documents along with the charge memo was not given to me for 1 long month, which is admitted at page 59.
Counsel for the petitioner firstly argues that 22 documents enlisted in the show cause SCN,
Charge memo, my lord.
charge memo, had not been furnished to her client
Which is admitted at page 59 by the authorities.
despite demand. First off, when we asked as to when and where the demand for the copies of these documents were made, was made. Come on, counsel replies. ಏನ್ ನಿಮ್ದು ಉತ್ತರ?
The reply submitted
ಎಲ್ಲಿದೆ?
is not produced before the tribunal also, my lord, because
ಅದಲ್ಲ. ನಿಮ್ ಈಗ ಇದಕ್ಕೆ ಆನ್ಸರ್ ಮಾಡ್ತಾ ಇದ್ದಿಲ್ಲ.
ಅದು page 59, my lord, para number 3.
59.
Page 59, my lord, para number 3.
59, para 3.
The charged
Pointed
official,
out that the copies of the document listed charges were not enclosed with the memorandum. However, seen that the same were forwarded to the charge sheet official by letter dated 11/9/2012. It is seen that no prejudice is caused to the charged official by delay of 1 month in sending the list of documents to her. 1 month delay ಹಾಕ್ಕೊಟ್ಟಾರೆ. ಒಂದೇ ನಿಮಿಷ.
True, my lord.
ಬರ್ಕೊಳ್ಳಿ. Counsel banks upon the stand of the management as reflected in unnumbered para 3 at page 59 of the paper book, that 1 month after, comma, the copies of these documents were sent wide letter dated 11/9/2012. 1 second, please. When the first witness was put to examination in chief, first witness.
First witness.
Proceedings have begin.
My lord, it is at page number 94, my lord, they clearly say first hearing happened on
11/9/2012 ಕೊಟ್ರ ನಿಮ್ಗೆ?
ಹೌದು sir.
ನೀವು ಅದಕ್ಕೆ ರಿಪ್ಲೈ ಯಾವತ್ತು ಕೊಟ್ರಿ? When did you give the reply?
My lord, my submission is reply without document. She denied the charges, my lord, because she had 15.
Asking the question.
That document is not produced. my
When
lord.
did you give the reply?
That document is not produced, my lord. As such, I cannot comment on it because the document
When
was
they
not
gave the
produced.
reply? Was it before this or after this?
Written statement of defense they have provided on 13/4/2015 through proper channel. 13/4/2015 proper channel at page number
2015.
At page number 154.
Defense statement.
Defense statement, written statement of defense.
Not that, sir. Reply to charge. my lord.
Submission of written statement of defense they have provided on 13/4/2015.
That is after inquiry. My lord is asking about reply to charge memo.
Reply to charge memo ಯಾವತ್ತು ಕೊಟ್ರು? ಅವ್ರು ಹೇಳಲ್ಲ, ನಿಮ್ಮ ಮೇಲೆ ಹಾಕ್ಯಾರ, ನೀವೇ ಉತ್ತರ ಕೊಡಿ, ಈಗ ನಿಮ್ಮ ಹೊತ್ತಿಗೆ ಇರತ್ತಲ್ಲ. ಏನು ಪ್ರಿಪರೇಷನ್ ಆಫ್ ಕೇಸ್ ಅಪ್ಪ? ನಿಮ್ಮ ಮೇಲೆ ಯಾರು ನಿಮ್ಮ ಮೇಲೆ ಕೇಸ್ ಹಾಕಿಲ್ಲನು ಕನ್ಸ್ಯೂಮರ್? ಇಂಗ್ಲೆಂಡ್ ಆದ್ರೆಲ್ಲ ಇವರು ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲ ಸೇಲ್ ಆಗಿ ಹೋಗ್ತಿದ್ದು. ಜಸ್ಟ್ ಫ್ಯೂಗಲ್ ಪ್ರಿಪರೇಷನ್. Call this matter for further hearing next week. The counsel for the petitioner and the counsel representing the respondents are mandamused to read all papers and come back with full preparation.
My lord, it is covered by.
Since they are not answering vital questions arising in the case. For further hearing.
My lord, a date may kindly be fixed.
Don't waste time. ಕರಿ ಒಂದು ಡೇಟ್ ಕೊಡಿ. ನೋಡಿ, ಶೋಕಾದ್ ನೋಟಿಸ್ ಯಾವತ್ತು ಬಂತು ಕೇಳ್ಕೊಳ್ಳಿ ಪೂರ. We work on this and we come here. Okay? ಹೆಚ್ಚಿಗೆ ಹೇಳೋದು ಬೇಡ. ಶೋಕಾದ್ ನೋಟಿಸ್ ಯಾವತ್ತು ಕೊಟ್ರು? ನಿಮ್ಮ ರಿಪ್ಲೈ ಯಾವಾಗ ಕೊಟ್ರಿ? ಎನ್ಕ್ವೈರಿ ಯಾವಾಗ ಬಿಗಿನ್ ಆಯ್ತು? ಡಿಫೆನ್ಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನೀವು ಆಮೇಲೆ ಯಾವಾಗ ಮುಗೀತು? ಡಿಫೆನ್ಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾವತ್ತು ಕೊಟ್ರಿ? ರಿಪೋರ್ಟ್ ಆಫ್ ದಿ ಎನ್ಕ್ವೈರಿ ರಂಜಾನ್ ಖಾನ್ ನಿಮ್ಗೆ ಯಾವತ್ತು ಕೊಟ್ರು? ಅದಕ್ಕೆ ನೀವು ರಿಪ್ಲೈ ಯಾವತ್ತು ಕೊಟ್ರಿ? These are essential material based on which challenge to disciplinary proceedings or punishment imposed in a disciplinary proceedings would lie. Okay, any standard book on law relating to disciplinary proceedings will say this. Istu uttara kodಬೇಕು next date ಗೆ. Okay, ನೀವು ಯಾರು ಉತ್ತರ ಕೊಡಲ್ಲ.
My lord, one request, my lord. These petitioners and their lawyer, there was some miscommunication and also most of the papers are lost. What is produced is only this, my lord.
ಅದ್ ನೆಡ್ಕೊಂಡು
If
ಉತ್ತರ
my
ಕೊಡ್ಬೇಕು.
learned friend, that's why my disability, my lord, other than reply and reply to Shoka's notice, other documents I have produced. Those two documents I'm disabled, my lord. If my learned friend could produce it, because my lord's questions are based on only two documents.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ತೊಗೊಂಬನ್ನಿ, ಅವರಿಗೂ ತೋರಿಸ್ಬಿಡಿ.
ಅದೆರಡು ಡಾಕ್ಯುಮೆಂಟ್ ಅಷ್ಟೇ, ಮಿಕ್ಕಿದ್ ನಾವು ನಮ್ಮ ಹತ್ರ ಇರೋದು ಕೊಟ್ಟಿದೆ.
ಅದನ್ನೆಲ್ಲ ನೋಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು ಈಗ.
Please.
Counsel for the defendant, respondent is
It is
instructed,
also
keep
cover-
the original entire file relating to the inquiry. Produce the entire file before the court relating to the inquiry on the next date of hearing. First off, he shall permit counsel for the petitioner to look into the same and make notes of the same, so that counsel for the petitioner shall not feign ignorance when question is put to him. Okay.
Great. Dates.
This time is.
My lord, date, my lord, kindly one date. One date.
The other one date. 13 pen.
My lord,
Again.
13.
Right.
15,
Where did it
15,
get?
my lord, 15,
Huh?
15.
Friday very difficult. 19th ಬನ್ನಿ.
Great.
ಎಷ್ಟು ಟೈಮ್ ಎಷ್ಟು ದಿನ ಖಾಲಿ ಕೊಡ್ಬೇಕಾಗತ್ತೆ ನೀವು ಮಾಡೋ ಕೆಲಸಕ್ಕೆ ನಮ್ ಟೈಮ್ ಎಷ್ಟು ವೇಸ್ಟ್ ಆಗ್ತದೆ ಏನು ಕ್ರಿಮಿನಲ್ ವೇಸ್ಟ್ ಹಂಗಾಗಿ ಜನರಿಗೆ ಸಿಟ್ಟಿದೆ ಜುಡಿಷಿಯರಿ ಮೇಲೆ ಜಡ್ಜ್ ಮೇಲೆ ಲಾಯರ್ಸ್ ಮೇಲೆ
ನೋಡಿ, ಇದ್ರಲ್ಲಿ
ತುಂಬಾ ಸಿಟ್ಟಿದೆ ಪಾಪ ಹೆಲ್ಪ್ಲೆಸ್ ಇದ್ದಾರೆ ಜನ ಅನ್ನೋದಕ್ಕೆ ಸುಮ್ಮನಿದ್ದಾರೆ
ಮಹೇಶ್ ದಯ್ಯ ಕೇಸ್ ಕವರ್ಡ್.
ಏನ್ ಕವರ್ಡ್ ಸರಿಯಾಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಸುಳ್ಳು ಮಾತಾಡ್ಸ್ಬಿಟ್ರೆ ನಮ್ಮ ಕೈಯಿಂದ.
This is a case where my pensionary gratuity has been withheld.
Have you
Okay.
come after reading the papers?
My lord, yes, my lord.
Body.
My lord, page number 38.
Page 38. ಏನಿದು ಕೇಸ್?
At the time of, my lord, it's a case where for having found convicted in a criminal case, punishment under 214(1)(a) is imposed, my lord, which I am not challenging because that is subject to the outcome of the appeal that I have filed, where only sentence is stated, not the conviction. However, my claim to that pension, that portion of pension which is withheld or withdrawn will be subject to the outcome. I am not agreed by that. But what happened is in the instant case, when I was that attained the age of retirement, my gratuity was not settled for want of LDC, not on anything else. What they have done is in the impugned order at page 40, while passing punishment under 214(1)(a), they have added one more word saying nivrutti upadanavannu anta ಸೇರಿಸಿಬಿಟ್ಟಿದ್ದಾರೆ. That should be deleted is only my
Because it's your contribution.
yes, my lord, and that is not the provision also. Rule 214(1)(a) only talk about the power to withhold pension, not gratuity. Therefore, that is wrongly made, my lord. If that is only modified, I am satisfied, my lord, because other claim would.
ಇವ್ರೇನು ಹೋಲ್ಡ್ ಮಾಡಿದ್ರು KT ಅವರು?
KT ಅವರು ಅದನ್ನ fail to appreciate this aspect, my lord, because they only went on the aspect of it is pension, 214 pension ಇದೆ ಅನ್ಕೊಂಡು. Kindly see the impugned order, my lord, at page number. Page 25, my lord, para 6. After perusal of the entire materials, they go to show that the criminal case instituted as against this applicant was while the applicant was in service itself, which is pleaded by the applicant in this application. He retired from services on 31.
14(1) KCS. What is the rule?
ಅಲ್ಲ ಇದು ಅಪ್ಲೈ ಆಗಲ್ಲ ಸ್ವಾಮಿ. ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಮಿಸ್ಲೆಡ್ ಇಟ್ ಸೆಲ್ಫ್ 214 ಗೆ.
ಏನು? ಮುಂದೆ No, what he says is your gratuity could not have been.
Yes, it should be confined to pension alone because 214(1)(a) talk about.
Wasting type. Yes, gratuity cannot be withheld. Is his contention. What's your answer to that? Which rule gives you power to withhold the gratuity? First, put it 214.
Kindly, there is 213 as well as 214. 213 future good conduct shall be an implied condition of every grant of pension. The pension.
What is pension defined? Gratuity is different, pension is different. That's our contention. Yes.
13 and 214(a) does not deal with.
Pension.
It does not deal with the gratuity.
That is what he is saying now. Then what is, suppose if you forfeit his private property merely because he is convicted, how can you do that? That's our contention. Pension is defined by Supreme Court in Devaki Nandana Mishra versus State of Bihar, UP ne other one, first match, and DS Nakar also. The periodical payment, ordinarily the periodical payment for the service rendered in past is defined as pension. This is not, this is only payable on retirement. That does not mean that it is being paid as a consideration for the past service. Number one. Number two, to withhold something, you should have power. You have power to withhold pension. That does not include gratuity. Pension ಎಲ್ಲರೂ ಡಿಫೈನ್ ಆಗಿದೆ ರೂಲ್ಸ್ ನಲ್ಲಿ? ಯಾರು ಸರ್ವಿಸ್ ಮ್ಯಾಟರ್ಸ್ ಯಾರು ಮಾಡೋರು? ಶೆಟ್ರೆ, ಪೆನ್ಷನ್ ಎದುರಾಗರೆ ಡಿಫೈನ್ ಆಗಿದೆನೋ? ಕೊಡಿ. Is it defined? Whether definition includes gratuity also? It includes. Include ಆಗಿದೆ ಅಂತ. ಎಲ್ಲಿ ಬ್ರದರ್ ಅದು? Pension includes gratuity.
My lord, kindly see rule 214(1)(a), my lord, because the impugned order talk about only one provision, that is 214(1)(a). And what it says is,
ಡೆತ್ ಕಮ್ ರಿಟೈರ್ಮೆಂಟ್ ಗ್ರಾಚ್ಯುಟಿ ಇನ್ಕ್ಲೂಡ್ ಆಗಲ್ಲ, ಬಟ್ ಗ್ರಾಚ್ಯುಟಿ ಇನ್ಕ್ಲೂಡ್ ಆಗ್ತದೆ ಅಂತ ಇದೆ ರೂಲ್ ನಲ್ಲಿ.
ನಮಗೆ
ಡೆತ್ ಕಮ್ ರಿಟರ್ನ್ ಆಲ್ಸೋ ಅನ್ಲೆಸ್ ಅದರ್ವೈಸ್
retirement gratuity, that is retirement
which
gratuity.
is 200.
214(1)(a), that is the provision which impugned order talks about. Small a, my lord, withholding or withdrawing.
214
1(a), my lord.
1A, small a.
Small a, my lord.
The government reserves themselves the right of either withholding or withdrawing a pension or part thereof, either permanently or for a specified purpose in any department of the body, and found guilty of slavery. Again,
Only talks about pension alone.
only pension includes gratuity ಇದೆಯಲ್ಲ definition clause.
My lord, gratuity cannot be partly withheld or withhold, my lord. Gratuity,
Where is the,
it's only pension, my lord.
ಏನಾರ rulings ಇದೆನೋ?
My lord, the very rule 214(1)(a) do not talk gratuity, my lord, pension for all.
Includes gratuity ಅಂತ definition.
Definition ಅಲ್ಲಿ ಇದೆ ಅಂತ. ಇದ್ರ ಮೇಲೆ ಆಲ್ರೆಡಿ ಯಾವ್ದೋ ಜಡ್ಜ್ಮೆಂಟ್ ಇತ್ತಲ್ಲ ಬ್ರದರ್.
My lord, can I just make one submission in a different angle, my lord? I retired in the year 2015.
ಎಂತ ಆಂಗಲ್ ಬೇಕಿಲ್ಲ, ಇದು ಕವರ್ಡ್ ಬೈ ಜಡ್ಜ್ಮೆಂಟ್. ಒಂದ್ ಸ್ವಲ್ಪ ಲೈಬ್ರರಿಯಲ್ಲಿ ಕುತ್ಕೊಂಡ್ರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಸಿಗ್ತಾವ. At least 2 judgments I have read, which apparently supported you. It was under some other law. Only thing is somebody should spend some time in the library. There are judgments. Correct. Call this matter next week. ಅಷ್ಟೇ ತೋರಿಸ್ಬಿಟ್ರೆ ಮುಗಿದು ಹೋಯ್ತು.
19, my lord. My lord, in that case, they have to withdraw this order and pass order under 208, my lord.
ಯಾಕೆ?
Gratuity, because gratuity is my lord, it was not subjected to pendency of I retired in the year 15. They had withheld it for the want of LDC, which is official technicality. They cannot club it to an event after 5 years, which ended up in conviction, my lord, which has no nexus at all. Just because they could not release it. If I had been released in 2015, would they still had a ground to say now in 2019, just because you are convicted, return the gratuity? Now,
ನೋಡ್ಕೊಂಬನ್ನಿ, ಅದಾದ್ಮೇಲೆ ಜಡ್ಜ್ಮೆಂಟ್. ನಮ್ಮ there is one judgment. Unfortunately, my memory is playing trick with me. Anyway, there are judgments. Gratuity cannot be withheld ಅಂತ ರೂಲಿಂಗ್ ಇದೆ. ಅದ್ ನೋಡ್ಕೊಂತೊಂಬನ್ನಿ. ಸರಿಯಾದ ಮೋಸ್ಟ್ಲಿ ಶಿವಶಂಕರ್ ಭಟ್ ಸಾಹೇಬ್ರದ್ದು ಯಾರೋ ಒಂದು ನಮ್ಮ ಹೈಕೋರ್ಟದ್ದೇ ಇದೆ. ತೊಂಬನ್ನಿ ಅದನ್ನ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹಾಕೋಣ. ನೆಕ್ಸ್ಟ್ ವೀಕ್
same date, my lord, 19th.
ಆಯ್ತು. 19.
Great.
We are for the petitioner in this matter, respondent.
Yes.
Respondent number 4 approaches the tribunal, my lord, claiming his promotion was not considered. The promotion granted to the petitioner was under challenge.
Application ಯಾವ year?
2023.
23. Call in the.
Lord, I was, Lord,
January.
only one submission. Now,
2023, there are
Yes,
many 2000.
I bow down to you. Lord.
Only
issue
pending matter.
for a moment. An unsettled position of the petitioner, settled position of the petitioner has been unsettled by the order of the tribunal. Lord, I am promoted in the year 2019. Applicant approaches, Lord, the fourth respondent approaches the tribunal in 2023. Lord, the tribunal, Lord, where already they have considered and to
Notice,
divergent.
Admission ಬಂದಿದೆನೋ?
Yes, B group.
Notice ಆಗಿದೆ.
B group, Lord.
B group ನಲ್ಲಿ
Lord, one submission.
Huh.
There are two judgments rendered by the honorable tribunal.
Correct.
Where, my lords,
In
they
case
have-
why we should take your case? when
Divergent-
Older case are here.
Please, my
Ah,
lords,
madam.
only submission is this. A divergent view is taken by the tribunal, my lords, where two applications are dismissed and this application is allowed.
ಅದು
Lord,
it is order is wrong ಅಂತ ತೋರಿಸ್ಲಿಕ್ಕೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅದು.
only on the basis of delay and latches, my lord. Though,
Sir, we are not answering why people in the queue. We have been waiting in the queue for years. You have seen 2013 or
I
April.
understand, I
Ah,
understand.
ಮತ್ತೆ ಅದಕ್ಕೆ ನೋಡ್ಬೇಕಲ್ಲ.
My apologies, my
Otherwise, we
lord.
would have taken that.
My promotional, my lord, granted in 2019, my lords, I have been reverted now. Lord, it's in view of the
ಯಾವಾಗಾಗಿದೆ ರಿವರ್ಷನ್ ಯಾವಾಗಾಗಿದೆ?
2023, after the order of the tribunal passes the order.
One submission.
23 ಅಲ್ಲಿ ಆಗಿದೆ.
As per the pleadings, lads, the respondent is the senior to the petitioner. man.
I am not disputing it, my lord. There is a lacuna, my lord,
Senior man.
in respect of filing the confidential report of the respondent number 4.
Third week of January, since there are older matters to be taken up, older matters in the queue, which court has to take up. Yes. ಎಲ್ಲ ಹೊಸ ಮ್ಯಾಟರ್ಸ್ ತಗೊಂಡ್ಬಿಟ್ರೆ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಏನು? ನಿಮ್ಮ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಇದಾವೆ.
ಅಲ್ಲ, this bench is only, my lord, 23, 24 matters ಬರುತ್ತೆ ಸ್ವಾಮಿ.
ಇಲ್ಲ, ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ RF ಎಲ್ಲ ಇದಾವೆ.
Please, I am not,
10 ವರ್ಷ ಇದೆ.
please,
11 ವರ್ಷ, 13 ವರ್ಷ. Sorry.
grateful.
Grateful.
Respond. 29. I gave them next week, my lord. Not ready? Next weekend. ಯಾವ year? 23. Call in the third week of January 2025. Yes. You know, long fought battle, we can understand, though number belatedly it goes to tribunal. Yes.
Lord, for the petitioner may seek for a passover, my lord.
This is my lord,
Any matter.
this is premature, my lord, premature. After notice is issued, directly we come to the
My lord, it emanates from a land grabbing complaint, my lord.
Third
So we
filing any
challenge the
objection.
proceedings before the land grabbing. My lord, the reason why the matter was,
ಅಲ್ಲಿ ರಿಪ್ಲೈ ಕೊಡಬೇಕು.
Yes.
ನೋಟಿಸ್ ಕೊಟ್ರೆ
no,
ಅವ್ರಿಗೆ ಹೋಗಿ
I'll just seek for a passover, my lord. Last.
week after next.
My lord, one short thing, what happened before the land grabbing court is, my lord.
ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡದಿದ್ರೆ ಈಗ ತಗೊಳ್ತೀವಿ.
But there was one clarification, my lord. The order, there are three connected matters, my lord. In two matters, it says stay of proceedings. In one order, my lord, it says no precipitative action. The land grabbing court is continuing to hear the matter only to that extent, my lord, if that can, because the matter is set down for hearing on 14th, my lord.
On 14.
Before the land grabbing court.
Stay ಇದೆಯೇನು?
Stay there, my lord. All the three matters, two matters, there is a clear stay, my lord. One matter, it says no precipitative actions.
Of the other court.
26804.
Therefore, there shall be stay of proceedings in so and so, so and so.
Please, my lord.
ಅಂತೆ ಅಲ್ಲ.
My lord, may I just pass on the order of the land grabbing court, my lord, wherein the court records the third line, my lord, the court takes into account the third line there. However, keeping in view the submission made by the learned senior counsel seeking intervention and also seeking grant of, it is deemed appropriate to direct the respondent shall not precipitate the matter relating to issues. So the court takes into consideration that one line, my lord, and has set down for appearance of the accused.
ಬಂದು ನೋಡಿ. ಪಡ್ರೆ ಏನಿದೆ?
ಅಷ್ಟೇ, ತಾವು ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀರಿ, ಅಲ್ಲಿ ಡೋಂಟ್ ಪ್ರಿಸಿಪಿಟೇಟ್ ಅಂದ್ರೆ
ಬರ್ಕೊಳ್ಳಿ. Learned senior advocate appearing for Mr. Holla appearing for the petitioner draws attention of the court to the coordinate bench order dated 7/2/2024, wherein unnumbered para 3 reads as under. Stay there.
Stay there.
Next paragraph. In view of the above, there shall be stay of all further proceedings pending on the file of the court of land grabbing. ಯಾಕೆ ಹಿಂಗೆಲ್ಲ ಇದ್ರು
ಏನ್ ಮಾಡಕ್ ಗೊತ್ತಿಲ್ಲ, ಇದು ಸ್ವಲ್ಪ
ನಾನ್ ಪ್ರಿಸಿಪಿಟೇಟ್ ಈ ವರ್ಡ್ಸ್
ಇದೆ, ಸ್ಟೇ ಅಂತಾನೂ ಇದೆ, ಮೇಲೇನೂ ಇದೆ, ಸ್ಟೇ ಅಂತಾನೆ ಬರ್ದಿದ್ದೀರಿ ನೀವು, ಆದ್ರೂ
86 ಅಲ್ಲಿ WP 26804 ಅಲ್ಲಿ ಸ್ಟೇ ಇದೆ.
ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆ, ಇನ್ನೊಂದ್ರೊಳಗೂ ಸ್ಟೇ ಇದೆ.
ಒಂದು ಸ್ಟೇ ಆಗ್ಬಿಟ್ರೆ ಉಳಿದ್ರೊಳಗೆ ಅವಾಗ ಅರ್ಧ ಮುಂದಕ್ಕೆ ಹೋಗ್ಬೋದು, ಅರ್ಧ ಮುಂದಕ್ಕೆ ಹೋಗಲ್ಲ ಅನ್ನಕ್ ಬರುತ್ತಾ?
All are one apartment, my lord. All are one apartment.
That's why.
Please.
Lord, I am appeal for the respondent in this case, ma'am. Lord, I am
Yes.
appeal for the respondent.
Why can't you land grabbing court? ಎಷ್ಟು ಮ್ಯಾಟರ್ಸ್ ಬರ್ತಾ ಇದೆ ನೋಡಿ, ಇಂಥದಕ್ಕೆಲ್ಲ ಕೋರ್ಟ ಆಲ್ರೆಡಿ ದೇರ್ ಇಸ್ ಸ್ಟೇ ಆಫ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್, ಅದ್ರ ಮೇಲೆ ಮತ್ತೆ ಕೇಸ್ ಮಾಡೋದು. ಅದರ್ ಡೇ ಯು ಹ್ಯಾವ್ ಅಪಿಯರ್ಡ್, ಯು ಹ್ಯಾವ್ ಸೀನ್ ದ ಕೈಂಡ್ ಆಫ್ ಆರ್ಡರ್ಸ್ ವಿಚ್ ದೇ ಆರ್ ಪಾಸಿಂಗ್. ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು ನೀವು. ನಾವು ಹಿಂಗೆ ಹೇಳಿದ್ದಾರೆ ಹೈಕೋರ್ಟ್ನಲ್ಲಿ, ಸ್ವಲ್ಪ ಮೈಂಡ್ ಅಪ್ಲೈ ಮಾಡಿ ಆರ್ಡರ್ಸ್ ಮಾಡ್ಬೇಕಂತೆ. Otherwise, we may pass some strictures, we do not know. But ಅದ್ರಾಗೆ ಹೋಗ್ತದೆ ಟೈಮ್ ಎಲ್ಲ. ಬಡಿ.
I am appeal for the respondent in this case. My lord, in this matter, my lord, the compensatory ground appointment. My lord, the respondent.
ಆನ್ ಮಾಡ್ಕೊಳ್ಳಿ ನಿಮ್ಮ ಇದನ್ನ.
On ಇದೆ.
ಆನ್ ಇದೆಯಾ?
On ಇದೆ.
ಧ್ವನಿ ಜೋರ ಮಾಡ್ಕೊಂಡು ಹೇಳಿ.
Kindly see, my lord, 105 annexure A8. My lord, 21/9/2021, the endorsement issued by the government. My lord, only stating that, my lord, the respondent is overaged. Therefore, my lord, he is not entitled for appointing for compensating ground, my lord.
Correct.
Kindly see, my lord, I have produced the rules also. Page number 113, my lord.
He is relying upon the amended
Amended
rules
rules
of
are
2021. It's a
Amended-
prospective in nature, lordship has that.
Kindly see, my lord, for a moment. My lord, page number 113,
113.
my lord.
ಏನದು?
Rules, my lord. Provided seeking appointment shall be within the age of limit specified for the post in the relevant rules of recruitment specially made in the respect of any service or post, so and so, my lord. Next, my lord, provided that the age of specified above shall not apply to widow or widower. My lord, he is the widower.
ಯಾವಾಗ ಬಂತು ಈ ರೂಲು?
Kindly, next, my lord, of the deceased government servant who seeks appointment under this rule, these rule, the age limit for these dependents shall not exceed 51 years at the time of submitting application.
ಒಂದ್ ನಿಮಿಷ, ಈ ರೂಲ್ ಯಾವಾಗ ಬಂತು?
My lord,
20 hours.
in the 1996, my lord, page number annexure A9, annexure A19.
For 21 ಅಲ್ವಾ?
ಅಲ್ಲ 21.
Kindly see, my lord, 108, 108, my lord.
108.
I have produced entire gazette notification also. Notification date so and so, 12th September 1996.
Is added subsequently.
Subsequently, my lord,
21
but
will
my
get
lord,
to
in the year of 2022 died, my lord, the respondent, wife of the respondent. Immediately, my lord, within 1 year, he filed a application for, my lord, appointment under the compensation ground.
ಡೆತ್ ಇನ್ ಹಾರ್ನೆಸ್ ಆಗಿದ್ದು ಯಾವಾಗ?
My lord, he died on, my lord, 28/1/2020.
28/1/2020. 1/2020. When did you apply for compassionate appointment?
My lord, within a year, my lord, that is not disputed by the.
We are disputing now. Yes, still give us the date. When did you apply for it?
Please. I produced the entire application along.
ನಾವು ಒಂದು ಎಂಟೈರ್ ತೊಗೊಂಡು ಏನ್ ಮಾಡ್ರಿ, ನಮ್ಗೆ ಬೇಕಾಗಿದ್ದು ಒಂದು ಕ್ಯಾಲೆಂಡರ್, ಒಂದು ಡೇಟ್ ಅಪ್ಪ, ಒಂದು ಡೇಟ್ ಕೊಡಿ. ಯಾವತ್ತು ಅಪ್ಲೈ ಮಾಡಿದ್ರಿ ಈ ಕಂಪ್ಯಾಷನೇಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್?
28/1/2021.
28/1/2021. That is 1 day after 1 year.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಡೇಟ್ ಆಫ್ ಚೇಂಜ್ ಇದೆ ಸರ್, ಮಿಸ್ಟೇಕ್ ಇದೆ. ಇವನ್ ಮಚ್ ಬಿಫೋರ್ ದ ಡೆತ್ ಆಫ್ ದ ಡಿಸೀಸ್ಡ್ ಲಾರ್ಡ್ಶಿಪ್
ಅವಾಗ ಅಪ್ಲೈ ಮಾಡಿಬಿಟ್ಟು
ಅದಕ್ಕಿಂತ ಮುಂಚೆನೆ ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ
ಅದ್ ಬಿಡಿ,
ಅದು
ಅದು ಹಂಗೆ ಮುಂಚೆನೆ ಮಾಡಿದ್ರು, ಅದು ಆಮೇಲೆ
ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ ಇಟ್.
ನಿಮ್ ಪ್ರಕಾರ ಯಾವ ಡೇಟ್ ಅಪ್ಲೈ ಮಾಡಿದ್ದು?
ಅಲ್ಲ ಅದು 1/3/20 ಅಂತ ಹೇಳಿದ್ದಾರೆ.
1/3/20
ಅವ್ರ ತೀರ್ಕೊಂಡಿದ್ದ ಡೇಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸರ್, ಡೇಟ್ ಆಫ್ ಡೆತ್.
Date of death is 28/1/20.
1320 ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಇಲ್ಲ,
1320.
ಇಲ್ಲೇ ಇದೆ.
ಹೌದು.
It makes your case worse.
49 your lords.
It makes your case worse.
20 ಅಂತ ಹೇಳ್ತಾರೆ. 13/2020.
That will make your case weaker. At least ಅವ್ರು ಹೇಳಿ ಡೇಟ್ ಇಟ್ಕೊಂಡ್ರೆ ನಿಮ್ಗೆ ಸ್ವಲ್ಪ ಹೆಲ್ಪ್ ಆಗ್ಬೋದು. ಜನವರಿ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ, ಮಾರ್ಚ್ ಅಂತ ಇವ್ರು ಹೇಳ್ತಾರೆ. All right. 28/1/2020 is the date of death, brother.
My lord, annexure A3, I have produced.
Not know all that. We are asking the question.
My
to
lord,
you.
one, actually death certificate is also produced. That is on, my lord, 1/3/2020.
That's what. 1/3. But you said 28/1/2020.
My lord, I
Now you have become wiser after hearing these arguments.
mentioned in the application, but my lord, the annexure also, death certificate is also produced.
ಅದೆಷ್ಟು?
Annexure A3, 1/3/2020,
A3 is death certificate,
death certificates. Page number 59.
All death certificate. It says 1/3/2020.
2020.
ಅದು filing application.
Application.
Death. When did he apply for post?
Annexure A to your lords, 52 page.
ಆ ಪೇಜ್ ನೋಡ್ತೇವೆ ನಾವು. ನಮ್ಗೆ ಡೇಟ್ ಉತ್ತರ ಕೊಡಿ.
Please your lordship.
Date,
That
when
is
did he
on
apply?
27/4/20.
27/4/2020.
ಅಂತ ಹೇಳ್ತಾರೆ.
2020. Within 3 months. Within one month, 27 days, 26 days. Applied. All right. Apply ಮಾಡ್ಲಿಕ್ಕೆ ಡಿಲೇ ಆಗಿದ್ದ ಪ್ರಶ್ನೆ ಇಲ್ಲ. All right. The question is whether he was age barred when he applied. That is the short question. Which rule prescribes the age bar?
Age bar, your lordship, finds at 155 page, your lordship, that Karnataka Rajapatra Gazette, your lordship.
155
page.
5.
ಕರ್ನಾಟಕ ಸಿವಿಲ್ ಸೇವಾ ಸಾಮಾನ್ಯ ನೇಮಕಾತಿ ನಿಯಮಗಳು 1977 ನಿಯಮನ ಅನ್ವಯ.
ಅದರಲ್ಲಿದೆ.
ಲಾರ್ಡ್ಶಿಪ್ ಸಾಮಾನ್ಯ 33 years.
ಗರಿಷ್ಠ
ಕನಿಷ್ಠ 18 ಇದೆ. ಗರಿಷ್ಠ 33 ವರ್ಷ.
ಇವ್ರಿಗೆ ಎಷ್ಟು ವರ್ಷ ಆಗಿತ್ತು?
41 ವರ್ಷ ಆಗಿತ್ತು.
41. What? 33 years. All right. ಈ ರೂಲ್ ಅಮೆಂಡ್ ಯಾವಾಗ ಆಯ್ತು?
21 euros.
21.
2021.
ಅದೆಲ್ಲಿದೆ? 108. ಅವ್ರು ಓದಿರಲ್ಲ ಅದ?
Please.
105.
ಬಟ್ ಅದರಲ್ಲಿ ಲೋಡ್ ಆ ರೂಲ್ಸ್ ಅಲ್ಲಿ ವಿಡೋವರ್ಗೆ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ. This is my lord amended later on.
Any candidate.
Widower thereafter my lord inserted on my lord annexure A19.
ಅಭ್ಯರ್ಥಿ
ordinary.
ಅದು ವಿಡೋವರ್ ವಿಡ್ದ ನ್ಯೂಟ್ರಾಲಿಟಿ ಇದೆ ಅಲ್ಲ, ಅಭ್ಯರ್ಥಿ ಕ್ಯಾಂಡಿಡೇಟ್.
ಇದರಲ್ಲಿ ಅದನ್ನು ಪ್ರೊವೈಡ್ ಮಾಡ್ತಾರೆ. ಅದಕ್ಕೂ
ಅದು ಎಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ?
ಅದೇ ಈಗ ಜಸ್ಟ್ ನಾನು 113 ಓದಿದ್ದೆ. ಅದೇ 113 of writ petition provided that last para.
ಅದೇ ಇದು amendment ಸ್ವಾಮಿ 9/4/2021 amendment, your lordship. It is mentioned in bottom. As per notification number DPR 26/CA 2018 dated 9/4/2021.
Did you take up, when did you decide his application for appointment? Which is the date?
Endorsement, your lordship.
21/9/2021.
By that time, rules had come into force. Brother, by that time, rules had come into force.
What date of death, your lordship? Date of application.
ಅದು ಬೇರೆ ಹೋಲ್ಡ್ ಮಾಡಿದ್ ನಾವು. ಇದನ್ನ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿಲ್ಲ ನಾವು. It was the other, whether benefits accruing because of annual benefits of the deceased in harness on employee in harness dying the harness ಅಲ್ಲಿ ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ ನಾವು. ಇದು as on the date you took up his application.
Please, sir.
He was not age barred because new rules had come into force. Those rules you should have applied.
It is for pendency.
KT ಮಾಡಿದ್ದಾರೆ.
Pendency of.
KT, my lord, consider ಮಾಡಿ order ಮಾಡಿ ಕೊಡಿ ಅಂತ ಹೇಳಿದೆ.
Correct ಇದೆ.
Thereafter, my lord, again endorsement was issued. KT is also quashed the endorsement and my lord, the allowed the application with cost, my lord.
Correct ಇದೆ ಬ್ರದರ್. ಅದು ಇದು ಈ ಆಸ್ಪೆಕ್ಟ್ ಮೇಲೆ ಮಾಡಿದ್ರು.
ಹೌದು.
ಎಲ್ಲಿದೆ ಆ ಪೇಜ್ ಅಲ್ಲಿ?
My lord, annexure A, my lord. Page number 15, operative portion.
10/8/2021, your lord.
Accordingly, my lord, page number
Endorsement was
25,
10/8. By that time rules had come into force.
page number
Rules
20.
have ಬಂದಿತ್ತು.
ಅಲ್ಲ,
ಬಂದಿಲ್ಲ.
9 ಅಲ್ಲಿ ಬಂದಿತ್ತು. 2021, 9/2/2021 ಅಲ್ಲಿ ಬಂದಿತ್ತು.
9/4/21.
9/4/21 ಗೆ ಬಂದಿತ್ತು.
ಮತ್ತೆ ರೂಲ್ಸ್ ಬಂದಿತ್ತಲ್ಲ ಅವಾಗ. ಆಲ್ರೆಡಿ ರೂಲ್ಸ್ ವೇರ್ ದೇರ್.
ಅದನ್ನೇ ಕನ್ಸಿಡರ್ ಮಾಡಿ.
ಬಟ್ ಅದು ಪ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಅಂತ ತಾವೇ.
ಪ್ರಾಸ್ಪೆಕ್ಟಿವ್.
ಲಾರ್ಡ್ಶಿಪ್
ಪೆಂಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್.
Page number 25, my lord. Accordingly,
Date?
page number 25. Accordingly, the application is allowed with cost 5,000 rupees with the respondent authority have to pay to the applicant herein within a period of 4 months from the date of receipt of this copy. Because there are 2 application filed, my lord.
ಬರ್ಕೊಳ್ಳಿ. ಕಾಸ್ಟ್ ತೆಗೆದು ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾಡ್ತೀವಿ. The writ petition is dismissed on the sole ground that as on the date the application for appointment on compassionate ground was taken up for consideration, comma, the amended rules had come into force. That is 9/4, force with effect from 9/4/2021. Specifically granting age relaxation for the candidates seeking benefit under the said rules. Full stop. Such amendments enacting a rule of a socio-welfare rule has to be given retroactive effect, if not retrospective. And if that is done, we cannot falter the judgment of the tribunal. First. Next, the above being said, there is force in the submission of learned counsel, learned AGA appearing for the state that such a case has arisen for the first time, arguably for the first time, comma, in the new regime, legal regime, comma, courts should not have awarded against acceptance. First, in view of the above, the requirement to pay costs is dispensed with, provided that the order of the tribunal is given effect to within a period of 8 weeks, failing which not only the requirement to pay costs would revive, another cost in the like sum shall be added to that. Okay. ಅಷ್ಟೇ ಇಲ್ಲಪ್ಪ ಗೌರ್ಮೆಂಟ್ ಮಾಡೋದು ಕೆಲಸನ ಮಾಡಿ ಅದು ಡೆತ್ ಇನ್ ಹಾರ್ನೆಸ್ ಅವೆಲ್ಲ ಅಲ್ಲೆಲ್ಲ ಸ್ವಲ್ಪ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ದಿ ಗೌರ್ಮೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಲಿಟಲ್ ಕನ್ಸಿಡರೇಟ್. Yes.
32 minutes.
Yes.
One first submission is on 15/10/24. The respondent had filed an application seeking for production of certain documents. We have responded to that, my lords, by way of a memo. We have served a copy on that. Insofar as the final argument is concerned, my lords, one submission, they have filed a statement of objections. And then,
When did they file that?
my lords, they have filed it, my lords, around a month back. Thereafter, the central government filed statement of objections, which was in favor of the
When
petitioner hearing.
it filed it?
Lords, that was also filed, my lords, around a month back.
Correct.
Thereafter, they filed a rejoinder, which was around 15 days back.
When the resigned was?
Lords, rejoinder, adilla, rejoinder.
We filed our
We just
statement
want
of
to complete
objection
the
on the very
pleadings.
first day of the case.
No, objections.
When
we
they
want
came
to
up for the first time.
Lords, rejoinder is in context
Overnight.
of the central government statement of objections, which where the stand taken by the central government before the tribunal was different. They have changed correct stand has been taken, my lords, in support of the state government now, or in terms of the rules now. Now, my lords, additional contentions have been raised, and along with the memo, certain documents have been produced, my lords, around 100 pages. We just want to complete our rejoinder, pleadings, short accommodation of 3 days, my lords. I will close.
3 days.
3 days.
And one day you are arguing the matter.
Tuesday, my lords. Monday. Tuesday. Monday, the sub-register.
Tuesday. What about the compliance of the order? Our
It is,
direction-
my lords,
some
we are
direction
filing a
we are
memo.
given, na?
We are filing a memo in compliance of that. We have given the.
Copy, sir.
Copies, sir.
Sir,
They have served the copy.
They served a copy. In
We
the
are
copy,
stating-
they
Huh?
say that there is no post of deputy collector. That is one statement. And then they say there is no, the second statement is that there is no equivalent declared by them.
They sought for information in the nature, my lords, all they have sought for, my lords, 2 questions. We have answered those 2 questions in our memo.
What were the questions?
My lords, the first question was, the government order notification or any other document with regard to existence of the post of nomenclature deputy collector in the state of Karnataka. For that response is, there is no post by nomenclature deputy collector in the state of Karnataka. Then, my lords, the government order or notification with regard to declaration of any post or post equivalent of deputy collector as stipulated in regulation 5.2 of the IAS appointment, no such notification has been issued. Thereafter, my lords, we have set out what are the equivalent posts, because now that is the consideration, the contention.
We are asking you
Please, my lords.
whether you treated office of the deputy commissioner or
Please.
post of the deputy commissioner as equivalent to deputy collector,
No, my lords, assistant commissioner is equivalent to deputy collector.
assistant commissioner as equivalent to deputy
Please,
collector.
we have stated in the memo also that in the most of the states in India, the nomenclature uses collector and deputy collector. In Karnataka and some other states, the equivalent cadres, my lords, is assistant commissioner and deputy commissioner. In fact, my lords, in Bombay, Karnataka, before the state reorganization, my lords, the word collector was there. Thereafter, equivalence was given to assistant commissioner. Assistant commissioner in the context, my
No,
lords, of the-
collector was deputy commissioner.
collector was collector was deputy commissioner. Deputy collector is
Or
assistant.
assistant, sub-divisional officer.
Sub-division. So an officer who is in charge of a revenue subdivision is treated, my lords, as assistant
collector.
and deputy assistant commissioner here, deputy collector, deputy commissioner, collector. In the central regulations, the use of the word deputy commissioner is there, but there are certain case law also where the equivalence at the time of reorganization also was considered. There is one paragraph where deputy collector in Bombay
Area.
ಅದೊಂದು ಇದೆ, one paragraph ಇದೆ. All those things, my lords, I will just organize and place it on record. And short accommodation.
Tuesday. All right. All this. Mr. Rajgopal, ಯಾಕ್ ನಿಂತಿರಿ?
My lords, connected matter is.
You are also.
Complications ಏನೂ ಇಲ್ಲ. Therefore, it may be delinked. Because of a variety of reasons, I think it may be dealing. There is already an order
ಎರಡು
passed.
ಏನ್ ಸಂಬಂಧ ಇಲ್ಲ, no? ಒಂದು
ಇಲ್ಲ, there was, my lords, for
ಇಲ್ಲ.
this reason.
In the instance of the state, it was connected. Therefore,
ಏನಿಲ್ಲ.
the connection is, in allowing his application, judgment rendered by the tribunal in my case has been followed.
Judgment rendered in your case having been followed, relief has been granted to the respondent.
No. For us, it is Surya Madhava case which has been.
ಅದು ಅದು ನಿಮ್ ಕೇಸ್ನಲ್ಲಿ ಫಾಲೋ ಆಗಿದೆ ಏನಾದ್ರು?
ಅದು
That
ನನ್ನ
Surya-
ಕೇಸಲ್ಲಿ ಅದು
ಇಲ್ಲ, ಇಲ್ಲ.
ಏನಿಲ್ಲ. My case is entirely
Therefore-
on the basis of interpretation of rules pertaining to promotion to IPS.
ಇವ್ರಿಗೆ ಸಂಬಂಧನೇ ಪಡಲ್ಲ.
ಅವ್ರದ್ದು IAS.
ಇವ್ರದ್ದು IAS.
ಅವ್ರದ್ದು IAS, IPS, the only connection, my lords, was the use of the word continuous service, whether it's actual service or notional service could be considered.
How can they?
It can-
ಬೇರೆ ಬೇರೆ
ಬೇರೆ ಮಾಡ್ಬೋದು, ಡಿಲಿಂಕ್ ಮಾಡ್ಬೋದು.
dissociate WP number so and so from WP number so and so. But post them on the same day.
Same day.
On Tuesday. Finally.
Please.
Finally. Okay. Information ಕೊಟ್ಟಿದ್ದಾರೆ. They have given the information which the court had directed.
Yes, what they are.
But
Lords, we are filing it along with the memo.
In fact, they say in their statement, in the lower court, before the CAT, they say such equivalence is given on case to case basis. We will see, we will deal with them on Tuesday, my lord.
Tuesday.
So depending upon.
Yes, my lord. Exactly, my lord.
Submit the AG. Shri so and so appearing for the petitioners has filed a memo dated 6/12/2024.
6/11.
6/11/2024.
In response to IA.
And submits that this amounts, this is in due compliance with this court's order
Dated 15/10.
dated 15/10/2024. First, this position is not disputed by the learned counsel, Mr. Keti, appearing for a private respondent. Obrena ನೀವು?
Obre.
Private respondent. Okay.
Not with regard to the DOPT, not Panigrahi case has been admitted by them in the first instance.
No, ಅವತ್ತಿನ this argument.
Not,
You appear for.
we had sought for,
Learned DSG appears for Union of India and points out that it has filed, his client has filed the statement of objections.
not, we had,
DSG assisted by DSG, Mr. Shanti Bhushan. Okay.
not, we had sought for the records by way of RTI with regard to the Panigrahi file, where they themselves have admitted that it is
Case to case.
parameteria. We are Siamese twins. Siamese twins is the right word, my lord, for that. Nonetheless, they say that no, this is something exclusive and invoke 81G. My lord, we are placing the RTI applications before the court. May we request the court to let them have the file, let the court have the benefit of the file on Tuesday, my lord?
ಆ ಫೈಲ್ ನಿಮ್ ಜೊತೆ ಇಟ್ಕೊಳ್ಳಿ.
No, not.
No,
that.
this is
Central-
for the DOPT.
Central government.
DOPT is supporting us, yet playing a slight truant there.
ಅವತ್ತಿನ ದಿವಸ Mr. Kamat, ASG,
If the file is there,
we file with you. If required, we can make use of that.
and
Otherwise, on that ground,
And
we
for
will
the-
not give adjournment. Berkeley. Learned DSG is instructed to keep the file of Panigrahi file. ಎಂತ file?
yes, Surya Madhava Panigrahi.
ನೋಡಮ್ಮ. Malava
Those are the
Panigrahi
RTI applications made,
File.
the reply received.
file. So that the information contained therein may come to aid of the adjudication of the list at hand. And first, to facilitate understanding and compliance of this direction, the copy of memo dated 15/10/2024 filed by the contesting private respondent, accompanied by RTI application, is directed to be served on the learned DSG. But has been served on the learned DSG. ತಿಳ್ಕೊಂಡು ಸಿಗ್ನೇಚರ್ ಮಾಡಿಸ್ಕೊಂಡು DSG ಇಲ್ಲಿ ಕೊಡಿ. And counter memo.
It is as
with
good
the
as served,
signature.
Mela.
No. We are nowadays, we are afraid of the kind of contention they take up in the Supreme Court. Because we are not parties there. Supreme Court will never ask us, did you say this? Did you not say this? Therefore, Berkeley. And filed. The copy of the said memo is filed with us in this court after being countersigned by the DSG. Okay.
Obligement.
One submission.
A copy of this, a carbon copy of this order be handed on demand to all the stakeholders,
Let's
all
one-
the council appearing for the parties.
One submission. Connected matter. Can it be the next day, Manoj?
Next date.
Next, connected matter, which got delayed.
Ah,
Then-
got it,
instead of-
quick, got it.
Please, 13th minutes. This is on
13th.
12th, that
Ah.
may be on 13th.
13 ಮಾಡ್ಬೋದಾ ರಾಜಗೋಪಾಲ್? ಯಾಕಂದ್ರೆ ನಿಮ್ಮದು ಇನ್ನೊಂದು ಯಾವ್ದೋ ಒಂದು ಹೆವಿ ಮ್ಯಾಟರ್ ಮಾಡ್ತಾ ಇದೀರಿ ಅದಕ್ಕೆ. ಅದು 19, 21st.
That Hyderabad, Karnataka is small. Madam,
All right.
please,
Not whichever date you
Date,
want.
please.
What? Okay.
date.
The train.
96 matter.
ಭಾಳ ಟೈಮ್ ಬೇಕನು? ಕಾಂಪ್ಲೆಕ್ಸಿಟಿ ಇದೆಯಾ?
I seek for 3 days time, my lord, for this issue, my lord. On one point, my lord, I have not taken judgments, my lord. Section 48 of Partnership Act, for 3 days.
48 of Partnership Act.
settlement of accounts. What has happened, one of the contentions taken is that there was an agreement that few of the assets will not form the assets of the partnership firm.
ಇವತ್ತು ಆಗಲ್ಲ, ಯಾಕಂದ್ರೆ ನಮ್ಗೊಂದು ಮೀಟಿಂಗ್ ಇದೆ, ಲೈಬ್ರರಿ ಮೀಟಿಂಗ್ ಎಲ್ಲ ಇಟ್ಕೊಂಡಿದ್ದೀವಿ. ಬೇರೆ ಯಾವ್ದಾರ ಡೇಟ್ ತೊಳಿ.
Anyway, I know, but I got a judgment of Justice Shivashankar, but they have dealt that question. And Supreme Court also.
When the matter is heard, na, bring that judgment. Call this matter in the, ಯಾವ year ಇದು?
96 OSA. But I have not get even a single paisa from them. My father was a one-fourth partner.
ಯಾವತ್ತು ಕಟ್ಟಿದ್ರಿ?
28 years.
23rd November, please. Yes. ಪಡ್ರೆ ಯಾವ ಮ್ಯಾಟ್ರಿಗೆ ಕೂತೀರಿ ನೀವು?
But may I pass on the few facts may not relevant.
ನೋಡಲ್ಲ.
I live.
36, serial number 36.
36.
But I think 23rd Saturday, I think, what of.
Sitting ಇದೆ.
Please, Manad. Much obliged.
Sitting.
Yes, please.
23rd ಇನ್ನೊಂದು ಯಾವ್ದು ಹಾಕೊಂಡಿವ್ರಿ? No, that day, perhaps Dharwad bench is being constituted with my brother.
But I.
26th ಹಾಕಿ. 26th ಬರ್ತ.
Much obliged.
ಪಡ್ರೆ ಒಂದು ಅಡ್ಜರ್ಮೆಂಟ್ ಕೊಡ್ರಿ ಇನ್ನೊಂದು. ಯಾವ ಇಯರ್ದು ಮ್ಯಾಟ್ರ್?
17, my lord.
26th ಹಾಕಿ ಇನ್ನು. Yes. Great. ಅದರಲ್ಲಿ ಕಂಪ್ಯಾಷನೇಟ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ಗೆ ನೋಟ್ಸಿಗೆ ಹಾಕ್ಬೇಕು. ಫೈಲ್ ಕಳಿಸ್ಬಿಡಿ. ಭಯ.
ಪ್ರೀತಿ ಮೇಡಮ್, ಪ್ರೀತಿ ಮೇಡಮ್, ಪ್ರೀತಿ ಮೇಡಮ್. ಅಣ್ಣ ಇದು ಕಾಲ್ ಲಿಸ್ಟ್ ಏನ್ ಮಾಡೋದು?